to 18, because these are those revocation act matters. Your Lordship recollects me day before yesterday, Your Lordship was pleased to pass certain orders directing the matters to appear on 2nd of March and 10th of March. But I was praying, when the matters are called on, not right now, kindly fix the same dates, for these matters.
When it is fixed?
2nd of no, 2nd March and 10th March, 3 p.m. and 3:45 p.m.
10th March.
Yes, my lord.
Okay, thank you.
But my juniors will be here.
Yes, yes.
My lord, may I permit to mention one urgent matter. That petitioner inter-business operation has been stopped.
Huh?
Petitioner inter-business operation has been stopped. Last 6 months they could not provide salary to their staff. The amount withheld by the PWD department.
PWD department withhold the amount.
Yes,
You are the contractor.
yes, my lord. Without my lord's blessing, they can't survive, my lord.
You are paying the salary from the bill received from the authority. You are not having the own account.
All businessmen, their entire capital has been blocked.
Who has blocked? Who has blocked?
PWD department, they invest entire capital.
PWD department has to release whatever the work you have executed.
Yes,
The PWD cannot stop your current account or saving account.
There is no dispute regarding the claim, whatever the work, nothing, my lord. My lord, any day, next month, February, any day, my lord, as your lordship convenient.
My lord, may I be permitted
to mention a matter, my lord?
My lord,
Just a minute. 20 February को रखो.
My lord, may I be permitted to mention, my lord, one matter, my lord. Lordship, can you recollect that the works contract matter? Interim order was passed, the matter was directed to remain in the list. Interim order will expire on 2nd February, my lord. Let it appear as the extension of interim order. The matter is not in the list, my lord, though it was directed to remain in the list.
2nd February.
2nd February.
2nd February इसको रखो. Extension of.
I'm mentioning. I'm grateful.
Extension of interim order 2nd February.
I'm mentioning one matter. Yesterday it was.
One by one, yes.
Why yesterday?
I need to mention item 577.
What is the urgency?
Because the petitioner, little finger will be amputated.
Huh?
Petitioner's finger, little finger will be amputated if proper medical treatment is not given by Midnapur Hospital.
So what you have prayed before this court?
To direct the hospital authority to render adequate.
When the incident was occurred?
I have given, my lord.
When the incident was occurred?
20 days back, my lord. He's going.
And when you filed the writ application?
Last month, December, my lord.
15-14 and you filed the writ petition.
But treatment is going on, my lord.
Yes.
My lord, yesterday item number 2 matter was fixed for extension of interim order. Your lordship extended the interim order, fixed the matter on 30th March and extended up to 31st March. But it was wrongly gone down up to 30th March. So it should be 31st March. My lord, kindly see. Last line. 1 day extension should be there. Your lordship said that. We have heard.
Okay, no problem. 30th March, the matter will be taken up for hearing. No problem.
Yes. It will be at bottom, so it cannot be. We should mention it on 30th so that
it is 30th March. It is extended.
Yes.
Let the matter. If it is not mentioned, I will take the matter. Yes.
May I
Restoration give the.
may I have your lordship's this matter?
You give non-prosecution, restoration. Give. And for listing the matter, all the list be given to my court officer.
May I have your?
Yes, I will come. Yes.
May I have your lordship's leave to mention this matter, my lord? The urgency is this, although the matter has not yet been listed. Your lordship directed to me, lord, the handover the slip. The urgency is this, my lord. Pursuant to a notice inviting tender, pursuant to a notice inviting tender, my lord, work has been handed over to the, my lord, the petitioner. The fact remains, my lord, despite completion of the work, the petitioner is not being allowed to demolish the plant and machinery because they are facing, my lord, the political resistance over there. Work is completed, everything. It is their own difficulty, but, my lord, the work is not being finalized. That's why neither we can, my lord, demolish the plant and machinery, nor we are not getting the, my lord, the my lord, the proceeds. Extremely urgent matter, my lord. Any day convenient to lordship, my lord.
18th February को रखो.
May I have
As
Milord's,
urgent motion. Yes.
may I have Milord's kindly?
Milord, only may I interject? Two Milord, similar matter is there, the similar matter, similar.
Prisoner is in jail for last 21 years. My brother and my sister-in-law, they were in jail. My brother expired, my sister-in-law got the remission from the order of the governor. Number I am in jail for last 21 years. Made the representation to the governor,
What is the conviction? Life. 302. 21 years past.
21 years, but I am in custody.
Years in custody. So what do you want?
Only my representation.
So your case has not been considered by the remission committee. It has not been placed.
Pending.
It is pending. कर लो 20 February को रखो urgent motion.
May I have-
February
May I have
urgent.
your lordship's leave to mention a matter, my lord?
Permitted.
May I be permitted, my lord, to mention the matter, my lord? I'm online. Am I audible?
Hmm. 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 That's why telling all persons are mentioning urgent matter. Urgent matter gone up to the 102. Now you in the urgent matter you are mentioning. Sorry,
Milord, may I have Milord's kind leave to mention, Milord, this is
I can't do the all the thing cannot be do one day. Go pray before the Chief Justice. I will release the matter.
may I have Milord's
It is in the list. You all persons will taking the 45 minutes for mentioning how the court will take the matter. And once the matter is taken up for hearing, you are taking the matter for the hours together for argument. So what can be done? All the matters are urgent. See? Yes.
Milord, mentioning upon notice, Milord, this has
You
been
go make a complaint to Chief Justice. I am not taking your matter. Go.
My lord,
Milord.
item number 100 upon notice I am mentioning.
Yes.
This matter has been released by a coordinate bench for lack of determination. It's an interplay between RDB Act and Sarfazi Act, Milord. I'm only praying for urgent inclusion in the list. But here, Milord, the only difficulty is after conclusion of affidavits, when the final matter was being heard, Milord, it was realized that since it is RDB Act which is involved, that the bench does not have determination and it was released. Milord, I'm only praying if it be included in the list. Milord, this is the last order. And Milord, this is the notice and Milord. The affidavits are complete, Milord.
Who is for the other side?
Milord, Mr. D.K. Kundu and Arjun Basu had appeared.
So it
We have
is to-
served notice, Milord,
So hearing is this is to be fixed for hearing.
for hearing, Milord.
Hearing, I don't know.
Since there is no interim protection,
Hmm.
Milord, the section 14, which is being illegally proceeded with, Milord, under Sarfazi, but it has an interplay with the RDB Act, Milord.
Okay, I am fixing as to be mentioned. Give the notice to the other side with the consent of both the
I'm very
parties and
deeply
inform-
obliged, very deeply.
काम करो इसको मंडे टू बी मेंशन में रखो for fixing date.
Upon
Milord,
notice to the learned
with
counsel
regard
for the
to
response, my lord.
Milord, with regard, একটু বলে নিন।
Please,
With regard to item number 83, not on 16th of this month, my lord, I had mentioned the matter. Your lordship had been pleased to fix this matter on 20th. Now, my lord, unfortunately, when the matter could not be taken up, I bow down to your lordship, but your lordship is overburdened with the matters. Now, the difficulty is, my lord, the passport and the visa has expired on the 20th. When I approached the London trial court, the London trial court refused to grant me NOC on the pretext that I did not appear before the London trial court physically. Though I had prayed before the London trial court to allow me virtually because I am in Kuwait. Now, my lord, unless and until, my lord, I am granted the emergency certificate or the white passport.
but you are having the criminal case.
Yes, my lord,
Correct.
323.
You are not appearing before the trial court.
But I am in Kuwait,
So
my lord.
that is the only way of the
Yes.
trial court to the accused should appear before the court. If
But-
you are reluctant to appear before the court, what the court will
No,
do?
no, I had approached this London trial court.
I
my
will
lord.
not grant. You go and appear before the trial court.
Yes, my lord, I had appeared.
You are appeared.
But on the 9th of this month, the London trial court rejected my prayer on the simple ground that virtual hearing cannot be granted and physical presence has to be mandatory.
Correct.
Now, my lord, unless and until I am allowed to travel to India, my lord, how can I appear, my lord? That is my only.
How you reached India and Kuwait?
At that time, my lord, my passport was valid.
So
till
if the
26.
passport and visa is over, then he will be accused in the Kuwait also.
Yes, my lord, that is
So
my
how the court can regularize that illegality in by
only prayer,
accepting
my lord, to consider my application by the union for grant of emergency certificate of the white passport. That's it. But after I reach, my lord, I am duty bound to comply with all formalities.
If you are the accused person, you are not appearing
But
before the
only-
criminal
but I'm-
court. You went to the Kuwait. Why
But kindly
the India
appreciate-
government
but
takes
kindly
all the
appreciate-
things?
I am mentioning, my lord.
My lord,
Your,
kindly-
your client is not so diligent. If
But
your
a
client is
323
having the
application,
criminal case,
madam.
why you have left to the
an offense of
Kuwait?
323.
My lord,
Plus petty matter, my lord.
5th of January, 5th of January, and your lordship was kind enough to fix it up on 21st of January. But the matter is appearing in 147 item number, and from then onwards, today it is 185. The urgency is there is construction going on in my land, and that is the urgency. Kindly fixes up in the next week, because we already the other side has filed their reply also. It's a very short matter. One day it will be accommodated.
18th February.
my lord, upon notice, I am mentioning.
Our 692 of the today's list.
Yes.
But 692 of the today's list is a hearing matter. But in spite of direction, no affidavit in opposition has been filed. My registration process has already been stopped. Some of the client come in my office and trying to physically assault me. But in spite of repeated request.
What is the registration? Land registration?
No, but
Flat.
marriage registration.
Who are you?
I am the marriage registrar.
Ah.
My online mode has been closed by the authority without any reason. Without hearing.
So your order is up till which date?
Alright.
Your continuation of the order is continue or
No interim order passed. On that ground, the only directed to the file an affidavit in opposition, but in spite of direction, no affidavit in opposition has been filed. But during that period, some of the client came in my office and created several type of if your lordship kindly here any day of the next week any time.
next week? I don't think.
Your lordship, may I?
Before 20 February, it is not possible.
Maybe any day, maybe
23rd February.
My lord,
Your lordship,
my lord, 15 February is the date of publication of the final voter list.
Yes.
My epic card number has been wrongly allotted to another person. Upon notice, I am mentioning before your lordship. Today's matter is item number 100. Lordship kindly fixed any date. And
No, it is in the
list.
it is in the urgent motion list.
Lordship,
That
but
you wait for, that you-
gradually going down.
Okay,
my-
let you
kindly-
wait for.
15 February is the last date for date for publication of the final voter
When?
list. 15 February.
15 Feb, by that time it will be taken up.
Lordship, kindly take it because at least 10 days before. Otherwise, my
You give the another heading where your
no.
matter can be
I am-
fitted
I am
other
bound
than the
by your lordship.
urgent motion.
It was mentioned before your lordship.
Correct, that is in urgent
13
motion. It will be
13
taken.
matter was taken up, but file was not traced out. That is why.
Please wait till 15th is time. By that time it will be taken. Yes.
your lordship, may I be permitted to mention a matter upon notice for extension of interim order, your lordship, it is expiring tomorrow, your lordship.
My lord, may I be,
Be mentioned for extension of interim.
my lord, may I be permitted? My lord, may I be permitted to mention, my lord, the petitioners association herein is claiming, my lord, notional benefit in accordance with the revision of pay and allowance rules 2009, my lord. My lord, association is having, my lord, more than around 2 lakh members. My lord, affidavits are complete. Any day your lordship may take up.
What is the matter?
Matter means, my lord, petitioner association is claiming notional benefit in accordance with ROPA rules 2009. This is the case.
Why before this court?
My lord, your lordship,
Department.
my lord, primary department. My lord, your lordship is having determination. My lord, 2023 matters hearing
But if it is going by that determination, you have to wait.
irrespective
You go
of
to the proper court
be
having the
permitted to mention,
proper
my
determination.
My lord.
May I be permitted to mention?
My lord.
This matter, my lord, relates to, my lord, the recruitment of Central Armed Police Forces, my lord. My lord, the
So
selection.
why you are coming here?
My lord, this
Recruit me and this court is not having
My
determination.
lord, your lordship, my lord.
your lordship that the determination.
What?
Group 6 to.
Group 6 এখানে
This court is not having determination.
Group
My lord,
9 তো।
my lord, your lordship, my lord.
17 years.
Okay, you give all, let all the court be closed. You come before this having written. Come all matter come here. I will sit up till the night, midnight.
My lord's graciousness has
My lord, the petitioner teacher can return benefit even after retirement of 17 years in.
Yes.
He got part payment.
Who?
Petitioner, a primary school teacher.
Both the primary school.
my lord.
This is hearing bench, irrespective of classification. Let it be listed. He is an old age.
April. Irrespective of classification, April.
April এ দেখবে বলছে জজ সাহেব তাই করে নিন
If you are ready, I will fix the matter in April. Ready?
রেডি হিয়ারিং এ রেডি তাহলে এপ্রিলে
You
রাখি
want ready in April?
may I be permitted my lord
2 बजे कौन सा फिक्स है देखो कौन सा डेट में है अप्रैल 2nd 3rd
বেরিয়ে আনা বলে দিচ্ছে বলে দিচ্ছে
2nd अप्रैल 2 बजे खाली है
Judge.
2nd April at 2 p.m. specially fixed matter.
my lord may I be my lord may I be
Your lordship,
Item number 71, which is appearing under the heading urgent motion, lordship, electricity matter day by day it is going down. Yes, sir.
Electricity matter, this court is not having determination. Why you kept here? I am releasing it.
Kaput saheb
Last occasion when the matter came before lordship,
Kaput saheb
keep the file here, lordship, and I appeared before the lordship.
That time the electricity determination was here. Now it is changed.
my lord
You are not gone through
Then kindly release this matter.
which matter? Item number?
71, item 71.
What is the name?
Subroto Tat.
Yes, item
Petitioner
number
name.
71. It is submitted by the council for the petitioner
আইটেম নাম্বারটা কত
in connection with the grant of electricity
বলো না
connection.
কত আইটেম নাম্বার সেম বলো
Grant of
Item
electricity
number to
connection, and thus this court is not having determination. Accordingly, WPA 25146 of 2025
নাম্বারটা লিখে দাও
is released from the list of this court with the liberty to the parties to mention before the appropriate court having determination.
Prayer for item number 42.
42.
Same prayer.
42 Gordon. The Leonard, you are for the state.
WBSCDC.
And then 42 council for the state. WBSCDC has submitted this matter is connected with the grant of electricity connection. Thus, this court is not having the determination. Accordingly, WPA 30288 of 2024 is released from the list of this court with the liberty to the parties to mention before the appropriate court having determination.
My lord,
my lord
to item number 162, same prayer.
162.
162, Bhadu Mondol.
Same. This is also electricity.
Yes, my lord, yes.
Same. 16 WPA 7243 of 2025.
my lord
Yes.
Your lordship directed this matter to appear on 28th of January. It has not, my lord.
What is the
In-
agency?
28th of 28th of January, my lord, yesterday. My lord, the interim order is still today, my lord. The interim order is expiring today, my lord. If your lordship, yes, my lord.
Why it is not listed?
My lord, if your lordship, my lord, kindly take it up at 2, my lord.
Supplementary में डालो.
Lord, may I be
Supplementary 2 बजे रखो. Extension of
Lord,
entry.
may I be allowed to
Grateful, my lord.
be allowed to mention a matter, my lord? My lord will kindly not take me amiss, my lord.
It will be signed. It will be signed.
Yes, yes, that is good.
my lord may I be permitted to
You will get within half an hour.
My lord,
my lord
ऐसे कैसे? चैम्बर में भेज दो एक बार चेक कर लेगा उसको कर देगा.
my lord may I be permitted to mention my lord
The matter is already in the item number 142, and my lord, the matter is the returnable date was 3rd of December, and from there it is been under the adjournment motion. And my lord, if the matter is being listed in the upgradation, then the matter can be heard.
What
And
is the urgency?
the urgency is that, my lord, the matter, the mediation center has closed the mediation. The mediation has failed, and
Non-starter.
yes, and the other part has sent us a letter and requesting that the mediation should be. We are ready to participate in the mediation. So once the matter is been mentioned, my lord, I will.
What you want?
You can pass, my lord, necessary order to go before the mediation again, my lord,
Again,
because they
again
have
sending it to mediation.
because they have given a letter of request, my lord.
Okay. इसको काम करो to be Tuesday to be mentioned में रखो. Tuesday to be mentioned. Inform the other side.
Yes, yes, my lord.
My
My lord,
lord, may I be-
another matter is here, my lord. This is a small correction, a typo error. It is to 26th February 2025. my lord.
Tuesday for correction.
my lord may I be permitted to mention my lord one matter my lord the urgency is my lord I am the
Obliged, my lord.
tenant in a portion of a building which has been sold in auction. My lord, my properties, my lord, plant and machineries are everything inside. My lord, I requested to the secured creditor to allow me to, my lord, take out because those articles were not mortgaged. My lord, that was not done. They have sold the property. Now the oxygen purchaser is coming and taking out my properties. My lord, this is the urgency, my lord. This is the because my lord, Article 300A would
What you prayed for?
I am prayed for that so that I can remove my articles. Those have not been.
Against whom you asked the direction?
Yes, my lord.
Against whom you asked the direction?
Secured creditor.
Huh?
Secured creditor. Secured creditor. Because secured creditor had sold the property, which has not been mortgaged. My articles had not been mortgaged. Only the immovable property was mortgaged. I have no difficulty. They take possession. But I can.
When you file the writ petition?
My lord, the writ petition, my lord, difficulty is, my lord, it has been dismissed once, my lord, for default, my lord. Because at that time, my lord, talks of
So it is
settlement.
already dismissed.
No, default.
Okay.
At that time, my lord, talks of settlement with the secured creditor.
Whether now what is the
It is not listed, my lord. It is, my lord.
What is the position of the writ petition? It is dismissed or default?
Default. Restoration has been filed. Immediately restoration has been filed.
That is pending.
That is pending, my lord. Along with the writ petition, my lord, it can be heard, my lord.
Oh.
My lord, any date, my lord, tomorrow or Monday, my lord.
5 तारीख को. 5th.
My lord,
Your
lordship,
my lord, kindly.
my lords, may I please,
Your lordship may be.
Number 289 of this.
289.
289, Lordship. Urgency is that, Lordship, petitioner preferred the RTI application. Thereafter, petitioner preferred the RTI application, Lordship. Subsequently, he didn't get the information. That leading to instant writ petition, Lordship. Thereafter, he got the information, and it consisting about, Lordship, around 700 pages, Lordship. Earlier, the matter was taken up by Honorable Justice Amrita Sinha. Her ladyship was directed that to prepare a small affidavit that discuss about that this information that related to this writ petition, Lordship. Till now, no affidavit has been filed, Lordship. This is the urgency, Lordship. Earlier, I mentioned the matter, Your Lordship.
What is the urgency?
This
In
is
the RTA application?
Small affidavit they had to prepare that this affidavit leading to
Whether
this
they have filed the affidavit?
No, Lordship. No
So
affidavit
what do you
has been
want?
filed. Lordship, kindly fix a date. Small matter, Lordship. Kindly fix a date, Lordship. Earlier, I mentioned a matter, Lordship. Your Lordship directed the matter will appear on 27, but nothing, Lordship. It's only under the heading motion, Lordship.
19th
not
February.
Yes.
my lord,
Lordship, may I permit it to, Your Lordship, may I permit?
my lords, may I please mention,
Urgent, my lord, since, my lord, the operation of the bank account of a school has been suspended by the concerned
Why?
bank. My lord, that is the dispute of the signatories, which we have tried to resolve, but the bank, my lord, is nearly 1 year. It has been suspended, my lord. Kindly hear out, my lord, 295. It is, my lord, the small functioning of the school is being hampered, my lord. That's
20 February. Your Lordship, may
My
I
lords,
permit to
kindly-
mention?
20 February.
Your Lordship, may I permit to mention today's, it is the item number 585. This is very urgent matter relating to SIR, ongoing SIR process. My name has been deleted from the draft rule without any cause, without any notice. Even
You appear before the authority.
your lordship, this is the case when there is no notice was served on me, and I have been citizen of India and voting since last 2022. My mapping is already correct.
In the last voter list, your name
Yes,
is there.
yes. My name, my family name,
So you filed your objection before the authority.
how there is no process. There is no process to filing objection, Your Honor. No notice was served to me.
What is the last date?
For final rule going to publish on 14th February. Very urgent matter, Your Lordship.
Urgent motion.
The
Lord, may I be
petitioner-
permitted to mention one matter?
Your Lordship, kindly fix a date. The petitioner is already.
You're not heard.
may I have, my
May I
lord,
be permitted to mention one matter, my lord? My lord, this matter, my lord, the urgency is, my lord, there is a huge tree just in front of my house, my lord. Now, my lord, the deep root of that tree, my lord, that has been cracked here and there over the, my lord, house. Now, my lord, this matter was filed on 8th of April 2025.
Where?
The department before the residue under Group 9, my lord. My lord, there is a direction by the forest officer to cut down the tree, my lord. But the local panchayat member came in between, my lord. 15 days time has been given, that has been expired, my lord. Now, my lord, I have made an
Have you filed an
application.
application under 133 before the subdivision magistrate?
No, my lord, as the time limitation has been expired, I have made another representation, my lord, before the concerned authority.
Concerned authority? Who is the authority? It is a subdivision magistrate under section 1. Now, what is the BNS 133 substitute? What is the action?
No,
It
my
is a
lord-
subdivision magistrate.
my lord,
He will
there is
call
a
for
ru-
the report. If you are having the forest report, then he will pass an order.
My lord, there is a specific rules in this regard, non-forest area rules 2007, my lord. Under this provision, my lord, they have the power, my lord. The officer in this division, Badaipur division,
forest officer. The order has been passed, my lord, in my favor. But my lord, the local panchayat member, my lord, creating that disturbance. As the 15 days time has been, my lord, over, for that reason, my lord may kind any date, my lord, as per your lordship's
24th
convenience.
February.
24th February.
Urgent motion.
My lord.
Great, my
My
lord.
lord, may I please mention item?
Caution, my lord, I'm mentioning this matter, though this matter is appearing as item number 67 of this today's list, hearing list. What had happened, my lord, this is a matter relating to supply of cooked diet, tender matter, supply of cooked diet of 2023. I am one of the participants, my lord. The finalization of the tender process is still pending because of the pendency of the writ application before your lordship. My lord, I am the private respondent. I have invested a huge amount of money that has been,
Is there any interim order?
there was an interim order, but
In the writ petition, interim order is there.
interim order, all affidavits have been completed, my lord. Any day, half an hour it will take, my lord. Any day, my lord.
Who is for the other side?
Mr. Kishore Doctor was appearing, my lord. I shall inform, my lord. So I have given notice to the petitioner upon notice.
No, who is for the petitioner?
Mr. Shujjo Maiti. I have given notice, my lord. Upon notice, I am mentioning. My lord, there is extreme urgency. I would not have troubled your lordship considering the items in the list, my lord. It will not take more than half an hour, my lord. It's a tender matter. My lord, there was a direction by the division bench, my lord, to
24th,
My lord.
24th February.
My lord.
February.
My lord, may I be permitted
February,
to-
urgent motion may go.
My lord, may I be permitted?
Have you license? You are having the license to run the sawmill. So who are you? You are the partner. Then yeah, so what the court will do?
Yeah, motion. Motion.
Huh?
Inclusion কি দিয়ে দেবো?
Only for taking the log by the villagers. Why the villagers have kept the log? How the villagers got the log without the license issued by the? So who will identify? Who will identify that? You will. Have you given any receipt who has brought the log? 25th February.
My lord, may I have my lord's kindly, my lord, in terms of Rule 26 of Writ Rules, my lord, may I have kindly permit me to move this matter in urgent?
What is the urgency?
My lord, urgency is my lord, the district registrar office has not considered my representation, whereas the executor of the deed, my lord, he has himself affirmed before the learned judicial magistrate, stating that he has forced the signature of the original landowner, my lord. My lord, what has happened? He being the landlord, my lord.
Who are you?
I am the developer promoter, in favor of whom, my lord, there is a development agreement as well as subsisting power of attorney, my lord. My lord, even after subsisting, even when the subsisting of during the subsistence of the agreements, my lord, the landowner, he has forged the signature of the original landowner of the property. He has
Who forged the signature of the landowner?
My lord, the present landowner has forged the signature of the erstwhile landowner. My lord, subsequently he has admitted the same before the learned judicial magistrate by executing affidavit, my lord. He has specifically claimed that there is yes, I have done that mistake.
So what you prayed in this writ application?
I have prayed before the authority to kindly not to permit anyone to execute any deed in respect of that property. Otherwise, the person who would be entering into the transaction, my lord, would be defrauded, my lord.
You go to the civil court, challenge the deed which has been executed, now declaring the decree as null and void.
That's true, my lord. That's true. But the other third person are entering into the property.
So take an interim order.
The registering authority does not stop the registration.
Sorry.
There, the private respondents were are violating the order of the coordinate bench of this honorable coordinate bench of honorable court by running the production of the sweet business without any authority from the Pollution Control Board as well as from any, without any trade license at all. The petitioners are the senior citizens and they are traveling as the private respondents are violating the order of this honorable court, which is the content of the court. Kindly fix any date for the hearing which is running under 443 of item number 443.
Affidavit filed.
Lordship, everything is compliant. Sir, this is all.
26 February, urgent motion.
Lordship.
RTI Act, but here the informant without the process of tendering, they are doing the huge work under the law of above.
Sir, what you have prayed for? I have no time to hear all this history. What you have prayed? What is the urgency?
Urgency is this matter, this program will removed by 9th February. Before that, this matter is required to be heard.
What you have prayed for?
For the RTI information by which
Yes.
Under compulsion, Lordship, this matter was filed as per the leave given by your Lordship. Lordship, if the matter is not taken up, Lordship, today is the date of eviction under section 23 of the Senior Citizen Act. So, Lordship, the
It is not in the list. It is not in the list.
Act number 33. But Lordship,
33. Let you wait. Well, let us see how
the date
My
of
lord.
eviction.
today. Okay, let us see.
My lord, may I be permit to
Matter was allowed for inclusion of the earlier person, and the file has been sent, but still your appraisal document has not added to the call. The file has been sent from the Mandama section. Kindly allow.
My lord,
my lord, may I be permit to mention
Include kar do list mein.
my lord,
The lordship background today, but it was not actually the urgent motion for the petition was as a selected as a journalist category candidate, but now his name is included in the OBC list. The urgent
You are having a certificate of OBC or EWS?
now PWS issuance of PWS. I don't think OBC certificate. But
So what certificate you are having? Earlier, what certificate you are having? EWS certificate. Now it has been changed category B, OBC category B. So,
advocate taken place in this week only, lordship. That is the urgent lordship, right? The matter was supposed to appear today, lordship, but it's not appearing in the.
उसको ना 4 तारीख को urgent motion within 5 matters करो.
my lord, may I,
lord, may I be permit to mention a matter for upgradation?
4th of February
my lord,
under the urgent motion.
my lord,
Mention one restoration application, my lord.
Give the restoration.
my lord.
Application of the passport, renewal of the passport, the passport also is not renewing my passport, 2011, my lord, is registered anything on FIR.
So you go before the trial court, file an application, take no objection, file before the authority, you will get the passport.
That I am claiming that issue is that I am the not citizens of India. Is that issue.
So you are not the citizen of India. How the Indian passport will be? If you are not a citizen of India, how the Indian passport will be granted to you?
Earlier occasion in 2013, my passport was renewed. Although the case was registered of 2011.
Case is registered under which section?
420, 420 and 34.
420. What is the allegation? You have forged the document showing the Indian citizen. That may be. That's why.
2013, my passport was renewed.
Maybe.
My passport was
Yes.
My lord, mention that item number 541 here, the petition enlisted contractor under the military services, my lord, he was facing an order of suspension for 6 months. It was going to expire in the month of November. And now in the month of November, they have communicated me, they have removed me from the enlistment. So that is the advocate I have filed it in the month of December.
19th February.
my lord, may I be,
My lord, may I be permit to mention a matter for upgradation, my lord? My lord, the urgency is without any hearing or without any notice, my lord. The insurance claim has been rejected, my lord.
Insurance claim has been
Rejected.
So you file the writ challenging the insurance that rejection order.
Yes,
So
my
what
lord.
is the urgency? Yes.
My lord,
Who are you?
And I was admitted once, and when I came to, I filed this representation and gradually this.
Without license, the
Howrah SC market is to that.
26 February.
my lord, praying, my lord.
Item number 9.
In a foreigners act.
Bangladesh national that we have provided the address, state as well as ASN. They're supposed to verify, they're supposed to file the report, man. And if your lordship only observation is that if the petitioner is condemned, where the petitioner will decide what. That we have provided. Item number 96.
Okay, wait, 96. 96 the urgent motion, it is there. Let me see how far the court will go, the urgent motion, then it will be.
My lord, I'm praying for urgent filing and hearing. The urgency is, my lord, the urgency tender was floated by the irrigation. Tender was floated by the irrigation and waterworks department, my lord.
I
Now
don't
the
understand.
tender was floated by the irrigation and waterways department, my lord. The petitioner submitted bid, my lord. The bid has been disqualified. The bid has been, my lord, rejected on the basis that petitioner do not have the requisite credentials, despite the petitioner having the requisite credentials, and those who have been, my lord, qualified, my lord, they do not have the requisite credentials, my lord. Several representations followed, my lord.
Tender order is issued.
My lord, work order is about to be issued, my lord. That is the urgency, my lord. Several representations have been followed, but the department is kept ignoring the representations, my lord. Kindly, my lord, grant the leave, my lord.
When the tender will be issued? What is the last date of the tender?
My lord, in December, my lord. Thereafter, several representations followed in January.
What was the last date of the tender?
My lord, end of December. Exact date I do not know, but end of the December, my lord. Somewhere.
Can I have a bit copy? Why you are not going to the record?
My lord. No. Note.
What is the last date of submission of this tender? And what was the date of the opening of the technical bid?
Technical bid was, my lord.
And when your tender was rejected?
In December, my lord.
Then?
My lord, kindly, my lord.
Now they have issued the work order.
My lord, there is no instruction as to, my lord, the work order, whether the work order has been issued or not, my lord. That is the urgency. In case the work order is not issued,
Why you not for December now? January is going to be end.
My lord, several representations followed in the meantime, my lord. Kindly.
You're not.
My lord, I have been following up with the authorities, my lord.
You file it and mention. Yes. Okay. Call.
My lord, may I be permitted to mention one matter?
May I have your lordship's leave to mention a matter, my lord?
Why it is kept there?
Lord, may I have permitted to mentioning a matter for substitutional application, my lord?
Give.
Item number 579 of the monthly list, my lord. I have filed an RTI application, not considered. I have filed
79. It is urgent motion. It is there. Yes.
Sir, I mentioned day before yesterday, my lord, the hearing matter. My lord was pleased to fix it on 26th March. Subject to correction, my lord. I think 26 March is a holiday, my lord. I have specially fixed matter. It was fixed.
26 March में देखो. ए दादा. 26 March में देखो क्या date fix किया? No, that has been changed to 27, I think so. Subsequently, my officers will inform me.
My lord, there is another matter, similar matter. Pleadings have been completed. My lord, may I just...
27.
Lord, there is another matter, my lord. May I give the slip?
Yes.
May I have your lordship's leave to mention an urgent matter, my lord? The urgency is that, my lord, I'm suffering an award passed by the arbitrator of MSME Authority, Facilitation Council, my lord. I was not served with any notice whatsoever. Only at the time of execution, when I have come to know about the execution proceedings, I was compelled to appear on 13th of January. The next date was fixed on 16th to file affidavit of assets, despite the fact that no copies of the application awards were served at any point of time. Pursuant to the court's direction, the executing court's direction, my lord, the copies have been served, but incomplete copies of the orders as well as the applications.
Where is the execution proceeding?
The next date has been fixed on 2nd of February.
Where?
Before the executing court, Rajarhat, commercial court, Rajarhat, my lord.
You file an application under 47.
We have already filed an
File
application.
an application under section 47. Yes.
My lord, we have filed an application which has not been considered by the authority, my lord.
How the writ court will go into? You go to the
My lord,
civil court,
I am covered by a
proceeding.
judgment of Supreme
If it
Court.
cannot be executed, file an application before the court. Yes.
My lord, may I please mention
in that
on the list?
My lord, may I please mention item number 30 and 31, my lord, into my lords, may I please mention my lords, item 30 and 31 in today's list, my lord.
The order date at 2nd September 2004, 15 July 2014 and 11th April 2017 are set aside and quashed. The co-education school is allowed to continue with the co-education. Next.
I beg to appear for the respondent bank.
This matter is appearing at our instance, my lord. For extension of interim order, it's till the end of January.
My lord, already the affidavit has been exchanged.
Affidavit completed?
Yes, my lord.
Yes.
My lord, can you fix a date?
As far as the respondent number 4 are concerned, Punjab National Bank, we don't require to file an affidavit. But there is no allegation against the bank. But we are holding a bank guarantee.
It is submitted. The matter is listed as to be mentioned on the prayer of the petitioner for extension of interim order. When the last interim order was extended?
On the 26th of November, could I hand up, my lord? 26th of November, 2011.
End of November 2025 or January 2020.
Yes.
Yeah, बोलना. Interim order. Counsel for the respondent. Respondent number?
Respondent number 123.
123 submit that. Readings have been completed. The matter can be taken up for hearing. Counsel for the respondent bank submit that there is no allegation against the bank and the bank will not use any affidavit. At the land counsel for the parties, it is submitted. It is found that the pleadings have been completed. The matter is ready for hearing. Let the matter appear. Appear under the heading hearing. Interim order is extended till 27th of February 2026 or until further order, whichever is earlier. Let the matter appear on 27 under the heading hearing. Next.
There's item 3, I beg to refer to the petitioner.
I appear for the respondent number.
There's an order of stay that I'm enjoying, my lords. There's a declaration of fraud at the behest of Bank of Baroda. But my account has been declared as a fraud. I'm enjoying a stay from 24th of September. It was last extended on 27th of December. The interim order is due to expire at the end of January. Affidavits are otherwise complete. Well, will kindly give one extension. We are ready to finish the hearing of the matter.
Lordship, I appear for the Bank of Baroda in this matter. Lord, I have taken out an application of vacating of the interim order. The reason being, my lord, the section 95, section 95 of the IBC has been filed before the tribunal, which has been suppressed in this writ petition. And my lord, their IRP has been appointed. That's also been suppressed. Because for that reason, my lord, the writ petition cannot proceed.
If I may, my lords.
If your lordship takes this application in that is appearing in the list, I will serve it today, my lord.
It's not been
application not listed.
It is not listed, my lord. IA number, GA number is there in the list. GA number 1. IA number 1.
Can number 1.
Let it be taken up tomorrow, I will serve it.
No. Malaj, if I may, if I just may make a submission. Today, a moratorium would apply against other civil proceedings that are pending against me in terms of section 96 of the IBC. The writ jurisdiction is not barred by virtue of the moratorium, and your lordship knows that a classification of fraud renders a criminal consequence where even the CBI's jurisdiction can be invoked. There is no moratorium on that under the IBC. Now, what they have done, Malaj, Bank of Baroda goes and files a police
Bank
in
of
action.
Baroda has not
Let me
filed.
finish kindly.
Bank of Baroda has not filed. It is some other bank.
Police in action writ petition is filed asking the CBI to proceed against me even despite the presence of the moratorium. It is only when we showed your lordship's order of stay that they were, Malaj, holding their hands on the matter.
It was some other bank. We came to know that has been filed before the NCLT.
It was Bank of Baroda.
No, Bank of Baroda has not filed. I have annexed a copy of the orders in this application.
What is the ground for challenging the fraud?
But it's the forensic audit report that they rely upon in the show cause notice. Malaj, that they rely upon one particular forensic audit report. Once the proceedings commence, they are telling me there's a second forensic audit report. Prima facie kindly see the 24th
So-called
September.
notice issued with the first forensic report or second forensic report?
It is issued on the basis of the first, but they're relying on the second for my declaration as a fraud.
So-
And that has never been served upon me.
So they, what
I
they have done
actually
is,
got a copy from that man from Union Bank, a different bank altogether.
so what they,
Forensic report.
The forensic, in fact, I don't even know whether that forensic report is valid or not. Today, Bank of Baroda hasn't given me any forensic audit report.
If it's the case that this you have relied upon the
what is done, my lord, an IRP has been appointed.
Huh?
An RP has been appointed.
Different thing.
Because it was done by the RP, not by the Bank of Baroda.
No. Once you have relied upon the second forensic audit report,
Lordship.
which is not served to the petitioner and relied and has declared the account of the petitioner as a fraud,
Lordship.
then as per the judgment of this court, my judgment, coordinate bench judgment, and the judgment of the Supreme Court, he is entitled to get.
Lordship will kindly hear the matter any day.
But
I am ready to
fixes it, my lord.
Lordship.
Kindly fixes it. I have no difficulty.
I mean, along with my application.
The matter is listed as to be mentioned on the prayer made by the counsel for the petition for extension of interim order. Counsel for the respondent bank submitted. The bank has also already filed an application being Can 1 of 2026, praying for vacating the interim order. Full stop. It is further submitted that the proceedings have been completed and matter is ready for hearing. In view of the above, let the matter appear on 18th of February 2026 under the heading adjourn motion within 6 matters. Within 6 matter, fully interim order is extended till 20th February 2026 or until.
Well, let them serve a copy of
I
this
shall, I
can
shall.
that they have filed. My lord,
I
kindly
shall.
directs them to serve a
I
copy of
shall,
the
I
can.
shall. I shall do it today.
I will take all the matters.
Lordship, I'm great.
May I just make one submission? I am for the respondent number 5, which is the erstwhile accountant that was called upon for the service of the forensic report. Sir, I have never been called upon to make an affidavit. Since Milord has recorded that affidavits are complete, there are no prayers against me, and I have never been called upon to make an affidavit. Just if a copy of the IAS out upon me, that's about it. I have received the writ petition.
Yes.
Next, I believe the can, my lord. He's asking for the can.
Just for the can.
Yes. I'm grateful.
Call.
Item number 4, Milord, I appeal for the petitioner, but we had mentioned the matter on the 27th, and the interim order is till 28th.
Till today.
Till yesterday.
Till yesterday. You are not paid for.
But we had prayed for.
Ready?
Not ready.
Not affirm. How soon you will affirm? How soon you will affirm? 4 weeks. It is ready and affirmation 4 weeks. The matter is listed as to be mentioned for extension of interim order. Counsel for the respondent submit prays for 4 weeks time to file affidavit in opposition. Let affidavit in opposition be filed by 24th of February 2026 after serving the copy to the London Counsel for the petitioner. Petitioner liberty to file affidavit in reply by 10th of March 2020.
Kindly give us some more time. It's a West Bengal Power Development Corporation. So
By 18th of March 2026. Full stop. List the matter on 20th March 2026 under the heading adjourn motion, urgent motion within 10 matters. The interim order is extended till 24th of March 2026 or until further order, whichever is earlier. Next.
My lord, these matters have been mentioned in the morning. My lord, in the original side, the other matters, Lordship has been pleased to fix, my lord, on 2nd of March at 3 p.m. and 10th of March at 3:45 p.m. My lord, this is the order. And my lord,
And my lord, 5 and 17, my lord, we filed affidavit. My lord, kindly, my lord,
We will,
5
my
and
lord,
17, my
5
lord.
and 17.
Yes, we will use, my lord,
5 and 17.
My lord. Others, my lord, we have filed within, my lord.
I am in
reply.
No, I just received it, my lord, yesterday. My lord, I'll file and reply in the meantime, my lord, before it is taken up next.
The counsel for the
I am in item number 6, my lord.
5 not.
No, not in 5. I am only in 6.
I'm in 11, my lord.
6 is 1, 3. Respond number 4 and respond number 3 and 4 have filed affidavit in opposition in connection with WPA number 13021 of 2025 after serving the copy to the learned counsel for the petitioner. Learned counsel for the respondent number 4 in WPA number
13176.
1317. That is not here.
Item 17, my lord.
13176 of 2025 after serving the copy to the land counsel for the petitioner. Counsel for the petitioner press for submit that press for time to file affidavit in reply. Let affidavit in reply be filed within 3 weeks after serving the copy to the land counsel for the respondent.
My lord, one more indulgence, my lord. Insofar as the other, my lord, writ petitions are concerned, let the authority also use their opposition, my lord, to that.
We filed, my lord, within 2 weeks. my lord.
Let all the matters be appear on 2nd March 2026 at 3 p.m. and 10th March 2023 at 3:45 p.m. In the meantime, the respondents of the other matters are directed to file affidavit in opposition within 3 weeks. Reply, if any, they are to be filed within 2 weeks.
Obliged, my lord.
Ready, Guru? Next.
My lord, only correction of the paragraph number 3 and paragraph number 8.
What is the correction?
Correction, it would be 3 crore 39 lakh 23,103.
3 crore?
3 crore 39.
Where from you got the 3 crore 39?
My lord, kindly come to page 8.
Page 8 of?
Eight of the report. Total bill amount 3 crore 39 charge.
Yes, record a note. And 3 crore 39 and?
39 lakh 23,103.
Paragraph 3 and paragraph 8.
8 and 3.
8 and 3. The matter is listed as to be mentioned for correction in the order dated 22nd of January 2026. Counsel for the petition submit that in the order dated 22nd January 2026 at paragraph 3 and paragraph 8, the amount is to be read as 3, 29,
3 crore 39.
3 crore 39, where is that? Where is 3 crore 39? No, in writ petition.
Petition page
3 crore 39, 23, 103 instead of 3 crore 22, 23, 271. Consider the submission made by the counsel for the petitioner. Peruse the record. In the order dated 22nd January 2026 at paragraph 3 and paragraph 8, the amount shall be read as 3 crore 39, 39, 23, 103 instead of 3 crore 22, 23, 271. This order which read with order dated 22nd January 2025. Next.
Lordship, this is for correction. Paragraph 2.
Paragraph?
Paragraph 2.
Ah.
Fifth line, instead of engineer, it will be officer.
Huh?
Instead of executive engineer, it will be officer. Instead of engineer. Fifth line, second paragraph.
Executive engineer?
Executive officer. Instead of the word engineer, it will be officer.
I could not understand.
Instead of the word engineer, it will be officer. It is written engineer. The word will be
Executive officer, okay. That only.
And your Lordship, the 8th line, instead of the date 20, it will be 28.
Huh?
Instead of the date 20, 2021, it will be 28. And then
28 September.
28, yes, your Lordship.
These are the two.
28.
These are the two.
No, your Lordship, next page, paragraph 4. The 5th line, respondent number 8 instead of 5.
That's all.
And your Lordship, 5th paragraph, again, executive officer.
28.
Officer and 28, yes. Yes, your Lordship.
Learned counsel for the petition, the matter is listed as to be mentioned for correction in the order dated 22nd January 2026. It is submitted that in paragraph 2, 5th line, 4th and 5th line, instead of executive engineer, the word shall be read as executive officer. And 8th line, The date is to be read as 28th September 2021 instead of 20 September 2021. And in paragraph 4, line number 2, it shall be read as respondent number 8 instead of respondent number 5. And in paragraph 5, the word executive engineer is to be read as executive officer. Consider the submission made by the counsel for the petition, peruse the records. In paragraph 2, the executive engineer shall be read as executive officer. Date shall be read as 28 September 2021 instead of 20 September 2021, comma paragraph 4, it should be read as respondent number 8 instead of respondent number 5, and paragraph 5, the word executive engineer shall be read as executive officer. This order shall be read along with the order dated 22nd January 2026. Next.
21, my lord. I am appearing for the petition, my lord. I am led by Mr. Somu Majumdar. My lord, he is on legs. I was praying for a short passover, my lord.
Why it is mentioned extension of interim order?
Extension of interim order. The interim order, my lord, we have filed an application, my lord. That application, the interim order is expiring till tomorrow, my lord.
Till?
Tomorrow. It is interim order passed by your lordship earlier is till tomorrow, my lord.
Well, direction for affidavit in opposition may be given, your lordship. We have not exchanged pleading.
Where is the interim order?
The interim order, my lord, was passed on 9th of 9th of January, my lord. Lord, may I hand over a copy of your lordship? But subsequent to passing of the interim order, my lord.
Yes, what is that?
My lord, affidavit in opposition may be directed to be
Not
given.
filed.
Yes, your lordship. No pleadings have been exchanged.
The matters listed to be mentioned for extension of the interim order. Counsel for the respondents press for time to file affidavit in opposition. Affidavit in opposition filed by
4 weeks.
By 4 weeks. Reply, if any, there to be filed within 2 weeks.
2 weeks, my lord.
2 weeks. List the matter on 19th of March 2026. Interim order is extended till 23rd of March 2026 or until further order, whichever is earlier.
Deeply obliged.
Next.
Your lordship, item number 22 and 23, I am for the writ petitioners. Item number 22 and 23, I am for
File
the...
is not here. Please
Yes,
wait.
my lord, I have instructions to withdraw the writ petition.
Withdraw the writ petition.
Yes, my lord, item writ petition number 25708, I believe. 22.
Item number?
Writ petition number 25708, I believe was already withdrawn.
25706.
08. Was already withdrawn and item.
You are appearing in which matter?
In 22 and 23, item number.
22-259-695.
Yes.
The file is not here.
Yes.
Please wait. When the file will come, then we'll see to that. 22 and 23 file is not here.
My lord, I have instructions to withdraw the...
Sir, unless the file
Very
is
well,
not
very
there, what order is there, we don't know. Might be it has been withdrawn earlier. Correct. Let it, if the file comes, it will be listed.
Very good.
Next.
24 is that matter, my lord. Where, my lord, the court fees is supposed to be returned, my lord. The last occasion, your lordship was pleased to, my lord, direct the finance secretary to appear personally. Thereafter, the learned advocate general came and assured your lordship.
My lord, Mr. Dotto is appearing. My lord, kindly gives a short passover, my lord. He's on his legs, my lord. Mr. Dotto.
Sombuddha Datto.
Yes, my lord. Samudra Dotto.
Whereas
Kindly gives
the
a passover,
learned
my lord.
advocate general had come, yes, on the last occasion.
Yes, on the submission of the AG
Yes, my lord.
court.
The last
Kindly gives a
occasion.
short passover, my lord.
No short passover. Let the your bank officer, the finance secretary appear in person here at 2 p.m.
My lord, kindly hear a
On that
short
day, pass
passover,
an
my lord.
order. Subsequently, your AG has come and stated that I will look into the matter, not to pass any harsh order. Then, on the basis of the submission of the AG, I have not signed the order. Not today, when the matter is called, again all are absent. When the stringent order is passed, then all the AG, ISGI, and all will be rushed to this court.
I bow down, my lord. My lord, kindly a short passover, my lord. I am calling him.
I will take at 12.
My lord. Great, my lord.
ফাইল তো ছিল না, ফাইল মনে হয় এসে গেছে। আগে একদিনও হয়েছে রেজিস্ট্রেশনের ওদিকে।
I have seen that though it was outside of the court.
The learned AG,
I have fixed at 12.
he has requested for 2 days time to keep it at. I have been spoken to him yesterday in his chamber. But he said he has a parted matter perhaps is going on before the court 16. Today it will continue. So that is why I am making this prayer for 2 days time. And apart from that, my learned senior friend has given a supplementary affidavit yesterday. But we have sent for instructions on that.
Whatever it is, see, unfortunate appear on behalf of the estate, sir. If I will pass an harsh order, then it will be very difficult to the total estate.
I bow down, my lord. I
Supplementary
humbly, my lord,
annexing the
beseech your lord.
subsequent
Then you will
payment that
say
I have
the
made.
court is totally against the estate.
My lord, I humbly beseech your lordship, my lord. I am, my lord,
I fail to understand.
with my lord, with the my lord AG's my lord request, my lord, I am pressing my lord, before your lordship humbly, my lord, to my lord keeps it after 2 days, my lord, we'll also take because the supplement.
Otherwise, I will call the chief secretary here.
Nothing will be
If your finance secretary is not in your control, then I will call the chief secretary. If you are not having the control over the finance secretary, then I will take care of the chief secretary here. For 50,000 rupees for transfer, it takes the yes together.
I bow down, my lord. I have nothing, my lord, to.
What the laborers will do?
I appreciate, my lord. I cannot.
We have the access to come. What would the other
That's why I'm
persons
telling
come?
what the laborers will do.
My lord, I would, my lord.
If this type of the attitude of the state.
My lord, it's a question of another, my lord, learned advocate, my lord, a junior member, my lord. I appreciate.
Say for instance.
Not, I am not telling that he is an advocate.
Citizen.
Yes, my lord. I cannot, my lord.
Citizen has paid the amount. Subsequently, you want to withdraw. Bank has transferred that amount. Now he is telling that it is there and there and there.
Well, this has
You're
to,
not coming a concrete area where the amount is pending.
Two, my lord, I think.
My lord, instead of my lord, because my lord, on the request of the learned.
Difficult to this court to call any of the officer.
Lord, I bow down. My lord, I always bow down. My lord, I cannot, my lord, dispute, my lord, that. My lord, any event, my lord, I am only with my lord, I beseech your lordship.
Record an order. In spite of the assurance given by the learned advocate general, when the matter is fixed, taken up today, again the state has taken time. Full stop. For the interest of justice, the case is adjourned. Let the matter appear on 3rd of February 2026 at the top under the heading urgent motion. It is made clear that on the date fixed, if the said amount is not been returned in the account of the petitioner, appropriate order will be passed.
But let it come under to be mentioned because first to be mentioned, thereafter urgent motion comes.
It will take, no problem.
Well, under the guidance of the AG, my lord, I'll try my level best, my lord. Grateful to you.
The supplementary affidavit may be kept on record.
Supplementary affidavit kept. Next one.
Grateful. Senior the name there.
25. कौन सा क्या का कौन सा अभी का 26 में 26 1605 24 25 नाम गलत है हाँ 24 16025 24 हाँ अच्छा 24 who has mentioned this हटा दो छोड़ दो yes next
please my lord. Well, this is for hearing of the CRAN. The main matter has already been fixed by your lordship.
My lord, Mr. Orijit Chakraborty is appearing
just,
for enforcement.
my lord,
my lord, he is
permission
addressing
go abroad, my lord.
for the Honorable Justice Rajoshi Bharadwaj. My lord, kindly take up the matter at 12 o'clock.
My lord, earlier he has given consent. Kindly see your lordship's order, my lord, page 34.
Page
34, my lord, annexure D.
And I appear for the Union of India.
Yes.
This was my lord, another petitioner at page, my lord, 34.
So what you, who has filed this scan? You?
My lord, I have filed this scan, my lord.
For?
My lord, my travel itinerary, your lordship will have, my lord, at page,
Another applicant?
another applicant, my lord, who was earlier granted permission, my lord, which your lordship will have at page 25. And the present travel itinerary, my lord, is for business purpose.
Where is
Page
that?
49, the last page of your lordship's brief, my lord.
London.
It's London, and then, my lord, from
Alright.
there, Germany, and to come back, my lord.
Within 12 days.
12
Yes.
days.
What is the, what you are submitting?
I am not briefed in this matter. Mr. Chakraborty asked me to pay for accommodation till 12 o'clock, my
12 o'clock.
my lord.
No, my lord, Mr.
My lord, there is
Chakraborty
no harm
requested for
request.
early hearing of the matter, which is why your lordship has fixed the main matter, which is, my lord, at page 35, your lordship will see. One of the main matters, my lord, rather page 36, paragraph 9.
9th March at 2 p.m.
I'm obliged. So he's coming back before that, my lord.
But
But in any, I appear for the Union of India. In any event, my lord, it is the main party. My lord, let my learned come, my lord. Your lordship take up at 12.
when you will come?
My lord, at 12 o'clock.
12 noon. 12 noon
Fine.
matter is there. दादा 12 noon matter अच्छे की 12 noon आज है आज का लिस्ट में है 12 noon स्पेशली फिक्स में 12 बजे ओके कम एट 12 past
12, my lord. Most of it.
12 noon huh? Yes, next. Item number 32.
My lord, I appear for the petitioner. My lord, Mr. Mukherjee was supposed to give his
29 की बोलो Lordship, I appear for the respondent bank. I'm led by Mr. Mukherjee.
तो फाइल नहीं तो हमें की बोलो फाइल नहीं बन
Yes.
फाइल तो उड़ीसा हाई कोर्ट फाइल है এখানে তো ফাইল
In this writ petition,
you mention
may I take your lordship to the writ petition? What are the prayers? Firstly, my lord, they have challenged one email, and also a notice dated 8 July 2024. If your lordship takes page 183 once, page 183, page volume 2.
Page 183.
Lordship, page volume 2, it is at page 183. I'm sorry, my lord, it is volume 4. Volume 183 to
You are appearing for bank.
I am for the bank, South Indian Bank.
Yes.
Lordship kindly gives you a moment, my lord. Lord, what does that page 183 says? Lord, this mail is dated 5th of July 2024. Has your lordship got it? Page 183.
180?
183, annexure P16.
Yes. 5th July.
Lordship, this mail is dated 5th July. This is to inform you that your account has turned to NPA on 30th June 2024.
Correct.
You are hereby advised to regularize the account at the earliest. But this is the first, my lord, annexure that they have challenged. Also, my lord, page 184, that is also under challenge before your lordship. Page 184 is dated, letter dated is 8 July 2024. With reference to the credit facilities allowed by the bank, you have not observed the stipulations regarding the account, and therefore your account has been classified as non-performing asset as on 30th June 2024.
So it is on 13th June you are informed
as NPA on 30th June.
Correct.
So, my lord, his main challenge is the classification of the account as NPA. That is his main challenge before your lordship. Now, my lord, may I just take your lordship the interim order that was passed initially. The interim order is dated 7th October 2024. What was the interim order? The interim order says the bank shall consider the, my lord, paragraph 2. As your lordship got it.
Order dated?
My lord, order dated 7th October 2024.
Yes.
Affidavit service filed in court with taken note record. The petitioners are at liberty to approach the bank within 10 days from the date of their proposal. The bank shall consider their proposal and come back with a report before this court. The bank shall not proceed further in respect of the secured asset till November 21 November 2024, or until a decision is arrived at in this regard, whichever is earlier. The writ court cannot force the bank to accept the terms of the petitioners, but the parties are within their right to negotiate and come to a settlement.
Correct.
So, my lord, the honorable judge had directed for a settlement since they were approaching for a settlement. So, my lord, the bank was directed to consider their proposal. Lord, they had approached for an one-time proposal. Now, your lordship knows that they had approached for a one-time settlement. They made first installment. Thereafter, they failed to make the balance. So, my lord, the OTS proposal stood cancelled. This interim order was there. Thereafter, my lord, the interim order was not extended by your lordship. They went up to appeal. The appeal court had said that not to create any third-party interest in respect of the secured asset. Now, in the meantime, my lord, prior to filing of this writ petition, after the account was classified as NPA, bank has issued a notice under section 13(2). Now, that notice is at page 191.
Yes.
My lord, this notice is at page 191. My lord, here it says that the account has been classified as NPA and these are the dues. My lord, page 194, the middle portion. Further, please note that in your event to fail your discharge the liability in full within 60 days from the date of receipt of this notice, the bank takes any action under section 13(4) of the Act and you shall be liable to pay all costs and charges, expenses incurred by the bank in that connection. My lord will kindly allow. খালি 13(2) টা দেখিয়েছি, অর্ডারটা ইনিশিয়াল অর্ডারটা দেখিয়েছি।
Lord, the principal point of challenge of my learned friend, Lord, it revolves around, Lord, the document which appears at page 179. His contention is that, Lord, that classification of his account as an NPA is, Lord, an illegal classification. He says that why it is illegal? Because, Lord, the first notice that was given, that is dated, Lord, July 19th. Now, Lord, in July 19th, we have stated about, Lord, the NPA date that comes. Lord, that is at page 179.
179.
179.
That is June 19.
That is June 19, 2024.
Correct.
Now, Lord, here your lordship will find there are 4, Lord, account numbers. And an adequate, Lord, a warning about that your account will slip into NPA on 24/6/2024.
Correct.
And, Lord, due to credit shortfall, the reason number 1, and subsequently due to continuously overdrawn and pending overdues 2. And then, Lord, the amounts have been, Lord, stated. The outstanding has been, Lord, overdue as on such and such day. NPA date, Lord, I have already marked. And, Lord, we say that the CC limit is continuously overdrawn from, Lord, a particular date and has to be within the limit by such and such date, 28/6/2024.
Yes.
The term loan critical amount of rupees 3.33 lakhs on 29/6/2024 credit shortfall is all enclosed. So, Lord, there is not only one parameter, Lord, based on which, Lord, this notice was given. There are multiple. Then my learned friend, Lord, relies upon the next page at page 180 to say that there was, Lord, a communication by WhatsApp. And, Lord, this much was, Lord, that was asked for by the bank. This was, Lord, dated 28th of June, this WhatsApp communication. Now, Lord, it is a contention of, Lord, my learned friend that, Lord, at page 181, Lord, the payments were made and Lord, certain amounts were shown to have been withdrawn.
Page 182. Yes.
182 also. Lord.
14 lakh 14 lakh 58,063.
Loan recovery.
Yes, that was deducted by the bank.
Lordship. So, Lord, we are on the classification of NPA. Therefore, classification of NPA is governed by Lord, the master circulars of Lord, the RBI. Now, Lord, I am to only show before your Lordship, Lord, whether Lord, on the basis of the notice that they were given, I am entitled to classify as an NPA or not. This is one point. Secondly, as of now, Lord, we have brought forth, Lord, and it is also an admitted position that 13.4 has, Lord, already taken place. After, Lord, the 13.4, Lord, whether, Lord, his remedy lies before the tribunal or before the writ court, Lord, to that effect, Lord, I have a judgment to, Lord, assist your Lordship. Judgment paragraph below barcode. Now, Lord, the other point that my learned friend was, Lord, trying to, Lord, emphasize is, Lord, the Reserve Bank of India, Lord, the circulars.
No, they have taken the, as per his argument,
Lordship.
page 180, the bank has informed through the WhatsApp 5.80 is to be deposited. Correct. And they have deposited that amount.
Lord, it was not, Lord, only that, Lord, the 5,80,000, which was, Lord, the only thing, Lord, that was being asked for. It was, Lord, that the notice which speaks for it. Because, Lord, what transpired in a communication in a WhatsApp, Lord, doesn't, Lord, bind the bank in a, or override, Lord, the notice dated 19th of June. That is what I mean to say. Therefore, Lord, not only, Lord, that what, Lord, 5,80,000 is what that has been asked for.
Yes.
Lord, it is, Lord, that the shortfall. Your Lordship will see, Lord, the shortfall is not quite much.
Yes.
Now, Lord, the overdue amount, the second last column, Lord, when it is added up in respect of 4 of, Lord, these accounts, Lord, it is a substantial amount.
Yeah, what do you? As on 10/6.
As on 10/6/2024, NPA date is 24/6/2024.
Correct.
Now, Lord, they never say that, Lord, this overdue amount or the outstanding has been, Lord, satisfied. It's not their case. So, Lord, whether I'm entitled to brand it as an NPA or not, that is not the question that is. Now, Lord, your Lordship will kindly come to the master circular. Lord, page 54.
Yes. Yes.
But your Lordship will kindly see, Lord, the classification 2.1.1, Lord, 5, 6, and, Lord, the notes, Lord, below. Page. This is 91 circular page 91. Classification of, Lord, a non-performing asset is a loan or an advance where, Lord, then it comes to, Lord, Roman 5, Roman 6.
Any amount to be received remains overdue.
And then, Lord, the note, any amount due to the bank under any credit facility, if not paid by the due date fixed by the bank, becomes overdue.
Yes.
Then, Lord, how it is to be treated as out of order? That has been stated here. II
remains out of order in respect of
Lordship.
So as per your case, so in terms of page 179, there are several amounts due. Even if the 5 has been accepted,
Lordship.
Even then there is a word.
Then the classification is in accordance with, my lord, the Reserve Bank's master
NPA.
circular. Yes, that is my point. Second point that my learned friend was trying to rely upon, my lord. Okay, I'll just check it. Well. Now, my lord, there was, my lord, another question of, my lord, the additional interest, my lord, which was, my lord, stated to have been charged, which is not, my lord, payable according to the circular that my learned friend has relied upon. Lord, that whether the additional, Lord, the interest can be charged or not, Lord, that doesn't go to the root of the question about branding or classifying, Lord, that account to be an NPA account. But that might be an arithmetical error at all, Lord, if any at all on the part of my client. And Lord, that only takes to an account, Lord, 2003 and 70%. That is at page, Lord, 205.
Penal interest. Penal interest.
Lordship.
Paragraphs below. फटाफट करना. Yes.
So as per your submission, okay, if the amount is there, the normal interest is 8,98,000.
Lordship.
And you have claimed the penal interest of 1,09,000.
Lordship.
And additional interest of 2,300.
Lordship.
If at all it is not to be taken also, it
becomes a NPA.
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 As
It is
per
all
your
about, Lord, yes. It is all about, Lord, the accounting, Lord. If it is improper,
yes,
then also, Lord, it cannot be said that it is, Lord, branding is, Lord, bad.
correct. Because that amount also not include that the NPA will over.
Lordship.
That is your submission.
Yes.
I think 179. 179. No, 179, no. One 191. So 191.
Yes. Now, Lord, your Lordship will kindly come to, Lord, the 13-2 notice at page 192.
Yes.
Now, Lord, here, Lord, the balance outstanding as on 6/8/2024, Lord, that has been given in respect of, Lord, all this, Lord, the loan, the 4 loan facilities that they had taken.
Yes. What is the date of the notice?
Lord, this is
7th
dated, Lord,
7th
7/8/2024 at page 191.
Yes. Then
But then kindly come to page 193.
yes.
Lord, the first line has classified the accounts as non-performing asset as defined under section such and such on 36/20/24.
Yes.
But this is because, Lord, the borrower has failed and neglected to pay the amount due to the bank. So, Lord, as of the date when I issued, Lord, the amount that was outstanding was about, Lord, to the tune of 9 crores and odd. I put them on notice on, Lord, the June 19th to say that you put your account regular on a basis. You could not do so. It was, Lord, at a out of order stage prior to that. So, Lord, since they did not, Lord, respond to the notice in the manner, Lord, that I asked for, Lord, I was within my right to brand, Lord, the particular account to be, Lord,
So they are not submitted any reply to this.
But later on, much later on, beyond the statutory period, when, Lord, the matter is continuing here. No? After the interim order was vacated, but they filed Lord 13.3A.
Well, to that lordship will recall, we've said that the period 27 days was still left in that statutory period because that entire period they're calculating was the period when an order of injunction was there from this.
No, injunction Lord doesn't Lord make Lord suspend their right to file the reply under 13.3A. It was only Lord in respect of the properties that I should not take any coercive action. So Lord, to answer your lordship, yes, belatedly they have given. Yes. And your lordship will kindly take our opposition, my lord. In the opposition, my lord, we have stated in paragraphs.
Respondent number 2.
My opposition. Lordship, yes. Respondent number one.
Assistant General RBI. RBI.
Jayakrishnan JS.
Yes.
Lord, at paragraphs, Lord, starting from Lord 4, that is at page 2. Yes. Well, the entire reason, Lord, that why we have not classified Lord as an NPA, that has been given in my Lord the reply. Yes. Sorry. Out of order, that's it. But we'll kindly Lord see after what has happened Lord from 19th of June. But that is at page 7. Yes.
So these are the incidents which
These are the incidents, and Lord, your lordship will not find that Lord at page 12. I have given a gist of why Lord it was required to be classified as a Lord an NPA.
Correct.
Now, Lord, coming back to the question, Lord, whether Lord your lordship will entertain the writ petition about the classification when Lord there is a 13(4) notice given and they have a right under section 17 to challenge. Lord, I will be relying upon a division bench of Lord Telangana High Court, Lord, which is reported at copy আছে okay এটা copy but your lordship will kindly come to paragraph 817. What is this? Paragraph 8, 17, 18, 19, 20, 32 and 39.
8, 17.
Lord, I can hand over a short written notes prepared. In that, Lord, these are mentioned. Only for the benefit of my learned friend, I am giving the paragraphs. 8, 17, 18, 19, 20 and 32, 39.
Yes.
আর বাকিগুলো ভানু প্রপার্টিজ যখন এখানে দিয়েছি সেগুলো জাজমেন্ট গুলো এনেছিস but I'm not taking my lord's time by lord reading the judgments. I'm just handing it over. The gist are all here. But the judgments that I am relying upon.
Yes.
একটা জজ সাহেবের কপি দে এক সেকেন্ড জজ সাহেবের কপিটা দে এটা একটা একটা করে না all together.
Give all, I will.
Yes, all together. We have already given
mentioned here.
already it's mentioned and given in the gist. I don't want to waste time. Yes. Yes. So, my lord, this is, my lord, my submission. The writ petition is not maintainable because of, my lord, the subsequent event. Even, my lord, the classification was proper because they did not pay up the amount according to the 19th June notice. And, my lord, the classification of NPA is to be, my lord, measured in the light of, my lord, what that is contained in the master circular. That's all for myself.
Thank you.
13-4 is admitted. I don't want to repeat. That is admitted.
Yes.
The reason we are.
Where, yes, you are arguing counsel. Not here. Record and
Your Lordship,
Learned counsel for the bank has concluded his argument. Let the matter appear tomorrow at the top under the same heading for reply of the petition.
Your Lordship, kindly give me 5 minutes for a reply.
Come tomorrow. Yes.
Lordship,
Call the matter.
Your Lordship, kindly give me 5 minutes for the reply.
Come tomorrow. First matter I will take for reply.
For 5 minutes for reply. Grateful, Your Lordship.
Grateful.
Pass.
Please, my lord. My dear friend has come.
You already. My lord,
He said that he has
It
not.
is very difficult to catch hold of the Hedino.
No, my lord.
But my lord, he has
My
said.
lord,
My lord, he.
I barely pray for time, barely. Unless I'm stuck up in any other court, my lord.
He
My
said
lord,
that.
this application is probably for the third time by the same petitioner for visit outside India. Your lordship has also allowed on the last occasion. So this time they have given a schedule to go to London and to Germany. The cause is same, that business purpose, but 12-day schedule has been
I
given.
will pass an order. Whatever the business he will gain, then it will be submitted to the DD.
Well,
If the proceeding
my lord,
survives, my lord.
my lord, that's
Now, my lord, my dear friend cannot object to this because earlier when I prayed for my lord, Bangkok, he did not object. So
No,
Thailand, he has not
Bangkok is
objected
the
to.
special area.
So now,
Bangkok was the special area. That's why he has not objected for that. Now,
no, I indicated before, your lordship, my lord, that the business tour is at Bangkok. And today, it was there in Pattaya. And now, this time, London, Germany. My lord, only one thing, in other matters also I have indicated.
it's fixed. I have shown the date. It's
Yes,
March.
those are fixed.
March is
in
fixed. March, 9th March.
On the same date.
Please, my lord, absolutely.
And let him complete this.
so this is another matter.
That's another matter. My lord, I think all are tagged matters. So one matter is fixed, other matters will also follow, my lord. There will be no
Three
difficulty.
total matters.
All
There-
are tagged.
there are
These
total
are
three
tagged
matters.
matters.
3 matters were there. Now 2 new matters have come, I believe.
No, this
But this is, my lord, WPA 4577.
4.77.
And your lordship order, my lord, page 35. And that's my lord, WPA 4575.
75. So this, in that case, this case is not fixed for hearing.
So your lordship may tag these also, my lord. Same issue.
Same issue.
Absolutely, my lord.
These are grandfather, father, and son.
So what will happen to the London and Germany?
My lord, only I'm sorry, my lord.
Yes, what will happen to the London and Germany?
My lord, to London.
Passport.
In London, some days from there to Germany.
And
Germany, Düsseldorf.
And that too via Doha.
That's for the transit, man. No, my lord, if I may just request your lordship one thing, if my lord's pleasure will be to come to page 27, my lord. The earlier order so far the present petitioner is concerned. Your lordship's order, my lord. If I may, I'm sorry, my lord. Well, it starts at page 25.
Yes.
Now, if I may just request your lordship to come to page 27, para 10, 11 and 12. If my lord, similar stipulation can be given here also, my lord, we will give our undertaking so that it is intimated by, my lord, Enforcement Directorate and Bureau of Immigration.
Same order maybe.
Same order, absolutely.
Same
my lord,
order.
in terms of 10, 11 and 12.
Only the dates and the destination will change.
Will change, right.
Same order pass. Only give the date, the area 31st, Kolkata to London. And then page 27. And उसमें the as the connected matter last time, as the connected matter being WPA 4575.
4575.
Yes, my lord.
Of 2025 is especially fixed on especially fixed on
My lord, 9th of March, my lord.
9th of March 2026
2 p.m. my lord.
at 2 p.m. Let this matter be appear on 9th of March at 2 p.m.
Most of
along with the other writ affidavit.
most obliged.
Can dispose of. Huh?
Obliged to.
Deeply obliged.
Item 28, my lord.
Getting order in the yesterday's matter.
That I think it will be uploaded or it will be, I have dismissed, but directed the authority to extend the time for so purpose, reply to the so purpose.
Yes, yes. Writ petition has been dismissed. Deeply obliged.
But
My lord,
I have not extended, request directed to extend the time for.
Yes, yes. Adjudicating authority will extend.
My lord, I apologize. Item 28 was a passed over matter, your lordship.
Come tomorrow. 28.
My lord has possibly, my lord, kept the file in my lord's chamber, my lord, for reserving.
Which one?
My lord, these are the 3 writ petitions challenging show cause notice under the RBI fraud.
Which one? Which one?
Item 28, my lord. A can has been filed, my lord, in the writ petition, my lord, because after your lordship passed judgment, my lord, on the next day they issued a fraud declaration.
Where is the can? Can is not come.
My lord, the can is in the records today, my lord.
Can is in the court.
My lord, can is in the court.
So what you have prayed for in the
My lord, what has happened here is that after your lordship reserved the judgment on 14th of January, my lord, the same show cause notice, my lord, would recall in one of the matters, my lord, Mr. Dewan appearing for the bank, had conceded, my lord, that that the declaration that was made was illegal. Concession was made, my lord, your lordship recorded that. On that satisfaction, your lordship had disposed of reserved the matter for judgment. Thereafter, my lord, the next day, my lord, the earlier fraud declaration, my lord, on the basis of which concession was given, it was withdrawn. On the very next day, a fresh fraud circular was issued, my lord. This is nothing but an attempt to sit over in appeal over this honorable court and to steal a march over your lordship's final determination of the writ petition.
Who is for the bank?
My lord, I'm preparing for the bank family led by Mr. Diwan, my lord. He is on legs, my lord. If you, my lord, if I can get a short pass over, he'll be here by 12:45, my lord. 12:45, he'll be here, my lord. I need this short pass.
Pass over. एक काम करो.
But in the meantime,
matter कल का रखा था ना? Item number 32. 32 कल रखा है ना? Urgent motion. इसको वो फाइल में टैग कर दो.
My lord, in the meantime, would your lordships we take the records of the writ petition before this?
Yes, it will come in.
Great.
Yes, next.
I appear for the respondent number 11, the primary opposing respondent, my lord. I have a ground of maintainability.
Item number
33 minutes.
And for the statement, Lordship, before going to the fact, Lordship, due to urgency, I have prayed for Rule 26 of the appellate side rules.
Yes. What you have
Lordship,
prayed
I have
for? What is the
sent-
prayer?
I have served the petition to the state respondents. So for the private respondents,
No, he is Maintainability, yes, arguing the comment. Yes,
Lordship,
what is the point of?
Lordship, kindly come, Lordship.
He is raising the maintainability point. Let he raise the maintainability points.
That's my ground of maintainability is availability of an provision for appeal under the statute, Millard. Millard, kindly have this is an order passed under the maintenance and welfare of
Section
senior
5, Section 5.
No, Section 23, cancellation of an instrument.
Okay.
So there is a provision of appeal, Millard, in the statute, Millard. My lord will kindly have.
Who was the petitioner before the appellate or before the SDO? Senior citizen.
Senior citizen was
and against who is the respondent?
The respondent is a transferee of a gift deed in whose favor the deed.
Who is the petitioner?
The petitioners herein are the legal heirs of the original transfer.
So they are not the senior citizens.
No. Look, this issue has been settled, Millard. This is
by which order? Show me.
Yes.
Division bench order.
Division bench of Punjab and Haryana High Court.
Our High Court, Justice
Yes,
Banerjee passed an order. It is not
This is
applicable.
the Honorable Division Bench.
Kindly go through.
Already settled that this
Yes.
order is not a good law.
Go through this judgment. This court has already held. No, it is only the senior citizen.
And lastly, another judgment also I have come with the same view expressed by the Lordship, the Division Bench of the Karnataka Bengaluru High at Bengal. Oh, sorry. তো কোন প্যারাগ্রাফে ওই যে একটা অ্যাপিলের সেকশন
The second issue which will fall for consideration if we consider the judgment of Honorable Division Bench headed by Justice Banerjee is whether 226 is maintainable or not.
That is subsequent. That has been left over the court.
Yes, Millard.
That is left over the court,
Yes, because
whether it is maintainable. But the point, the senior citizen only can make an appeal. That is that has been upheld by the division bench. No, only the senior citizen can go to the appeal. The other, if it is not a senior citizen, the writ. Now it is writ also, whether it is 226 or it is 227.
That's the only issue which probably was not urged or argued before either the single bench or the division bench. I've gone through the order, Millard, is one primary issue. The challenge before a high court was to the vires of that particular statute, the Punjab and Haryana judgment. The Punjab and Haryana considered the vires of the judgment. Their lordships therein held that had it not been because of this interpretation, we would have held the statute to be ultra vires. Look, that is the sum and substance.
What is the date of the Punjab and Haryana?
Punjab and Haryana is May 28th, 2014.
2014.
Let's kindly appreciate the challenge before the
2014.
2014.
Order dated.
28th of May 2014. The Punjab and Haryana judgment, Millard. I have handed over a copy, Millard. Lordship can have it just for the records, Millard. 28th of May to 2014.
2014.
Yes, Millard. Millard, kindly appreciates the challenge was in relation to the vires of this particular provision.
Correct.
That it only enables a particular party to go into appeal.
Correct.
Their lordships therein held that we are holding it to be intra-virus because we are providing a purposive interpretation.
Correct.
Millard, in my humble respectful submission, Millard, had this interpretation not been accepted, then the only alternative would be to hold the provision to be ultra-virus by a competent constitutional court. And why I say, Millard, though this argument might not lie today, considering there is a judgment of
that's why I'm telling
division
you,
bench.
This court has to go by your parent court.
But Millard kindly appreciates one thing: when a judge, when a particular provision is declared to be ultra vires by any constitutional court, that provision is no more applicable or is held to be ultra vires by all other courts.
Correct.
If any high court holds that X provision is ultra vires, I cannot go to a different high court to say that no, that high court has held.
Where is that problem? Where the Punjab and Haryana?
Yes, Millard. Kindly have that Punjab Haryana judgment, Millard. Kindly give me just one moment, Millard. There is no paragraph numbers. I'll just indicate the particular paragraphs, Millard. Millard, the discussion is at internal page 8 of the judgment, Millard. Page 8. This is by a division bench of the Punjab and Haryana.
Correct. Justice Sanjay Kaul.
Yes, Millard. Because kindly sees page 8, the right of appeal of an affected party other than the senior citizen or parent.
Correct.
That is the heading. The maintenance tribunal is constituted under section 7 of the act, and appeal qua an order passed by the tribunal lies to an appellate tribunal. The appellate tribunal is constituted under section 15.
So these
15
are
and 16
these
is
are
laid
the-
down, my lord. Might
the
not,
provision has been
not
covered.
relevant. Kindly turns over to the next page, my lord, at page 9.
Yes.
An appeal is envisaged against an order of the tribunal.
Correct.
This is how section 15 reads.
Correct.
It does not say an appeal only by a senior citizen or parent. However, subsection 1 of section 16 refers to any senior citizen or parent aggrieved by an order of the tribunal. This seeks to give an impression on a plain reading as if only a senior citizen or parent can prefer an appeal, and thus restricting the appeal to only one set of party, while denying the right of appeal to the opposite sides who are liable to maintain it. However, this is not followed by the first proviso, which deals with the operation of the impugned order during the pendency of the appeal and clarifies that the pendency of the appeal will not come in any manner in the way of the children or relative who is required to pay an amount. Now, it can hardly be envisaged that in an appeal filed by the senior citizen or parent, there could be a question of absence of stay. Such absence of stay was only envisaged where an appeal is preferred by the children or relative. So the provision of stay is considered to be an enabling provision in favor of the child. It is that eventuality the proviso deals with. The proviso is thus consistent with what has been set out. Now, let's kindly turn over to the next page, at page 10. It has been the paragraph starting with the last paragraph. It has been submitted by the learned amicus.
Yes.
That the subject matter of right of appeal is not merely confined to the issue of maintenance upon the amount of such and such, but of seriously affecting the rights of parties even qua immovable properties as set out in section 23. Thus, transfers of immovable properties can be declared void. This power is vested not only qua family members or children of senior citizens, but qua every person. Not only that, as stated aforesaid, the provisions of such and such have to be read harmoniously. This is where the interpretation comes in. Section 15 nowhere mentions that the appeal against the order of the tribunal be confined to a senior citizen or parent. Similarly, is the proposition qua the first proviso to subsection 1 of section 16, which would only have been in the case of an appeal by the party liable to be maintained. The right to file an appeal is not excluded specifically by the provisions of section 16 subsection 1 of the said act, but it omits to mention. We may also usefully refer to subsection 5 of section 16, which provides finality to the order of the tribunal. Such finality can only be achieved after hearing grievances of both sides. If the appeal is confined to only one party, then the finality can only be qua the rights of that party, which has preferred the appeal, and cannot be envisaged qua the opposite party, which would have to take recourse to Article 227 of the Constitution. So this is the another observation, my lords. Thereafter, my lords, at the ultimate paragraph, the concluding part at page 20, my lords. 20 minutes, last paragraph, starting with now coming to the conspectus, my lord. My lord, has it, my lord? Now coming to the conspectus of the discussion aforesaid, we have no doubt in our mind that we would be faced with serious consequences of quashing such a provision. So the challenge is to the Bairis. Such a provision which deprives the right of one party to the appeal remedy while conferring it on the other, especially in the context of other provisions of the same section as well as of the said act. We have to avoid this. The only way to avoid it is to press into service the principle of purposive interpretation and casus omissus. The parliamentary discussions on the other provisions of the said act do not convey any intent by which there is an intent of the parliament to create such a differentiation. There is no point in repeating what we have said, but suffice to say that if nothing else, at least to give a meaning to the first proviso of section 16 subsection 1 of the said act, the only interpretation can be that the right of appeal is conferred on both the sides. It is a case of an accidental omission and not of conscious exclusion. Thus, in order to give a complete effective meaning to the statutory provision, we have to read to the words into the course of action as suggested in such and such. How can otherwise the proviso of subsection 1 be reconciled with subsection itself? In fact, there would no need of the proviso, which would be made ocious and redundant. It is salutary role of the construction of the statute that no provision should be made superfluous. There is no negative provision in the act denying the right of appeal to the other parties. The other provisions of the act and various subsections discussed aforesaid would show, on contrary, an appeal from both sides is envisaged. Only exception to this course of action is the initial words of subsection 1 of section 16 of the said act, which needs to be supplanted to give a meaning to the intent of the act. other provisions of the Act as also subsections of the same sections of the said Act. In fact, such and such is considered, and their lordships hold. We are thus of the view section 16 of the said Act is valid, but must be read as a right of appeal of is conferred to any affected party. So, my lord's challenge was to the virus. Their lordships held, we are holding it to be intra-virus only because thereby giving a purposive interpretation. Otherwise, it would be ultra-virus. So, my lord, in this context, whether this argument was advanced before the single bench or the honorable division bench of this court, my lord, that issue, my lord, is not there in the judgment. I have gone through it. Secondly, why 227 and not 226? Let's, we all know that 226 is not maintainable from an order of a civil court. Now, whether that can be extended to a tribunal of like nature or not. My lord, my submission is obviously yes, because of two reasons. Kindly appreciates, my lord, this is a statutory tribunal. It is not a hearing which has been conducted in the personal capacity or in the capacity of an SDO being an SDO.
Summary.
He is a designated officer. My lord, in that event, my lord, there are certain tribunals which are headed by members of the judiciary or ex-judiciary, like we have the municipal tribunal or we have the consumer forum. Lord, these are forums which are headed by members of who were ex-judicial officers. Lord, our court has consistently held that 227 is maintainable against orders of such forum and not 226. That is the reason we don't file 226 against such orders. 226 is generally filed where the person who has passed an order is made a party. So, in such nature where he is just a mere adjudicating authority. He does not have to do any inquiry, or his personal opinion is of no consequence, or his personal knowledge is of no consequence. 226 should be avoided also because it is at the expense of the exchequer. 227 is a litigation inter se parties. The moment it becomes 226, the primary litigant becomes the state.
Yes.
So, that is my argument so far as 226 and 227 is concerned. That 226 is not maintainable. Because here the SDO...
If the 226 is not maintainable, how the 227 will come in?
No, 227 is maintainable because 227 is the supervisory power over all courts and tribunals by the High Court.
Correct. All courts and tribunals.
Yes, Milord.
Correct. It is not a court.
This is the tribunal, statutory tribunal. Please kindly have the Act, Milord, the constitution of the tribunal. Section 7 is the constitution provision.
Yes.
Other will kindly consider other statutes like the Consumer Forum Act or even the insolvency and bankruptcy codes. There is a qualification given so far as the members and the presidents are concerned. The parliament did not deem it necessary in this statute to provide such qualification. The parliament left it to the discretion of the state government as to who will be the member or when will or how the tribunal will be constituted. But nevertheless, this is a tribunal constituted under a statute.
Correct.
In other provisions also, the state government appoints, but after giving deference to the qualifications mentioned in the statute.
Yes.
But the appointment is by the state government.
Yes.
The same provision is here, Milord. So why 226? Because it is at the expense of the state. The state becomes a litigating party. And the other point, because a constitutional court has held a provision to be intra-virus only because, I say only because, providing a purposive interpretation to a particular provision of that or that particular provision, Milords, I say, Milords, that becomes a ratio for all other courts. Because otherwise, if that is not followed, then as per the opinion of that constitutional court, this provision becomes ultra-virus.
Which provision?
This provision of providing an appeal for only one party. Lord, kindly appreciate if your lordships today say...
That's what, see, 226, 227 comes later on.
Yes, Milord.
Once the court, now there are two judgments.
No, Milord, subject to correction, Milord. If your lordships hold that 227 is maintainable and 226 is not maintainable, then probably, Milord, subject to correction, your lordship cannot go into the second question. First question is 226 or 227?
No. Now the first question is with regard to other than the senior citizen, can the appealist maintain, can prefer an appeal? Now, before this court, there are two judgments. Punjab and Haryana has gone into the ultra virus, but it cannot be ultra virus, it's an intra virus, and the 16 needs to be read valid, and any person can prefer an appeal.
Only because of that intra-virus.
That's why intra-virus, hold and intra-virus. But this court has considered, but it is not considered as ultra-virus, intra-virus only with regard to the interpretation has been given to the section 16.
Yes.
Section 16 and held that no, only the senior citizen has to be. And with regard to the 26 and 226, 27 kept open. Now, if first it has to be decided whether the other than the senior citizen is to file an appeal. Once it is file an appeal, so 226, 227 will not come into.
Subject to correction, Millets. Your lordship has to first decide the issue whether a 226 is maintainable or not. Because if your lordship holds that a 226 is not maintainable,
then
this issue will be probably considered by the bench taking a 227.
Correct.
The second issue.
Okay.
Whether an appeal is maintainable.
I appreciate.
But subject to correction, Millets. That is
I
my...
appreciate. Correct.
Yes, Millets.
Yes.
Also, kindly come paragraph 15 of the Honorable Division Bench order.
Our division bench? Yes. Justice Banerjee's order?
Yes.
15.
15, 1-5.
Yes.
Relying upon the decision of the Punjab Haryana High Court in the case of the Paramjit Kumar Saraiya, the learned advocate for the respondent number 6 argued that unless section 16th of the Act is construed as providing the right of appeal also to the children and relatives, there is a possibility of there being parallel proceeding resulting in conflict judicial decisions. There may be an order of maintenance tribunal with which both parents and senior citizen and the children relatives are aggrieved. The parent senior citizen would challenge the order before this appellate authority constituted under this Act. The children relatives would have to challenge the order by way of a proceeding under Article 226 or 227 of the Constitution before the Honorable High Court. This would give rise to an anomalous situation and possibility of conflict decision. Such a mischief can be avoided if the section 16th of the Act is interpreted as giving a right of appeal to the children and relatives also. With respect to the learned counsel, we are not impressed with this argument. Theoretically, such a situation may arise. However, there would be no possibility to conflict of decision of the High Court withdraws it to itself the statutory appeal filed by the parent senior citizen. The power of the High Court has whether under 226 and 227 of the Constitution. In view of the aforesaid, we set aside the judgment of the order impugned in this appeal and remanded the matter to the Honorable Single Judge having determination to where the matter to consider afresh. The learned counsel for the respondent number 6 argued that even assuming that no alternative remedy is available to the writ petitioner appellant, still an order of tribunal cannot be challenged by way of application under 226 of the Constitution of India. That must be done by way of an application 227 of the Constitution. We have noted this point as argued before us. However, we express no opinion thereon. We leave all issues open to the learned single judge to issue, including the point of maintainability of the writ petition, except on the ground availability of an efficacious alternative remedy in the form of appeal under section 16th of the Act, since in our opinion the right of appeal is not available to the petitioner. So, Lordship, I have no right of appeal. I only can avail 226 or 227. That is the issue.
Yes.
Now, Lordship, kindly come the division bench. I have also handed over the court of Karnataka, Lordship, in the High Court of Karnataka, that is
Karnataka High Court. Karnataka High Court.
Karnataka High Court.
Yes.
Division bench order just I have handed over. Same issue has been, Lordship, decided. Lordship, kindly come in at page 11. Points for consideration. Having heard the learned advocates for the parties, and on consideration of the submission of the following 2 points arises for the consideration of this court, whether respondent number 2 has a right of appeal under section 16th of the Act, whether the Honorable Single Judge in the facts is justified. Now, Lordship, for the convenience, relevant provisions are outlined below. Section 23 has been quoted. Yes. Now, 16th has been quoted. Now, Lordship, kindly come, paragraph 14.
তুমি কাজের কাজটা আগে করো না।
Yes. Section 23 stipulates that if a senior citizen transfer property, whether as a gift or otherwise, with the condition that the transferee will provide the basic amenities and physical needs, and the transferee subsequently fails to refuses to fulfill these obligations, the senior citizen may request that the transfer be declared void. Section 16 provides a senior citizen or parent the right of appeal against an order passed under Section 23. However, in this case, Deputy Commissioner entertained the appeal at the request of the transferee. The appellant has argued that such an appeal is not maintainable and that any order passed in such an appeal would withstand the legal scrutiny. Also, the learned advocate for the respondent 2 has cited argument from the various high courts and to argue that an appeal filed by the children or transferee is maintainable under Section 16th of the Act. However, before examining the judgment relied upon, the court deems it appropriate to first analyze the provision based on their plain text and intent meaning. When an order is issued under Section 23 of the Act, either by senior citizen or transferee may be considered an aggrieved party. The statute provides a remedy of appeal against such an order, which is governed by Section 16th of the Act. While two parties may potentially be affected by an order under Section 23, the appeal remedy explicitly applies to the senior citizen or parent. The language of Section 16 is clear and leaves no room for ambiguity or confusion in its interpretation. There is no difficulty in reading Section 16 of the Act in its plain context. The language of Section 16th of the Act is plain, clear, and unambiguous. The provision specially unequivocally grants the right of appeal exclusively to senior citizen, extending this right to any other persons, including the transferee is not permissible interpreting Sections 23 of the Act to provide the right of appeal to the transferee or any other person should amount to rewriting the provisions, a function that lies beyond this jurisdiction of the court. Granting such a right to the transferee would contradict the legislative intent behind that. There is no dispute with the legal principle that when a statutory provision is ambiguous, interpretative tools can be used to resolve the ambiguity. Now, if after such an exercise the court finds ambiguity, the interpretation should aim to fulfill the purpose of the provision. However, Section 16th of the Act is clear and unambiguous, leaving no necessary to resort the interpretation tools. Such and such in Gujarat High Court held. Now, Lordship, this is the several judgments has been relied. Now, Lordship, kindly turn off page 18. As the title of the Act suggests, the provision of the Act deals with the maintenance and welfare of the parents of senior citizen. The Act enacted for welfare of a class of citizen with an object to provide immediate relief towards their amenities and the basic physical needs. The aim was not only provide amenities and basic physical needs, however, with another broader object of speedy and expressive remedy. When the text of Section 16th of the Act read as understood in the light of the object and the reasons behind the legislation, it becomes abundantly clear the Parliament intended to provide the remedy of appeal under Section 16 solely to citizen or parents. An alternative interpretation would lead to an absurd outcome, which is not permissible. In view with the justifiable and other reasons, if the children transfer is agreed with the order of Section 23, they are not without a remedy. They can always invoke 26 of the Constitution. Now, while this may result in two separate proceedings before the different forum, such a situation cannot be used as a basis to extend the right of appeal under Section 16th of the Act to a different class of persons, as this right was not provided by the Parliament. The proposition that a statute is to be read, understood, and construed in its plain text without deeming or ignoring any words needs to reiteration. Further, while interpreting the provision, it is for the court to apply the law of its plain text. The proposition has an exception to invoke interpretation tools when the statute leads to ambiguity. However, language of section 16 is clear in the plain context without any ambiguity, which needs to further interpretation. The right of appeal inheres in no one, and therefore an appeal it is maintainable must have clear authority of law, and this explain why the right of appeal is prescribed as a creature of statute. As observed earlier, there are two classes of persons involved in the adjudication of the process under section 23 of the Act, and transferor and transferee. In this context, transferor refers to a senior citizen and parents, while transfer includes children, third parties. The legislature had granted the right to appeal only senior citizen parents, with no such right extended to the children or third parties. The court must also consider the potential of violation of Article 14 of the Constitution of India. In evaluating any claim of the discrimination and reasonableness of the classification of a critical factor as established by the various courts, Article 14 prohibits class legislation, but not classification. For a classification, it is to be permissible. It must be based on an intelligible differentia that distinguishes the persons or things grouped together from others left out, and differentia must have a rational connection to the object the statute seeks achieves. That if equality and uniformity exist within each group, the law will not be deemed discriminatory, even if due to specific circumstances, some individuals within the class receive an advantage over others, so long as they are not singled out of the special treatment. Therefore, the provisions granting the right of appeal solely to senior citizen or parents cannot be interpreted to include children, third parents as having right of appeal. Now, Lordship, this Honorable Supreme Court's order has been relied, and ultimately, Lordship, kindly come. Paragraph 38. In the light of the above analysis, the only reasonable interpretation of section 16 of the Act is that right of appeal is vested exclusively in senior citizen and parents, not any other individuals, including children and transferees. Thus, having held that section 16 of the Act grants the right of appeal only to senior citizen or parents, the contention of the respondent number 2 is unsustainable. The appeal under section 16 of the Act before the Deputy Commissioner by the respondent number 2 is held to be not maintainable. In the light of the conclusion reached by this court, the judgment of different High Court with the contrary view providing right of appeal to the children transferred, the courts respectfully disagree to endorse such view. Learned advocate for the respondent number 2 relied various judgment of the High Court to contend that appeal under section 16 of the Act is maintainable by other than a senior citizen. The first judgment of Punjab, Haryana, Paramjit Kumar Suraiya. Lots of that judgment I have, my learned senior friend has relied.
Junior
The other judgments relied are rendered by the following judgment of Punjab, Haryana High Court. It is suffice to the judgment is dealt. It would be repetition if other relied judgments are separately dealt with exercise to unnecessary with the due respect. The Punjab and Haryana Court has held that section 16(1) of the Act grants right to appeal of any affected person. The reasoning behind this conclusion is that the omission to other parties from the provision of an incidental oversight rather than a deliberate exclusion. Additionally, the court noted that there is no explicit provision of the Act that denies the right of appeal to other parties. The court finds difficult to concur with the above reasoning, with the provides right of appeal to the affected parties. As held by the Honorable Supreme Court, the golden rule of the interpretation of a statute is that. Now, Lordship, subsequently, Lordship, it is held that section 16 is not available to
52.
Yes,
52I.
52.
I did not have this, Millets, on the issue of 226 and 227. I just got it, Millets. But there is one judgment of the Honorable Supreme Court holding that 226 is not maintainable. On the basis of that judgment, a division bench of Allahabad High Court, headed by Justice Saraf, has also passed the similar order. Just on the issue, on that issue, because that is the primary issue. I mean, bolo dikhti side. Let's the first one is by the Honorable Supreme Court reported in 2010, Volume 8, SCC 329. It was judgment of Shalini Shyam Shetty and another. This is solely on the issue of whether 226 will lie or whether 227 will lie. But I will not refer to the entire judgment. Kindly just note this, that the dispute herein was inter se between a landlord and a tenant. That Honorable Supreme Court has classified this dispute to be a private dispute. Now, let us see the observations of the Honorable Court. Kindly comes to page para 46 minutes. Article 226 and 227 stand on substantially different footing. As noted above, prior to the Constitution, the Charter and as also the Judicial Committee of the Privy Council to issue prerogative writs in exercise of their original jurisdiction. However, after the Constitution, every High Court has been conferred with the power to issue writs under Article 226, and these are original proceedings. The jurisdiction under 227, on the other hand, is not original, nor is it appellate. This jurisdiction of superintendence under 227 is both for administrative and judicial superintendence. Therefore, the powers conferred under 226 and 227 are separate and distinct and operate in different fields. Another distinction between these two jurisdictions is that under 226, the High Court, kindly marks this.
Yes.
High Court normally annuls or quashes an order.
Correct.
Or proceeding. But in exercise of 227, the High Court, apart from annulling the proceeding, can also substitute the impugned order by the order which is inferior to the tribunal should have been made. Because kindly considers this is a judgment which is either in appeal, revision, whatever. So if it is in 226, your lordship is devoid of the power of supplanting or improving the judgment. Your lordship can either say the judgment is okay or it is bad in law. But your lordships cannot change, amend, or modify the judgment under 226 as held by the Honorable Supreme Court.
Then what would happen if the Central and Fifth Tribunal, it is also a tribunal?
227 will lie.
No, 226.
That is under 320, Article 323.
23, yes.
That is separate, Milu. That is by the constitutional bench.
Okay.
Chandra Kumar.
Yes.
Please kindly see 48. The jurisdiction under 226 normally is exercised where a party is affected. But powers under 227 can be exercised by the High Court suo motu as custodian of justice. In fact, the power under 226 is exercised in favor of persons or citizens for vindication of their fundamental rights or other statutory rights. The jurisdiction under 227 is exercised by the High Court for vindication of its position as the highest judicial authority in the state. In certain cases,
where there is an
infringement of fundamental right, the relief of 226 of the Constitution can be claimed ex lege or as a matter of right. But in cases where the High Court exercised 227, such exercise is entirely discretionary and no person can claim it as a matter of right. From an order of a single judge under 226, an intra-court appeal or a latest petition appeal or is maintainable. But no such appeal is maintainable from an order under 227. In almost High Courts, rules have been framed for regulating exercise. So thereafter, the concluding part, kindly at para 49A. A petition under 226 of the Constitution is different as held. In any event, a petition under 226 cannot be called a writ petition. The history of conferment of writ jurisdiction on High Court is substantially different from history of conferment of power of superintendence. High Courts cannot, at the drop of a hat, in exercise of the power of superintendence under 227, interfere with orders of tribunal or courts inferior to it, nor can it, in exercise of power, act as court of appeal over such orders. This is not relevant here. D and E is also not relevant. I will not waste the.
No, E, come to E.
Yes,
the High Courts cannot, at the drop of the head, in exercise the power of superintendent and 227 of the Constitution, interfere with the order of tribunal or court inferior to it.
So those are the self-restraints imposed so far as 227 is concerned. That even if the order is bad,
then it has to be interfered.
Yes.
One thing, before this Justice Banerjee's order, it has come to the single bench. Whether it was decided, single bench decided or not. The Justice Banerjee has referred to the single bench. Whether what has happened to that proceeding, it is pending or decided. Otherwise, then again it will be a contradictory order.
Lordship, that will, I will.
You have to see, because if suppose the coordinate bench had decided it is 226 or 227, and this court will decide, then again it will be a contradictory order.
Just kindly just a para 51. Just one.
It is 1033 of 2019.
I'll not read it to para 51. And thereafter, let's just kindly have para 51 of that order. So 226 window is open when collusion with the authority administrative, where somebody is saying that the deciding authority is my friend, etc. 226 is maintained. Apropos that, we will kindly have the division bench of the Allahabad High Court judgment of Justice Saraf. Strictly on this issue. Statutory tribunal. Here the case of consumer forum.
Yes.
Whether 226 or 227 is maintainable, longish order, but the relevant portion is at page 19, paragraph 20.
Yes.
Moreover, the Supreme Court in such and such has held that writ petition against order of National Commission is maintainable either under 226 or 227 of the Constitution. Kindly mark this. Subsequently, the Supreme Court in such and such has held that writ petition under 226 would not be maintainable if there is an alternative remedy under different jurisdiction of the same High Court. So, thereby meaning, if 227 is maintainable, then 226 cannot be invoked. Kindly have 21, para 21. In light of the judgments referred above, we are of the view that when a supervisory jurisdiction under 227 is available to the petitioner, the writ petition under 226 should not be normally entertained, but remedy under 226 would be available under exceptional circumstances. That is there. Further, writ jurisdiction under Article 226 is cautiously to be used when grave injustice has been caused due to violation of principles of natural justice, etc., etc., etc. So, I say that it's a statutory tribunal. Under 227, the High Court has power of superintendence over all courts and tribunals under its territorial jurisdiction. There is nothing to indicate or propose that this order is not amenable to 227. By the dictum laid down by the Honorable Supreme Court and followed by the Honorable Allahabad High Court, it is made clear that when 227 is maintainable, 226 is not maintainable, and the general proposition that we go into, that 226 and 227 are of similar nature, but that is not true, my lord, as held by the judgment of Justice Ganguly. Those are my respectful submissions so far as the issue that 227 is maintainable and 226 is not maintainable. And also, my lord, kindly consider 226 is always the primary relief is against the state. Lord, here it's a private order. I went file an original petition. He's aggrieved by it. What has the state got to do in this?
Okay.
Yes.
Lordship, first of all, the Honorable Division Bench already held that 226 is maintainable. So far, this writ petition is concerned, Lordship, this writ petition already has been disposed of, but I have to collect the order.
And that's why what has been, whether it's 226 or whether it has been decided, the issue is decided.
It is online showing it is disposed of, but no order has been uploaded.
Order.
Well, I'll just take it off.
See the order.
I'll just take it off.
Now, Lordship, so far the urgency of this matter, Lordship, I have pleaded. Because, Lordship, the order was...
No, it first it says to whether it's 226, 227. If it's 227, and then again the question whether 226 is to be converted into 227, or you have to withdraw and file it 227.
Now, Lordship, this is then not a first round, this is a second round of litigation. Because earlier round of litigation, your Lordships has entertained this application under...
Point was not raised. Point was not raised. If now the point has raised, now it has been brought to the notice of the court has to decide.
Now, Lordship,
now the point has been settled. Now, appeal provision is not applicable to you. Okay, no problem. As per our court judgment and the Karnataka High Court judgment, so we have to ignore and the Karnataka High Court disapprove the Punjab and Haryana High Court judgment. Now, appeal is not applicable to you. Now, whether it is 226 or 227, you are relying
upon division bench of the Karnataka High Court judgment.
That is one paragraph. It is
one paragraph. It is written that 226 is maintainable.
But now it has to be. Now our court is has been left over to this court. Whether it has to be. They can always invoke the 227. Now,
Lordship, this order, this writ petition order has not been uploaded. So far, just now I have checked. Matter has been disposed of after 2020 because
when it was disposed of
2024. No, this is the judgment of
2020.
2020. So after COVID. So after COVID,
No,
it
no,
ought-
during COVID.
Huh? No, Sarvana, that is after initiation of this, Lordship, the new system of WPA. So, Lordship, this order ought to have been uploaded, but it is not uploaded. I have just checked now. On this order, after this order, the Honorable Single Judge has disposed of the writ petition. So I have to collect this order. Now, Lordship, so far my urgency is concerned, Lordship, I cannot wait till tomorrow.
But what is the urgency?
Lordship, urgency, Lordship, kindly come
Where
to
is
the
the order?
impugned order. Within 7 days, the subdivisional officer has directed to Lordship to remove the encroachers.
Where
That
is the order?
Lordship, kindly come, starts from page 362. Third, Lordship, the volume. Kindly come, third volume, 362.
I don't know about your lordship's copy, but my copies, I cannot read anything in the impugned order. Same.
Yes.
Lordship, kindly see the legible copy. I have, if it is problem. Lordship, kindly come, inner page
362.
Inner page 15.
Yes.
As per the order, as per section 23(1), Maintenance and Welfare Parents and Senior Citizen Act 2007, this tribunal to hereby declare the deed void such and such of 2014 deed has been cancelled. ADSR Rampurat is hereby directed to note the above order of cancellation of two deed on the margin of the copy of the books as per Rule 17.4, 17.5 of the West Bengal Registration Rules. Ms. Sri Onkur Mitro, WBCS Executive Block Development Officer, Rampurat 1, is directed to recover the physical possession of the house situated in the following schedule of the land within the fortnight and to hand over the same to the applicant, Srimati Sipra Mukherjee, at the same day and same time. The BL and LR Rampurat 1 is directed to provide a team for identification of the suit land at the time of takeover possession. The inspector in charge, Rampurat Police Station, is directed to provide police force to maintain law and order at the time to take over the possession. The applicant, Sipra Mukherjee, will have the liberty to proceed with the office of BLR Rampurat 1 to correction for record of rights in her favor. By virtue of this order, and the BLNL Rampurat 1 will proceed on application to reinstate the record of the applicant, and Srimati Sipra Mukherjee will have also the liberty to transfer the said property afresh.
Okay.
Kalachand and Ashish Datto and Sri Subhasis Datto, son of Sri such and such, hereby directed to vacate the premises of the above civil land and a house wherein to remove the encroachers of the house of the applicant, Srimati Sipra Mukherjee, situated at such and such, within 7 days after receiving of this order. Failure of which the block development.
Where is within 7 days?
Lordship, the kindly come paragraph 7.
Kalachand, so both sons, so vacate this house, plot number within 7 days.
Within 7 days after receiving in the order, failure of which the block development officer Rampurat 1 will enforce.
What is the date of the order?
Lordship, this
January.
Yes. Now, Lordship, kindly when the order was communicated. The kindly come page 367. This is the receipt. The original count. The order, the letter envelope was drafted on 21st of January 2026.
367.
Page 367. And this is the original envelope.
Dispatch 20 January.
21st, Lordship, January, it has been dropped.
Yes.
Now, Lordship, I received on 22. From 23 to 26, it was a holiday. I filed it on 27.
Yes. See, there is a law point involved here. Correct. I am staying the order. First, I will decide with regard to 226 to 27. I will 226 because I want that order. in that just a Banerjee has
That's
passed.
fair. That is completely.
If it is taken, if it is decided, then nothing to do. If it is not decided, then I have to decide. That.
Even if it is decided, your lordship can take a contrary view. Nothing.
Ah, that's correct. But we have to see.
Yes. Persuasive value.
Yes. To see the findings. What is the findings on that? So that has to be seen. So for the time being, I am for the fortnight. I am staying this order.
Just 2 minutes, madam. This is the second round of litigation, but just to show the conduct of the petitioner. Now, your lordship's earlier order is dated 7th of November 25. Kindly just have that order once. That is at page 52 of the present writ petition.
Yeah.
Last time, my lord, your lordships interfered because of 2 grounds, my lord, which is at page 56, 55 and 56, para 12.
Yes.
So the 2 grounds were that the report which was prepared by a officer, subordinate officer, and the letter of complaint which was filed by B were not made over to the petitioners, and hence violation of a principle of natural justice.
Yes.
That is the ground that why the lordships interfered, my lord. And my lord, thereafter, my lords, kindly see what has happened and what was the direction. My lord, kindly have para 14. Para 14 of your lordship's order.
Yes.
My lord, order is set aside. As the petitioners have got the copy of the report, the petitioners are directed to file the exceptions, if any, as well as objection to the complaint of the private respondent within 2 weeks. 2 weeks from 7th of November. From the date of the 2 weeks before the subdivisional officer. Thereafter, my lord, kindly have para 15. Till the disposal of the matter by the subdivisional officer, the parties are directed to maintain status quo with regard, etc., etc. It is found that the subdivisional officer has received the report that the original donee, such and such, has died. But instead of impleading the legal heirs of the donee, the subdivisional officer has proceeded the matter according to the petitioners. The petitioners therein and the petitioners herein are directed to inform the subdivisional officers with regard to the legal heirs of Devashish Dotto if information is received, etc., etc., within 2 weeks. So again, 2 weeks from 7th of November. I am a septuagenarian 73-year-old lady who is a widow, does not have any children, does not have any source of income, so I cannot claim maintenance from anybody. The only way
Who are they?
These are the legal heirs of a transfer. Because I did not have children of my own, I was a teacher. So I was fond of 2 students and I treated them like children.
Yes, I understand.
So I transferred my property to them. I did not have any children of my own. So after some time, they stopped looking after me. So today, the only way of maintaining myself is through these properties, because some portion of this property is on rent, which is now been collected by them. That is the first part. But what I am indicating is this direction was passed on 7th of November. Because on 22nd, they say they have received the impugn order and they are before your lordship within 5 or 6 days. They had 2 weeks to go before the subdivisional officer. Now, my lord, kindly sees the order of the subdivisional officer on 10th of December at page 198. Because, my lord, by their conduct, they have to also display before your lordship, before seeking an interim order, that there has been no delay or latches.
No, we have submitted the.
May I? Page 198.
Yes.
This is 10th of November, so clearly after more than a month after your lordship's order.
Yes.
Case record is put up for compliance with solemn order dated such and such, passed by the Honorable High Court in such and such. It has been intimated from the end of the district magistrate that by an order passed dated such and such by the Honorable High Court, the passed order dated such and such in this case has been set aside and remanded back to the matter to the maintenance tribunal to consider the case afresh after giving an opportunity of hearing to all affected parties. At the same time, the petitioner of such and such were directed to file exception against the report, if any, as well as the objection to the complaint of the private respondent within 2 weeks, that is from 7th of November, yes, before the undersigned. But those petitioners did not comply with the said direction of the High Court, not submitting any exception to the report or objection to the complaint. Till disposal of the matter by the undersigned, the parties to the instant proceedings have been directed to maintain status quo, etc., etc. Thereafter, the petitioners were also directed to inform the undersigned with regards to the legal heirs. But no such information has been received. So thereafter, further notices were served upon them. So this is their conduct, that even after a month, though it was directed within 2 weeks, They have not complied with what your lordship had directed them to do. Thereafter, my lord, kindly sees their further conduct. They go and ask for a condonation of delay of the time period provided by your lordship before the subdivisional officer, belatedly, on 19th of December. My lord, I'll just indicate the page number. My lord, kindly just give me one moment. Because many pages in my copy which has been served are not legible altogether.
Page 59 is my receipt copy.
59 minutes probably. Thank you so much.
59 is my receipt copy.
Yes. 59 on 19th of December, they filed it. Direction on 7th of November, direction for 2 weeks. Matter is taken up on 10th of December. On remand, they file it on 19th. Kindly sees the ground made out at page 62. But I'll not read it along, Lord. Kindly just have paragraph 1, 2, and 3.
Yes. So whatever it is, it has been granted.
No, not granted. Not granted.
They are not filed.
No, the subdivisional officer has held, I do not have the jurisdiction. I will only consider your written argument. That is there in the impugned order.
This application has not been considered.
May I? He only in the impugned order has stated it has been filed belatedly. I will not consider this. I will only consider the written submissions. I will be very frank and honest before your lordship. The written submission also had the same documents which were appended to this. But what I am indicating on is they are praying an interim order today on the basis that order passed on 22nd. I have been asked to vacate within 7 days. And they can file this writ petition before this honorable court, which is 300 kilometers away. However, when they had to file a representation pursuant to your lordship's order at 50 kilometers distance, they made out a ground that this is the reason I could not do it even after 1 month. So, their conduct do not inspire. Kindly see what I am against. Today, I have been served a writ petition, half of the pages of whom are unlegible on WhatsApp. I am 72, 73-year-old today. I do not have anybody to look after myself.
But the court.
I do not have a source of income.
Okay, whatever they have done, but they cannot take the benefit of that when the final hearing will be taken. Let the court.
But kindly also sees that till that point of time, I do not have a source of income. I do not have.
So I will pass an order, conditional order, that till the state subject to payment of maintenance of rupees 10,000.
Very well. Very well.
I am staying this subject to payment of maintenance of 10,000.
Very well. Kindly do not indicate as maintenance because then a legal issue may arise. Kindly says cost.
Not cost for the maintenance of
Very
the
well.
Maintenance, maintenance.
Well, kindly makes it reasonable so that I can maintain myself 10,000 minutes as your lordship so desire.
Now,
lordship, for a limited period.
First of all, lordship, this is not on merit. Lordship, this is the section 4 and 5. Lordship, for the time being, lordship, I am ready to willing. Lordship, as the alleged, I am ready to willing to pay. But lordship, so far section 4 and 5, this is a proceeding under section 4 and 5 initiated along with section 23. Lordship, I am lordship part of the property. Lordship, part of the property, lordship, the given to the another private respondent, who is the sister of the lordship, the petition, the private respondent.
Where is the impugned order?
Lordship, impugned order at page.
The petitioner has filed the present
374, 348.
Challenging petitioner or petitioners?
Petitioners, 3 brothers.
Petitioners have filed the present application, praying for challenging the order passed by the subdivisional officer, passed by the presiding officer, maintenance tribunal, Rampur Hat subdivision, and subdivisional officer Rampur Hat Birbhum. In case number 23/PG/maintenance/SDO-RPH/2025 under section 5 of 5 read with section 6 of the Maintenance and Welfare of Parent and Senior Citizen Act 2007, wherein and whereunder the subdivisional magistrate, the subdivisional officer has passed the following order. This 362, na? 362 to 364. Yeah. Learned counsel for the petition submitted. The impugn order is passed on 21st of January 2026, which was received by the petition on 22nd. 22nd January 2026, and immediately the petitioner has filed the present writ application. He submitted in the impugn order. The sub-divisional officer are directed the petitioners to vacate the premises of the scheduled land and the house, and to remove encroachment from the house of the applicant, Srimati Shipra Mukherjee, situated within 7 days after receiving the order, failing which the block development officer Rampurhat Development will enforce the eviction and removal of the encroachment with the help of the inspector in charge of Rampurhat Police Station. Learned counsel for the petition submitted unless and until the impugn order is not the operation of the impugn order is not stated, the writ petition filed by the petitioner will become ineffective. The learned counsel appearing for the opposite party number?
Respondent number 11.
Respondent number 11 submits that the writ application is not maintainable as the order passed by the sub-divisional officer is appealable under section 16 of the Maintenance and Welfare of Parents and Senior Citizen Act 2007. In support of his submission, he has relied upon the judgment in the case of Paranjit Kumar Soria versus Union of India and others, reported in 2014 SCC online P&H 10864, wherein the Honorable Division Bench of the Punjab and Haryana High Court held that Section 16 subclause 1 of the Act is valid but must be read to provide for the right of appeal to any of the affected parties. He submitted any of the affected parties. He submitted if the petitioners are affected by the order of the impugn order, they can prefer an appeal under Section 16 of the said Act. He further submit that. Learned counsel for the petitioner has relied upon the judgment in the case.
I'm sorry, but I found out the order of the single bench. It has been held that 227 is maintained. So I can handle it. In that event, probably they should be relegated.
Then it cannot be here.
Thank you.
Then how is this court can take?
I don't know, so I have to.
I'll hand over. I'll hand over a printout to your lordship.
Give the printout.
Lordship, kindly next week, Lordship, kindly fix it next week. In the meantime, Lordship.
Once it is there, how the court can?
No, Lordship, kindly.
This court is not having jurisdiction. This court is not having jurisdiction.
I'm sorry.
No, because Lordship, this is contrary view. Because Honorable Division
Bench. Contrary view. 226. Our courts. I will go by the parent court, and the division bench of the Karnataka High Court only then he can invoke the 226. It is not decided.
No, whether this
the point is not decided whether it is 226 or 227, and the division bench of this court has specifically framed the issue, directing this court to decide whether it is 226 or 227, and the coordinate bench has decided. I don't know.
I don't know also which is the judgment in terms of the.
Just you are having.
Yes, I'm just handing it. If your lordship provides the mail ID of the court, I can forward it. No, I'm just handing it.
I am not keeping phone here.
No, the court.
No,
yes.
Urijit Banerjee WP number ta Justice Banerjee.
No, this is the 103.
I have kindly see the order which was come back from the Honorable Division Bench.
The division bench is Mamta Sarki and another, but the cost item is same, Milord.
1033 of 2019.
Mamta sir ki.
Yes, that is the cost title there, Milord.
Mamta sir ki.
One thing. Final order.
চেক করুন তো এটা চেক করুন
Circuit bench.
Got it?
This is probably a
Oh.
circuit bench of
Jalpaigur. So you do one thing. So what can be done? You take.
I use my online খুঁজে পাচ্ছিলাম না।
Lots of kindly take this matter tomorrow, lots.
One line order.
Lots of not to take any steps in course of the today because
no,
in course of the today, lots of.
क्या बोलना?
In course,
kindly do not pass that order because
It is in
eviction is not
no,
there.
no,
Otherwise,
only because today is the date of eviction.
This court, the Honorable Division Bench of this court, by an order dated 19th of March 2020, held that the other than the senior where is the division bench order? That is conclusion.
Lots of the division bench order, lots of the
at para 19 minute at page 12.
हाँ क्या बोलना?
paragraph 15. Kindly come paragraph 19. अरे এটা তো corrected form টা আগের অর্ডারটা কোথায়?
Honorable Division Bench of this court in the case of Mamta Sikri and another versus State of West Bengal and others in MAT number 61 of 2019 held that section 16 of the act is applicable only for the senior citizen. Only for the senior citizen. But it was left open to this court whether the other aggrieved person may prefer a writ application under Order 226 of the Constitution of India or Article 227 of the Constitution of India. Full stop. The parties are directed to place the order whether any decision has been taken by the Mila kya? By an order dated. Full stop. In terms of the Honorable Division Bench order, the coordinate bench of this court, by an order dated 22nd of April 2022, in WPA 1033 of 2019, within bracket Mamta Sikri and another versus the state, held that
বলছে এটা তো 226 dispose করে দিল।
held that, but it is corrected order.
Lots of this is the correct. Lots of kindly come previous day's order. It has been dealt with the 226.
Where is the main order?
It's the main order. Lots of kindly see.
Where is the? It's a corrected order.
It's the corrected order. This is the main order. The 226 it has been disposed of.
This order is prior to division bench order. What you are showing? Kindly see, this is the order of 2019. Division bench order 2020. It is in sub carto. Let the matter appear.
Because I just read it out, it has become abundantly clear that an order passed by the learned tribunal under such and such, the Senior Citizen Act, can be challenged by way of an application under 227 of the Constitution and not by way of an application under 226. In view of
No, but because that was only 2 page.
yes,
Evidently clear that an order passed by the tribunal under maintenance senior can be challenged by way of yes.
কুড়ির পরে অর্ডারটা বার করবে
No, WP, na? Held that the order passed by the tribunal under Maintenance and Welfare of Parents and Senior Citizen Act can be challenged by way of an application under Article 227 of the Constitution of India and not by way of an application under 226 of the Constitution. This court find that the present petitioner has filed the present application under Article 226 of the Constitution of India. Thus, the writ application filed by the petitioner under 226 of the Constitution of India, being WPA 1775/2026, is not maintainable. According, same is dismissed. However, the dismissal of the present writ application will not prevent the petitioner to take appropriate steps for filing an application under Article 227 of the Constitution of India challenging the interim order. I dismiss with the liberty to file a.
Lordship, kindly, Lordship, as this is the order, today is Lordship the eviction. Lordship, kindly give some protection.
So, my lord, would your lordship be pleased to take it up now, or my lord, any other time?
What is the matter? What
My lord, he told your lordship they will not do any declaration. Next day they do a declaration. Then next day they recall it and do another declaration.
Yes,
So
Mr. Diwan, what has happened?
Yes, my lord. May I now, my lords, may I explain to your lordships? Now, my lords, your lordships will recollect. On the 14th of January, your lordships had heard 4 different matters of 4 different banks.
Correct, correct.
Now, insofar as the Indian Overseas Bank was concerned, which is the matter now there, I had myself very candidly and fairly told your lordships that in Indian Overseas Bank, there is a problem.
Correct.
And the problem was, and I told myself this as an officer of the court, the
Correct.
problem was because there was a fraud order, but there was no prior SCN.
Correct.
So if your lordships recollect, the SCN in that case had communicated that we have declared you as a fraud and we are now giving you an opportunity. This is the state at which the matter stood on the 14th of January. Now, what we did not know on that date was that prior to 14th, which is on 6th of January, the bank had sent another letter, but saying nothing new, saying already the same thing which was there in the SCN of 2025, that we are continuing with the fraud order. Nothing new was said. That letter was received by the petitioners on the 14th of evening, though dated 6th of January. Then the letter was recalled on the next day, which is 15th of January, again saying nothing new.
Reissued.
No,
if it was
Fraud declaration reissued.
and
Yes,
fraud
yes.
was reissued, that's my problem.
I'm
I
coming
totally
to that.
believe Mr. Diwan when he says his clients hadn't told him.
No, that's
Happens to
one
us all
second.
the time.
May I just clarify? There
Yes,
is no
please see
attempt to.
52 of the application.
There has absolutely been no attempt to overreach the jurisdiction of that court. If that would have been the intent, I would not have told your
No,
lordships.
nobody is saying that, Mr. Diwan. We trust you.
Yes. So my point, Balas, long story short, my point is simply this. When your lordships considers the main writ petition, if your lordships set aside the show cause notice, giving liberty to the bank to reissue as in accordance with law, these subject letters would automatically go. They will not survive. So the assurance to my friends is that if they succeed in the main writ petition, these letters issued on the 14th or 15th of January will automatically go.
Absolutely.
That's all that I'm saying. So I'm
Absolutely, and
again.
he's right. But in all the matters where your lordship set aside, your lordships also set aside the consequent declaration. So, my lord, your lordship would set aside 15 January.
The petition, though the matters have been heard by this court and kept for passing judgment, but in the meantime, the bank has issued further notice, which the petitioner has brought the same by way of the CAN application. Let the CAN application be tagged with the writ application.
Grateful.
I have only one very humble request to make. There were almost 4 different matters. I'm sorry, I'm repeating myself. Because in one of the matters I'm fairly telling your lordships should not affect the outcome in the other 3 matters because there is no proprietary, there is no lack of.
That's why not pass any. Only I kept the same as with the writ petition.
And this is
Let the court.
correct. Then
I'm so deeply aware.
Already it is CAV, so I cannot pass any further order. Let it be decided.
Yes, I'm so grateful. I'm deeply obliged.
Before your lordship calls the list, my lord, before your lordship takes up the 2 p.m. matter, but item 40, the interim order is still today. Let it remain in the list.
Today, man. That matter yesterday we did, my lord. The interim order is still today.
Let it remain in the list. Kindly extend the interim order for item 40, my lord.
40.
40.
And my is 38.
40 record an order.
38, my lord, I appear for the
But just a minute. Please wait. If it is the 2 p.m. matter is not taken, then I will call the list.
This is the order in item 40.
I will take the matter. If it is not taken, come at 3. I will act.
Yes.
If the 2 p.m. matter will not taken, then I will call the list. Yes, call the list. Supplementary. Just a minute.
My instance, my lord, this matter was supposed to appear yesterday, my lord.
Yes.
But the business of this honorable court did not permit it to happen, my lord. It mentioned that interim order expires today, my lord.
My lord, in this matter, I am for the state of Arunachal, my lord. Only yesterday I received the copy of my lord.
What, writ petition?
Yes, my lord.
Writ petition was served, my lord, upon the my lord. The department had received the writ petition. The department, my lord, did not forward it to its counsel, my lord. The fault cannot be attributable to us.
Yes.
Lord, I have to go through the entire petition.
So I am extending it.
Yes, only I.
File will, you are appearing for all.
Yes, all.
So you will file
no,
affidavit.
2 to 12, my lord.
2 to 2, you file affidavit.
Yes, yes.
You will file affidavit.
Yes, my lord.
The matter is listed in the supplementary list as the interim order is still today. And the yes, yes. The counsel for the petition prays for extension of the interim order. Then counsel appearing for the respond number 2 to
12, my lord.
2 to 12. Submit that only yesterday has received the brief and a praise for time to file affidavit in opposition. Let affidavit in opposition be filed by
4 weeks, my lord.
within 4 weeks. Reply if any there to be filed within 2 weeks thereafter. Full stop. Thereafter. List the matter. 6 weeks no. List the matter on 24th March में देखो time है कुछ 2 PM होगा क्या
28 नवंबर item
24 25 नहीं है ऑलरेडी फिक्स है कब खाली है देखो March 31st March at 2 PM as especially fixed matter. Interim order is extended till 6th of April 2026 or until further order, whichever is
next.
Next.
Lordship, I appear for the petition.
Item.
Lordship, 4 writ petitioners, essentially 3 companies and 1 common director. Lordship, on this last occasion by an order dated 18th of December, had directed us to pay separate court fees for each petitioner, which has been paid and it has been complied with. Lordship, I'll just tell you, Lordship, what the matter is about. I'll
Who is
take your
for the
Lordship.
respondent?
I am for the Union of India.
Yes. All.
I'll just tell you, Lordship, what the
No,
matter.
no. Who is the respondent? Other.
Lordship, there is one more. Essentially, it is the Union of India Ministry, Lordship. And there is respondent number 5, who is the statutory auditor. They have been served.
What is the prayer? What is the prayer?
Lordship, there is an order passed by respondent number 2 under section 140 of the Companies Act. We are seeking quashing of the same only on the ground that principles of natural justice were not maintained, because my written submissions, which was mailed to them, posted to them, there is no whisper of it. There is no consideration of the same, and that has led to giving an order which is not as per the facts. That is my small submission before your Lordship, because as a writ court, I cannot I cannot ask your Lordship to go into the merits, or won't even trouble your Lordship on that.
Yes.
My lord, kindly see the order impute first.
Where? 122.
2 impute order, my lord. One is
116.
116 and
116.
116.
Yes.
120. Difference matter, my lord. Case number RDT 28684. Another, my lord, 286824. Stroke S 148. Stroke 9536. Order passed similarly, my lord. Kindly see the what is the order impugned, my lord. Order page 116.
Use microphone.
116, my lord. Hello.
116, yes.
116 and continuation page 118, my lord.
Yes.
And whereas from the contention of in the application in further submission on the applicant or company during the course of hearing and all of our relevant facts is available on record, it is observed that no documentary evidence regarding proof of submission of board approval final statement for the year 2016-17 to the respondent auditor has been furnished by the applicant company. Hence, it cannot be said that the respondent auditor was in a position to comment the financial statement in the year 2016 and 17. Further, respondent auditor is ready to audit of accounts of the applicant company. Second, it is seen that the last 2 years financial company 15-16 and 14-15 was signed timely by the respondent auditor on 26 August 2016 and 31st August 2015 respectively. In case of non-cooperation of any matter, facts, duty, work with the management not being
audit assignment, the applicant company is free to appoint engage a person of his choice for such matter. Hence, this ground is not tenable in this such case, my lord. The applicant company has failed to produce evidence to substantiate their other allegation made against the respondent auditor to his removal. Hence, that ground cannot be acceptable. There is no wrong in this order, my lord.
Because these written submissions, may I now just place the written?
Where is the written submission?
Lordship kindly takes up.
What is the date of the order? 26th October.
Lordship, I'll tell you. 4th October was the first hearing. Second hearing was on 11th of October. My written submissions, my lords, will just kindly take up page 101. This is where it starts. It has been sent by speed post to them. Lordship will kindly take up page 112. Lordship will see it has been sent by speed post on the 9th of October, which was received to them on 11th of October. Lordship, just prior to that, Lordship's got page 112, page 111. After I came out from the hearing, which was given on 11th October, because they were not taking it on record, I by email have sent them the written submissions, which is page 111, which they have received. Lordship, because I get no reply from them, on page 110, which is the very next day on 12th October, I also write a letter to their superior, which is the secretary. Lordship kindly sees that is the email, page annexure P8, page 110. I also write a email specifically stating, Lordship, if I may, Lordship comes on the 4th line on the email, Lordship, sir, how can RD deny party in matter to submit written submissions on the day of hearing?
Where page?
Lordship, page 112, 110, my lords have got it. This is an email of 12th October 2018. Lordship kindly sees it has been sent to, Lordship will kindly see to the secretary. Lordship, the 5th line from the top on the right, I specifically, Lordship, I'm just reading it of the 2nd line, Lordship. However, RDER Kolkata, Mr. Bandopadhyay, without any reasonable cause, denied to accept the written submissions as attached with the mail in the matter. We already posted this written submissions on 9th October 2018. Sir, how can RD deny party in matter to submit written submissions on the day of hearing? Lordship, my specific cases, the written submissions were not taken into consideration. And I'll show my lords that if my written submission was taken into consideration, then these clauses which have formed the factum of giving the order would not have remained the same. Because my written submission consists.
Where is the written submission?
Lordship kindly takes up page 101. Lordship, it is quite an elaborate written submission. But Lordship will kindly see. I'll show 2-3 documents from the written submissions, Lordship. 2-3 pages on the written submission. Lordship kindly takes page 107, para 31 of the written submission. Lordship will recall, my learned senior friend has read out that they've said that we couldn't found the allegations, loss of confidence. Lordship, para 31, it is to be noted that in violation of section 143, 145 and others are major and primary offences by accused auditor. However, the auditor under various other authorities such as Income Tax Department is also under scanner for misappropriation of funds and other fraudulent acts which forms the secondary offences for adjudication of present matter. In fact, copy of online FIR against the accused auditor is enclosed. So, Lordship, the loss of confidence is such that there have been FIRs against each other. Secondly, Lordship will just kindly take up, this was a part of my written submissions, page 132. Way back in 2017, the auditor had given a letter to us, my lords, page 132, kindly sees. This is a letter given by the auditor to the board. Lordship, got it? Lordship kindly sees the auditor says, this is to inform you that due to our preoccupation and other assignments, we are not in a position to devote our time into the affairs of the company. Accordingly, we are submitting a resignation. My case is after...
No, where you mentioned this letter in your written statement,
Lordship,
written notes of argument.
Lordship, my written notes of argument consists of all these annexures. Lordship, this is what we ought to place. If they would have...
This...
Lordship.
132.
Lordship.
132, which paragraph you are referred to?
Lordship,
in your
it is not expressly written as an annexure.
Then?
But Lordship, 2 grounds. One, they are saying that I have not been able to substantiate that I have that we have lost confidence on the auditor. But Lordship, I have showed you that one paragraph which is expressly stated that FIRs have been filed. I say, my lords, that that is the most prima facie way of showing that I have lost confidence on the auditor. The issue is very simple, my lords. He gave me a letter saying that I want to resign.
Correct.
Now, Lordship, as per section 140 subclause 2 of the Companies Act, Lordship's aware, after that he ought to have placed that letter before the ROC by filing it. Because he's a statutory auditor under 139, it's not my choice to remove him.
Yes.
He does not do so. I sent them letters saying kindly come and visit. In any manner, Lordship, the relations had strained. So I, in order to remove him, have to file an application.
So you could have been forwarded this application to the ROC.
Lordship, that is what we have done, based on which they have given a hearing.
When you forwarded?
Lordship, kindly sees.
When you forwarded this 5th September letter to the ROC.
Lordship, I cannot forward. That is not the procedure.
Not forward.
Lordship, page 72 is where I have, in 2018, I have submitted to the ROC that I want to remove the auditor. That is page 72.
Correct.
And this hearing is on the basis of that. And Lordship, in the order which is impugned before your Lordship, the ROC records or the officer records that the auditor was all along willing to do my job and to do my work. I have this letter to show that way back in 2017 he has refused. And after 7 days of passing the order, he writes a letter to us saying, I don't want to continue anymore.
No, passing the order, which passing?
After passing of the impugned order, by which I was denied to remove the
impugned order is 26th October
2018. After that,
and this letter is of 5th of September.
Yes,
20.
after that again page 149. Page 149. This is on 2nd November 2018. That is after the impugned order.
Yes.
May I just kindly read it out, my lords? Second paragraph. You and your management are also making wrong allegations on us via letter dated 1st September 2017 and letter dated 25th May 2018. You have made an application under section 140 for removal of auditor. You were not produced any evidence corroborating documentary evidence support of your grounds, failed to produce evidence to substantiate your allegations. The regional director rejected your application. Kindly takes the next paragraph, my lords. You have questioned, marked on our integrity, independence and professional ethics without any basis and also could not prove this till date. All these actions are hurting us and now we are not in a position to continue as auditor of our company. So, Lordship, the relationship had
subsequent to the order.
Subsequent to the order.
Correct.
So, Lordship, in the order it is recorded that I'll just show that paragraph which has not been placed, my lords, before the order. Lordship, page 116, my lords was reading. Lordship, page 118, where my lord was, those points are there, my lord has marked. Lordship kindly takes up the first paragraph, the 5th last line from the middle, my lords. The authorized representative of the respondent auditor, submitted that between 14th July 17 to 21st August 17, the company never came to auditor's office and the company never handed over books of account. Shri Bishwal has further stated in the hearing that respondent auditor is ready to do the audit of books of the account of the applicant company. So, Lordship, this was a specific submission made by them. My written submissions which have been there, which contains a lot of documents, none of it taken on record.
So that's why which document one is okay, FIR.
One is the FIR, Lordship, because this FIR will go to show.
What are the other documents the authority has?
Lordship, that resignation letter which I showed, 2007.
You are not mentioning your written notes of argument.
Yes, my
Lordship will just kindly visualize
one thing, my lord.
Visualize one thing. The written notes have been drafted by the practicing secretary and the director who had visited the hearing. It was not by any lawyer and no lawyer was presented during that hearing. Lordship's aware that the drafting, the documents were a part of it, man. Sir. I understand. Lordship will just kindly visualize that. The document was a part of it. Lordship also kindly takes up paragraph in page 118 that my lord has marked what they have observed. Point number 2 and point number 3. I have no qualms, my lords. There is no mischief. First 2 years, relation was good. There was all audit. Point number 3 is not applicable to a statutory auditor because I cannot remove a statutory audit under 139 as per my own whims and fancies. Point number 4, my lords, 4 and 5 kindly reads up together that the 4 is applicant company failed to produce evidence to substantiate the other allegations made against the respondent auditor for his removal. Hence, the ground cannot be acceptable. Next page, it is settled principle that for removal of auditor, the applicant company must prove that it has lost its confidence from the auditor due to some tenable reasons.
Correct.
Now, Lordship, I'll have to place each and every paragraph of the, or two or a few more paragraphs of written submission. Very lengthy written submission. I was showing only the paragraph which shows that the relations have gone so sour that there have been FIRs against each other. So, Lordship, if this was considered, then such an observation would not have reasonably arisen. All I'm saying today, my lords, is let my written submissions be considered and a fresh hearing be given where I can prove my case. The difficulty I'm facing is, my lords, that because of this, we are in default of not being able to conduct our AGMs for those period, which I can be pulled up by the ROC at any point of time. Also, Lordship, there's another observation, but this is slightly going into the merit. Another observation that is there in the impugned order is that we have not produced our books of accounts. Lordship, I have letters which we have posted, which is also a part of us. This is part of my written, of my writ petition also, my lords. Kindly takes up page 47 once. Kindly takes up page 47 once, my lords. All this formed a part of my written submissions, my lords. Kindly takes up page 47 once. Lordship, this is dated 23rd June 2017.
Yes.
Lordship, kindly sees invitation for audit of books of accounts and financial statements for the year ending 31st March 2017. Lordship, kindly takes up the 5th line. The management seeks your expression of opinion on the accounts and statements. Please take due steps for compliance accordingly and intimate us your suitable date and timing for inspecting the accounts. Lordship's aware how and I'll show you, Lordship, how this was sent. Yes, page 50.
It was given
to the statutory auditor, my lords. And Lordship kindly takes page 50. It has been posted to the correct address. I've checked it up. It is the postal receipt. Now, Lordship's aware that
all the things are okay. I appreciate.
Lordship, all this was a part of my written submission.
In your written, okay.
This is in my written submission.
This court cannot appreciate what the argument you have made before the ROC. But it is your specific case that you have made a written submission, but they have not accepted the written
Lordship,
submission.
this is there in the written submission.
Not accepted the written submission. Physically, you have sent through the speed. Correct. So, what are the documents you are relying upon now in the writ application? You show me that you have placed all the documents in your written statement.
Lordship,
Argument. That's matter ends.
Lordship kindly takes up my written submission. Kindly takes up.
Which you are showing either it is prior to that or after to that, and the FIR you have mentioned that I don't know whether the FIR has been there or not.
Lordship, it's written enclosed as annexure so and so.
Maybe
it's all enclosed.
So where is the in the written is I am since beginning telling show me in the written.
Lordship kindly takes up page 104. I understand, my lords. Kindly excuse me on that. Lordship, page 104. Paragraph 12, that non-examination of books of accounts and discharge of responsibility as stipulated in section 143 and 145 of CA2 Companies Act 2013 is deemed refusal on part of auditor to carry on audit, and therefore it amounts to willful negligence and dereliction of duty together with professional misconduct in impugned matter. Further, it is highlighted.
So where is the letter? Where is the letter you have given to the auditor for conducting the?
I showed my lords the letter.
Where is that?
I showed my lords.
That is page
in
page
the
47.
Yes.
Page 47.
Yes.
Now kindly come to the page 104. Where is the letter annexed?
Lordship, that is exactly what I was trying to beseech my lords. Lordship will kindly understand, because it's not a legal writing. They have written the story and they've annexed all the documents with it.
Where is the document? Show me, annex the document.
Lordship, then I'll have to bring the entire documents and I place it before.
Why? You have filed the writ petition.
Absolutely.
You have disclosed it in that. See.
I bow down. I bow down.
Senior persons.
I bow down.
If kindly see what are the document and disclosed, that is mentioned here, annexer D, annexer.
Yes, your lordship.
So how you can say it is enclosed there? If it is enclosed there, there will be a list of annexers in the back page of the
should have been, my lord. Should have been, but only because my lords will just kindly consider Lordship will kindly consider, because it is not drafted by a legal mind, my lords. It is not as if like how we do it every time we talk about a document, we annex it. Every time we refer about a
Paragraph 13, Annexure B enclosed.
Yes, your lordship.
So why not Annexure A enclosed?
A few of them are there. I have gone through the entirety, my lords. A few of them are there and a few of them are not. It all forms a part of the writ petition. Now, lordship, this writ petition, after being filed, I'll take full responsibility. This is a change brief. We are pushing it now. I've taken instruction. These were all part of the documents. All this was a part of the
One thing, my lord,
documents.
they have sent me email on 12th October 2019, my lord.
Where is that?
Page, my lord, 110. My lord, kindly see the upper portion, Friday, October 12, 2018.
Yes.
18.
110, my lords.
My lord,
110.
yes, my lord.
It is a petitioner sent the mail.
Yes, my lord. Kindly see the order impugn on page 116. 116. Order impugn, my lord. And continuation page one, next page 117. Middle portion. My lord, kindly see to the respondent auditor to short time to produce at the time, and thereafter the hearing was adjourned on
Where from you are reading?
last bottom portion, my lord. Kind of 117. Thereafter, hearing was adjourned and fixed on 11th October 2018 at 2 p.m. And on that day, my lord, hearing was concluded.
Yes. Yes, your
How the auditor, how the appellate authority consider that they are written submission?
I placed that email, my lords, on the 12th of October.
12 of the already the order was passed and all hearing concluded.
Lordship has marked where I've stated that during the hearing I was not allowed to submit.
Already conclude hearing.
Before that, the email is there, my lords, on page 99, where I have given it to the authority. I have placed, my lords, the email of 12th of October.
Already hearing conclude.
And in my email, I specifically stated that because they have not taken it.
Kindly, that's right.
Yes.
Kindly come to the page 117.
Yes.
On 117, the matter was fixed on.
Yes. So, my lords, my submission
11th
was
October. 11th October.
Yes.
Correct.
Yes.
Thereafter, so and so appear, authorized appear, so
Yes.
and so, and
Yes.
nothing was.
Yes.
And this email which you're telling that is the 12th of October.
Yes, that was to the higher authority. Page 99, I showed, my lords. Page 97. Page 99. I'm sorry, my lords. Page 99, annexure P7. After the hearing, I sent an email on 11th October at 7 p.m. to the authority. Before that, I sent them by email, by post. The speed post is in page 112, which I've annexed. In speed post, it has been sent on 9th of October. They received it on 11th of October. And I carried the entire files with me, my lords. It's because they did not take it into consideration is why on the 12th I wrote an email to the superior authority.
Yes.
That is why I wrote it to the superior authority on the next day, my lords. And my submission is...
What was the urgency to the RC?
Hearing was fixed on 11th October, and on the same date they are.
You show me from your impugn order, the written notes have been considered.
Not a whisper, my only case.
Show me the impugn order, written notes are considered that,
Already,
that FIR was considered.
hearing already concluded, my lord. After they have sent this editing statement.
Specific case that you are not allowed to file, then they have sent the written notes on by mail. It is a specific case they have made out. He has not accepted the written note. Thereafter, they have sent through the mail.
Well, kindly see the page 118, my lord. Order number 4. The applicant has failed to produce evidence of sustainable.
Correct. So where is the finding with regard to the FIR? Page number. Kindly come to the page 107, paragraph 31. Paragraph 31 with regard to the FIR. Where is the finding on that?
So then I shall take instruction, my lord. Instruction is required.
What discussion?
What happened was done, my lord.
That's why then 12th October 2010 email was sent. What has happened to that email? It could have been recorded in the FIR. He has sent the email.
My lord, kindly allow me, my lord, filing affidavit of opposition. Kindly allow.
What affidavit in opposition? I am setting aside, reminding you, you considered all these documents along with the written notes of arguments and the document subsequent after the order. Then the chartered has filed this letter that he is not ready to continue. This is also to be considered. In the affidavit opposition, what you will improve?
All right, my lord, your lordship.
What you will improve? You tell me there is
No,
a
no,
chance
no.
of improvement, then I
Clear
will.
taking the name of Musman पे other words.
You will say then you
No,
have
no.
a chance. Then.
Your lordship, order, my lord, remind.
Application
Lordship, application.
before the ROC.
Lordship, after the impugn order, we've come before my lords.
Before that.
Before that, my lords.
First
82.
application on
Lordship, page 72, my lords. It's a form number 82 which has to be
Correct.
uploaded.
Correct.
Lordship, this is uploaded. Supporting documents with it, page 76, the board resolution and everything. It has to be uploaded like this in the ROC, my lords.
So there are two orders.
Two orders.
Lordship, like I said, Lordship, three family
orders.
companies, 3 orders.
Some,
All same date, verbatim, my lords.
the petitioners have filed the presented application challenging the order passed by the regional director within bracket ER. ER. Comma, the respondent number.
Respondent number 2 has passed the order, my lords.
The respondent number 2, Eastern region, here located in Eastern region, Ministry of Corporate Affairs, Kolkata. 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 By rejecting the request of the petitioner for removal of its statutory auditor filed by the company under section 140 of the Companies Act on the ground that the application filed by the petitioners does not have any merit. The respondent number 4, respondent number 2 has passed the following order. Page 118. Page 118. The grievance of the petitioner has filed the presented application on the ground that at the time of hearing, the petitioners intend to file their written notes of argument, but the respondent number 2 failed to accept the written notes of argument, and subsequently finding no other alternative, the petitioners have forwarded the written notes of argument through email. But the respondent number 2 has not considered the written notes of argument and the documents disclosed with the said written notes of in the written notes of argument. The specific ground for rejection of the application of the petitioner is that the petitioners have not filed any documentary evidence that the auditor has documentary evidence that has not conducted the statutory audit of the petitioner's company. Now, counsel for the petitioner draw the attention of this court to the written notes of argument at page 107, paragraph 31, wherein it is categorically mentioned that the auditor under various other authorities such as income tax department is also under scanner of for misappropriation of funds and other fraudulent act which forms the secondary offences for adjudication of the present matter. It is also informed that an FIR was also initiated against the auditor, and the FIR was annexed with the set written notes of argument. Full stop. The petitioner has also relied upon the email dated 12th of October 2018, wherein the petitioner has categorically informed the authority that the ROC, without any reasonable cause, denied to accept their written notes of submissions. Full stop. The petitioner has also disclosed the document in the present date application issued by the statutory auditor dated 5th of September 2017, wherein it is mentioned that due to their preoccupation in other assignment, they are not in a position to devote their time to the affairs of the company. Accordingly, they are submitting, and accordingly, the auditors have submitted their resignation as statutory auditors of the company for the financial year 2016-2017 with effect from 5th of September 2017. Counsel for the petitioner further submit that after the order passed by the respondent number 2, the statutory auditor by a letter dated 2nd November 2018 has informed the petitioner that the statutory auditor is resigning from the post of statutory auditor of the petitioner company with immediate effect. Considering the full stop, learned counsel for the respondent submits that the hearing was concluded on 11th of October 2018, and subsequently the petitioner has sent the email, and thus it is not possible for the ROC to consider the said email. Full stop. Learned counsel for the respondents submit that the impugn orders passed by the ROC, passed by the respondent number 2, has given reason that the petitioner failed to prove the allegation against the statutory auditor, and as such, the respondent number 2 has rejected the application filed by the petitioner for removal of the auditor. Consider the submission made by the counsel for the respective parties, peruse the materials on record. This court find that by an email dated 12th October 2018, the petitioner has informed the concerned authority that the respondent number 2 has denied to accept the written statement which the petitioner intend to file at the time of hearing of the case. Full stop. In the written argument, it is the specific case that in the written argument, petitioner has made out a specific averment that the auditor is under various that an FIR has also been initiated against the auditor. Full stop. It is also found from the record in the year 2017, the auditor has informed the petitioner's company that the auditor has resigned from the company as a statutory auditor, from the financial year 2016-2017 with effect from 5th of September 2017. Full stop. Considering the above, this court find that the said full stop. This court also find that in the application submitted in the application filed by the petitioner under form number AD2 dated
Lordship, it's 8th of August 2018.
8th of August 2018,
my lords.
2018. It is categorically mentioned that in what comma auditor refused to audit. Auditor refused to do audit. Refused to do audit. But full stop. Considering the above, this court find that there are several materials were on record, but the respondent number 2 has not considered the same. And even after the impugn order, the auditors have submitted a resignation to the petitioner's company to act as a statutory auditor of the company. Considering full stop. In view of the above, the impugn orders dated 6th of October 2018 passed by the respondent number 2 is set aside and passed, and the matter is remanded back to the respondent number 2 to consider afresh by taking into consideration all the documents, including the written notes of argument and the subsequent letters submitted by the statutory auditor dated 2/11/2018, wherein the statutory auditor has informed the petitioner that they have resigned from the company as a statutory auditor. Full stop. The respondent number 2 is directed to give an opportunity of hearing to the petitioners and the connected parties for hearing and to dispose of and to pass reason and speaking order within a period of 8 weeks.
8 weeks.
8 weeks from the date of receipt of this order.
So great.
WPS disposal.
I'm deeply obliged.
Next.
One thing, my lord, if they are not appeared on that day, hearing date, the matter will be passed and expiry. Kindly one letter.
Extra record करेंगे. It is made clear that if the petitioners fail to appear before the auditor, respondent number 2 at the time of hearing, the auditor is free to take appropriate decision in the absence of the petition.
I'm deeply obliged.
Next.
Worship, I am appearing for the state respondent. My lord, in item number 34, I am appearing for the private respondent number from 7 to 10, led by Mr. Kaustubh Bagchi. My lord, he was there in the courtroom.
Who is the petitioner? Yes, what is the prayer?
My lord, before the petitioner starts, my lord, I was just seeking on behalf of Mr. Bagchi, since there is a medical emergency at his house, he had to leave, my lord.
Only one.
Matter could be taken
Nothing
up
to
from
do with
our-
the matter, my lord. I have heard your lordship, assisted your lordship. This is a senior citizen matter. My lord, may I just put in the affidavit?
Lordship preferred under 226 as
Preferred
well.
under
226.
226 and 227. But I can satisfy your lordship that this petition is only for a violation of the principles of natural justice. That's a very limited question that
227 also decide that.
Can decide that.
Principle of natural justice.
Principles of
It's
natural
not that the principle of natural justice with not in the 227.
No, I am not beseeching, my lord. Since
What you want?
But my lord, whatever your lordship is, my lord.
Withdraw file. I will give leave, but
my lord, the difficulty will be, my lord, I have taken leave and filed this matter. I'll tell you, lordship, why I am seeking this. The order is to cancel the order has been passed by the appellate authority cancelling the gift date. And if that is executed, but that is the only reason I was praying for a conversion.
show the law. Show the law.
But it can
Only,
be
only one indulgence, lordship. Only difference in this particular case would be that when this matter was taken before the appellate authority, they chose not to be present before the
No,
appellate
no, no,
authority.
no, no, no. That's not,
There is even in their submission also.
I have, if that they get into the matter, my lord, I can show 2 documents and I will.
Who are you? Your son?
I am the son. My lord, I can get into the merits.
Who has filed the appeal?
The appeal was filed by the senior citizen.
My lord, an elaborate order by the SDO saying that not to transfer the property, Appeal preferred against that order. Second day, I filed an adjournment petition.
Okay. You think what you do?
My lord, conversion would have been, I'll tell you, lordship, same court.
Even conversion also, this court will not, then it will be difficult. 227 not jurisdiction
No
before the court.
jurisdiction, my lord, it
Then-
will go back, but if your lordship directs, my lord, I don't want the petition to go off the record. Why I'll tell you, lordship.
No, what I say, I will allow you, you file the 227, will not prevent you to file.
My lord, lordship will kindly keep it pending. I'll let me file the 227. I'll come and withdraw it. Well, at least this much I can.
As per the prayer made by the counsel for the petition, case is adjourned. Let the matter appear on 9th of February 2026.
As a judgment, if your lordship want a copy.
Affidavit of service be kept in the
As a judgment. That judgment, my lord.
Okay. Thank you.
Circuit bench at
Next.
Obliged.
Lordship, item 35, I appear for the petition. Lordship, a
My
10
Lord, in this matter, I am from the Union of India.
Challenge
Response number
on-
1 to 3 in this matter.
Lordship challenged on 2 counts. Before I show your Lordship. 1, I am a bidder. Technical bid accepted. Financial bid accepted. I am L3. Then I receive a letter after 4 days saying that I am not, my bid would not be considered because of an issue with the EMD. And EMD, the earnest money deposit. And secondly, my lord, the second count is that the L1 who has been chosen, who's respondent number 4 herein, he could not have been allowed because he's submitting submitting documents and products based on stuff which do not have certificates by the RDSO. There are 2 counts. First, my lords, let me just, my lord, show my lords the rejection. Lordship kindly will take up. The petitioner, is an MSc, my lords.
If you are in the L3, so what right you will
I'll
have?
say that, Lordship, this is a split tender. Split tender, Lordship, as per the GCC, L1 and L2 both will have the right to give the supplies. So, Lordship, L1 is also I'm challenging. And L2, in the event L2 doesn't, then it comes to L3. L1 also have challenged saying that over here there's a supply of cameras, video surveillance system. The make brand of the video surveillance system which L1 is seeking to supply, that has been categorically rejected by the RDSO. So that could not have been allowed. In that situation, if that count goes through, my lords, then that situation I would become L2.
L2 has been rejected.
L1.
L1 is rejected.
If L1 gets rejected, Lordship, I'm led by Mr.
Lord, this is sharing. Depending on, my lord, the difference in the price, whether you get 45% or 40%, 60, 55 or 60, and L2 gets the rest. A shocking state of affairs.
Where is?
My lord, I am an MSME. I'm a registered MSME. Kindly, my lord, see the certificate at page 26.
Not difficulty. What is the challenge? Where is the challenge? L3.
Challenge,
Where
my
is the-
lord,
where
I
is-
am technical evaluation done. I am accepted. Financial evaluation done. I am declared L3. At this point of time, I discovered 2 things. I discovered that L1 is, my lord, a person who is supplying as a dealer of somebody else. And RDSO has rejected his principle. Rejected. So L1 can't be accepted.
L1 will be out.
Will be out. So I go to railways and tell them that how can you make him L1? Railways, my lord, write a letter to RDSO asking, is it correct? I don't have a copy of the letter. My clients have seen the letter. RDSO replies saying, yes, I've rejected him. Then, my lord, as a vendetta, they reject me.
Why?
On the ground that you did not submit your earnest money deposit. Though I'm an MSME, earnest money deposit was not required to be submitted. Some loophole somewhere they'll try to figure out. No, I'll just take 2 minutes on the tender conditions. My lord, first is, my lord, 26. Lordship would see, my lord, major activity. Third, my lord, fourth on the left.
MSME.
MSME, major activity, manufacture. My lord, this is a printout. The manufacturing is in yellow. So, my lord, it doesn't reflect on the scanned copies. Now, my lord, tender is at page 30. Page 31, Clause 4, eligibility conditions. Last, my lord, at 32 is capital E. This is for the purpose of, my lord, setting up cameras inside railway, my lord, compartments.
Where?
My lord, 31,
Ah.
4, 1, my lord, lordship has seen 4, my lord. Under that, A or B or C or D or E. E, my lord, is at page 32. I come under E.
34.
32. Page 32. I come under E. System integrator who shall submit tender specific authorization for camera software, etc. So, my lord, long and short of it, I have to fix, my lord, 4 camera system with 4 cameras, and, my lord, the software connection, the mobile network connection, so that they, my lord, synchronize and run together. Long and short of it. So, my lord, I buy, assemble. Assembly is termed as manufacture. So, I'm a manufacturer. They also accept this. My lord, please come to page 35 now.
Yes.
My lord, 35, lordship will see middle of the page, other conditions.
Yes.
Below other conditions, number 3. Earnest money security was applicable. Then number E, number 3, tenderer who is participating as authorized dealer trader.
Where from you are reading? Page 35 is other conditions.
Yes, other conditions. Number 3.
Number 3, the earnest money.
Earnest money, and then my lord, see 3 in 3.
Tender who is participating.
Yes, as authorized dealer trader and meeting eligibility criteria will not be eligible for MSME benefit. MSME benefit is you don't have to give
Tenderer who is
earnest money
participating
deposit.
dealer meeting eligibility criteria. E.
So MSME benefit you can't get if you're a dealer.
Yes.
Now my lord, see page 50. .31
Exemption.
exemption, and A is firms registered with MSME. So MSMEs will get that benefit.
What is the status of this particular case?
Yes.
Now it refers to 3B. Previous page, my lord, has 3B. There's nothing there.
What is the 3B?
My lord,
Yes.
previous page, my lord, page 49.
MSME is
Interested to availing must give certificate. So certificate is a must. I've shown the certificate, I uploaded it.
Yes.
Now, my lord, I applied. Please come to page 107.
Yes.
At, my lord, page 115. This is, my lord, techno evaluation result.
This is your form. This is your tender.
No, my lord, this is for all. For all the bidders. This is the techno commercial tabulation. Page 115. Lordship will see bidders remark MSME Udyog enclosed. Against, my lord, at page 115, number 3. 115, number 3.
Earnest money
And security was applicable.
Para 5 and 6 of the GCC.
And then, my lord, see Panorama Electronics. That's, my lord, number 5. MSME Udyog, third column, MSME Udyog enclosed. And document attached.
Where you are?
My lord, 115, my lord.
115. Acha,
3.
Panorama Electronics.
My lord, the paragraph 3, which is essentially the second box. 3, my lord, on the middle of the page. My lord, towards the middle of the page. 3.
Panorama.
Yes, Panorama. Then to the right, my lord, MSME,
Udyog.
MSC Udyog enclosed.
Correct.
Bidders remark. Then on the further right, my lord, Udyam certificate.
Yes.
Now, my lord, this is, my lord, technical bit. Now, my lord, please see page 120.
Yes.
This is, my lord, make brand. Middle of the page, my lord, make brand.
Yes.
There, my lord, your lordship would find, my lord, in the first box, the second last, my lord, entry is Rail Vikas Nigam Limited, RVNL, New Delhi.
Yes.
Who's the L1? RVNL. And the make brand is A. Paul and Matrix Comsec.
Where is that?
My lord, on the right, Rail Vikas Nigam Limited.
Rail Vikas Nigam Limited, Delhi.
On the right,
Uh,
Millard make under Millard on the right hand column is A. Paul and Matrix Comsec.
correct. Make brand.
That's Millard, the brand which they'll supply.
Correct.
So Millard Matrix Comsec, I've said so in the writ petition, has been Millard rejected by RDSO.
This Paul and
Millard Matrix Comsec.
this has been rejected. Where is that?
Millard paragraph 10.
Okay. So how you can the L1, how you can say that the L1 and L3, where from you got it?
Yes, financial bid. I'll just show that. Technical bid is approved, Millard, 124. This is written to me.
Your panorama.
Yes.
24.
Now here, surprisingly, your lordship would see, they write that I am a non-MSc class 1 local supplier.
Correct.
But I've supplied as MSc. Why are you saying non-MSc? But then they proceed.
What is written here?
I'm sorry, Millard?
Installation of commission IP surveillance so and so so and so.
Yes.
Qualified or financial
Approved.
bid, the above.
Remarks qualified for opening of financial bid as non-MSc. I don't know why they've called me on non-MSc. Whatever it is, but I am approved. Then, my lord, financial bid is page 126. Panel, my lord, number 1 is RVNL, New Delhi.
Yes.
2, my lord, is Bharat Electronics Limited. And 3 is, my lord, Panorama.
So you quoted.
So I'm L3.
L3.
So when this happens, my lord, 13th of January 26. Now, my lord, when this happens, I go and tell them that, look, RVNL can't supply because they are taking it from a person whose product has been rejected. They can't possibly supply. Backlash is 129.
128.
128.
It is intimated that your office cannot be considered.
Yes.
Non-submission of EMD.
EMD. Then why did you consider my financial bid? Why did you consider my technical bid? Why did you make me L3? Now, my lord, this is on the periphery. On a larger question, my lord, I researched on this.
Yes.
My lord, the MSME Act says that, my lord, you can, under the provisions of the MSME Act, you have the purchase procurement policy. Not, public procurement policy. That's under the Act. Public procurement policy, my lord, lays down that the benefit to be given to MSCs for the purpose of developing their business is they don't have to give EMD. Now, they are not being arbitrary for the first time in their lives, and nor are they the first people to be arbitrary. Regularly in India, my lord, people make a differentiation between MSCs. Courts have said you cannot differentiate. If you are an MSc, no EMD required. And public procurement policy has the force of law. This, my lord, so my lord, this argument that you should have submitted EMD, my lord, because you are X, Y, Z, that, my lord, is totally wrong. Second time in MSc, I don't have to, my lord, give. And now, my lord, see the tender condition on EMD. Page 49.
Yes.
My lord, 49.
That's 3B.
Benefit, clause 3.
3B.
B.
3B.
Yes.
Because that 3B is discounted 5.2.
Yes.
5.2.
Yes, yeah, I showed this. I'm sorry.
And 5.2 that has been taken into consideration.
Yes.
115. You have submitted the certificate.
Absolutely.
So let the yes. Why?
My lord, may I just, my lord, rejection. I quoted. My lord, please don't take note of it, but just read it once for the purpose of giving some credibility to my submission regarding L1. They have to, my lord, produce this. This is, my lord, RDSO writing to them on their query saying that Matrix Comsec cameras have been rejected. Cannot be treated as valid for technical compliance.
Yes.
No, I don't have a copy. This is the perversity. Milord, I am humbly praying, kindly, Milord, ask them, Milord, most important relief for me is that they should file an affidavit indicating that whether the two questions, L1, and they should disclose all documents.
Yes, sir.
My lord, should kindly come to page 50. Again, yes.
15.
Of the petition.
50. My lord, 50.
5.3.
50.
50.
50. 50. Clause 531.
Yes.
What is the status of the petitioner hearing? However, EMD is not exempted. The tender participating in the tender to a trader dealer. Lordship, kindly see.
Exemption for submission of the earnest money. Category tender need not to deposit.
Trader dealer.
Dealer.
MSME.
What are you giving? Please give me a copy. What did you hand up? No problem. No problem. ঠিক আছে, আমি নিয়ে নেবো।
দেখি আমার দেখি আমাদের কপিটা
এই থাকে, otherwise it's fine.
না আমাদের কাছে আমার কাছে কপি নেই।
Doesn't matter.
আমাদের কপিটা কোথায় গেল?
Yes.
Yes. He is an authorized dealer on behalf of Aditya Infotech Limited. Aditya Infotech Limited, he has no right to bid before the railway authority. These Taranaba Electronics Limited taking the goods and assemble it and deploy and give it to the railway authority. So it's an authorized person. Therefore, Lordship, can you see that?
No,
Last paragraph.
Where is the tender condition? Who can apply for?
MSME is not the question of fact. MSME has. He has the right.
No. You are telling, see, normally what has happened, if a tender is floated, A is the firm, supply of electrical goods.
Yes.
And you are asking that electrical goods, Crompton, Philips or Bajaj.
Yes.
The person cannot having the dealer.
Not a manufacturing. MSME is the manufacturing unit. He is not a manufacturing in this particular case.
That's why
That's why the letter specifically stated.
In the tender, where is the notice inviting tender? Where is the notice inviting tender? What you ask for?
The Aditya Infotech Limited specifically stated, we CP this subject PSC for supply, installation, and commissioning of IP-based video surveillance and this is LHB coaches. We CP brand Aditya Infotech Limited established and reputed manufacturer of Canada. And these are
from
the
your reading.
Just copy.
This one.
This one.
That's correct. Authorized so and so to represent.
He's not manufacturing the goods. He has taken the goods and bidding it on behalf of Aditya Birla and assemble it and supply before the regular authority. So therefore, EMD is necessary to pay that. In that case, EMD should be paid.
Because he's authorized.
MSME is not the question. MSME has the right. He is
Where is your tender?
General condition is there.
Sir, what you call for?
35 আসতে বলুন the earnest money
35.
New deposit are applicable para 6 and para 5 and 6 of
Lastly, kindly come to page 35 of the petition.
other condition.
See,
Other condition. See.
Other conditions. Lastly, kindly got it. Other condition.
3-1.
35, 3-1. Roman 1.
Yes.
Earnest money and security deposit are applicable as per para 5 and 6 of GCC attached with the tender. And this tender. Tenderer to read these clauses carefully which have been amended recently.
Para 49 আসতে বলুন. Para 5.
Kindly come to again para 49 thereafter. Para 49.
Earnest money.
Earnest money deposit EMD 5.0.
এইখানে exemption আসতে বলুন. 5.3.
Yes.
5.0 earnest money EMD that 531. 531.
Got it. Yes. The tender who is participating as an authorized dealer, trader, or meeting eligibility criteria as mentioned in clause E of the condition eligible tender not be available of the MSME benefit. That is your submission.
2 and 3.
That is your submission.
That is
because authorized dealer, trader, and meeting eligibility criteria are not entitled to not eligible for the MSME benefit.
Which one you are reading that?
If you 35,
35.
other condition 3-3.
35.
3-3, what I had shown.
Yes.
35. Sir. What about that?
3-3.
Yes. 3. Other condition 3. And is tenderer who is participating as authorized dealer and trader and meeting eligibility criteria as mentioned in clause E. Candidate, the condition of eligibility of tenderer will not be eligible for MSME benefit.
Yes. May I answer? Totally, my lord, with respect to my learned friend, his client
Now-
haven't, my lord, given him the instruction. This is, my lord, a CCTV system. I'll buy the camera from, my lord, Max Plus or One Max. That's given here also. Wire I'll buy from somewhere else. And full system in the carriage I am doing, and I'm integrating the system on, my lord, or software. So, my lord, there are, my lord, various things which I buy. And then, my lord, I assemble, integrate, and, my lord, set it up. So, my lord, this, my lord, assembly is, in the world of MSME, a manufacturer. It's not, and I haven't applied as a dealer. I'm a manufacturer.
No, that's why I want to see what is the tender notice. Where is the tender notice?
My lord, tender notice, your lordship will see that, my lord, at page 30.
Is authorized, tender specific authorization for manufacturers.
Tender notice. Where is
Please
the
come
tender
to page 30. Tender notice. And, my lord, please come to,
Inward C
E.
tender, closing dates.
my lord, please come to E. System integrator. My lord, please come to page 32. I am eligible under E.
System integrator.
System integrator who shall submit tender specific authorization for camera software of MNVR, mobile network video recorder, and MNVR from OEMs of camera software of MNVR, and MNVR tenderer has to submit an approval of camera and software from OEM who possess STQC approval on or before tender opening date.
OEM means, my lord, original equipment manufacturer.
Now,
Original equipment manufacturer.
correct. Now, my lord, I'll tell you,
Lord.
lordship,
Original equipment manufacturer.
Lord, everybody
Is not his
everybody has to buy from somebody. Nobody, neither RVNL nor I manufacture cameras. So we'll have to buy from somewhere and integrate. Yes. Milord, I have to buy wire from somebody. I'll have to buy camera from somebody. I'll have to buy, Milord, the recorder. Everything. Now, Milord, please see again. System integrator who shall submit tender specific authorization for camera software. So I have to get a authorization from the for the camera software from the original equipment manufacturer. And I am a system integrator. I assemble and integrate the system. This system is not available on the market. I have to buy components.
So you are the system integrator?
I am the system integrator. Yes, Milord, please now see. Your lordship would see the a whole lot. I asked you page 120, na 120. See, my lord. Everybody buys from a company, the OEM. Milord, RVNL buys from Poland Matrix, and I buy from CP Plus. Kindly see Panorama Electronics Private Limited, CP Plus. So, Milord, I give the authorization from CP Plus, and then I integrate the system, which is why I am a manufacturer, and that is on my certificate. Milord, if your lordship kindly see the certificate at which I handed up, it's also there at page 26. I am a manufacturer. And now, Milord, judgment of the manufacturer. Milord, this issue has been decided, Milord, by your lordships. Milord, please see paragraph 4 in a different context, but please see this. The tribunal relying on decision, affirmed decision of Commissioner of Appeals, second page. Both the statutory appellate fora thus came to the conclusion that the assessee's units at the aforesaid two places were involved in manufacturing activity. Revenue stand was that the assessee was only involved in assembling activities at these units. The tribunal found that assembling of different products which are giving rise to a new product and which has become a new name in the market and function will be regarded as manufacturing activity. And on this logic, Milord, I am, Milord, termed as a manufacturer because I buy cameras. I'll show you, lordship, Milord, the Kerala judgment also, Milord. 2020 SCC Online Kerala 12075. Paragraphs 6, 14 and 15. No, sir. Milord, 6 is the issue. Milord, this is not the first time this issue is raised. But Shri Ramanan Learned Counsel for the petitioner, etc., as the main arguments advanced, Milord, fourth line at page 6, were on the eligibility of the fourth respondent for exemption from payment of earnest money deposit and tender form fee. It is necessary to examine the relevant provisions in the MSME Act. Exemptions are provided in accordance with the procurement preference policy of the Government of India. Section 11 of the MSME Act, which provides for procurement policy, Milord, quoted. Now, Milord, 11 is the policy. Then below paragraph 7, the definition of supplier given in section 2N, below supplier is quoted. Then buyer, below please see paragraph 9, bottom of the page below, goods. Now, my lord, please come to paragraph 14. This is very important. The next question which is relevant to be considered is whether exemption is available for services other than with respect to the items manufactured by the MSME concerned. Lord, may I stop here for a moment? This system cannot be manufactured in its entirety by one person. Somebody will manufacture camera, somebody will manufacture wire. When I put it together and create a system, that's below the manufacture. Assembly is the manufacture. The corporation should, in the fourth response, having Udyog Aadhar registration, corporation should ensure technical financial capability of MSME supply goods by carrying out due diligence. In the light of the aforesaid provisions in the store purchase manual and the government orders, when it is decided to grant exemptions to all MSCs having Udyog Aadhar registration, there cannot be any doubt as to the eligibility or entitlement of the fourth respondent for exemption from EMD and tender form. The next question which is relevant is whether exemption is available for services other than with respect to items manufactured by MSME concerned. In this context, it is relevant to note the office memorandum issued by the Government of India, by which a clarification is issued on definition of goods and service under procurement policy. The office is in, now I read the MSME order. The office is in a number of clarifications being sought by procuring agencies relating to providing of benefits under definition of goods and services. The matter was placed before review committee, which was held on 12 July 16, chaired by Secretary MSME. It was decided by the committee that the definition of goods and services provided in the such and such may be accepted. Goods, my lord, is defined, service, my lord, is defined, but my lord,
Yes.
Now, my lord, please read on 15.
How much time will take?
2 minutes. My lord, let me just show your lordship the sentence. My lord, please look at paragraph 15 at the top. Objection raised by the petitioner is that since the fourth respondent is not manufacturing the goods covered by the tender, it is not entitled to exemption. My lord, please omit 3 lines. This is more clear when section 11, my lord, definition of goods and service separate. And then, my lord, 5th last line. Moreover, when the government of India has already clarified as per its order dated such and such, defining that the term goods and services separately, and exhibit R4C order of government which is in tune with PP policy, there cannot be any scope for any doubt for eligibility. Now, my lord, there are other judgments also. I'll cite them at final hearing. In this matter, my lord, other matters become, your lordship disposes it off. We have no difficulty. But this is a matter where, my lord, railways has to come, should, my lord, be called upon to file an affidavit indicating whether L1 is disqualified or not. Number 2, whether, second important thing, they can't write roughshod over it. They have to say on affidavit whether I am a manufacturer or not. They have to take a stand whether assembly is manufactured. Because they cannot, my lord, take the stand that assembly is not manufacturer. The assembler is not manufacturer. Otherwise, there will not be a single manufacturer. Number 3, they will have to take the stand whether I participate as a dealer or not. Nothing has been shown to your lordship that I participated as a dealer. I have not participated as a dealer. I have participated as a manufacturer, which my certificate says I am.
Okay.
Let them, my lord, file an affidavit.
How this document has come to them? This document you are not disclosed in your application, in the tender document.
My lord, I don't have it. My lord, please let me see.
Lord.
I asked my learned friend, he doesn't have it.
Whether this document you relied in your tender document.
My lord.
Yes, I
see.
That's right.
This document you relied in the tender.
Yes. My lord, please just take page 121. This is not correct. This is not fair. My lord, just take page 120. My lord, please see. Make brand. This is make brand. My lord, first name, Fleetmatics Private Limited. They buy from CP Plus. That doesn't make them as a dealer of CP Plus. My lord, please see the certificate document once more. May I just see it? It will not say dealer.
No, not dealer. That's why.
Yes. So everybody buys from somewhere. Now, my lord,
Authorized.
my
That's
lord,
why
just one more thing. Clause 3.1 of the tender. My lord, E, where be eligibility? System integrator who shall submit tender specific authorization for camera software from OEM of camera. This is that.
As per 333E.
Yes.
As per 4E.
Yes.
4E, you should be only a system integrator.
My lord, system integrator. I am a system integrator.
The tenderer should be system integrator.
Right.
Who shall submit tender the specific authorization of the camera. So he can have a authorization for purchasing of the camera
from somebody.
For somebody.
That doesn't make me dealer.
Software or MR so and so. And tenderer has to submit the STOCC approval of the camera.
That's what your lordship has. Now, my lord, what does he say? Rejection is on the ground that I am a dealer.
You don't deposit that.
Okay.
They want a single document to show that. This is the unfairness.
Okay.
And that's why, my lord, one copy in court and I don't have a copy.
Lordship kindly is in that. They enter in the.
Okay, how much time will take? It will take time.
Only 5 minutes, my lord.
5 minutes because my original side matter is.
Kindly give me.
Otherwise, may I suggest this? May I suggest this?
Everything.
No, no.
I'm not.
No. May I suggest this? My lord, please ask them. My lord, heavens will not fall. And my lord, this is, my lord, we are selling.
What is the status of the tender process now?
My lord, let them file an affidavit. No work order has been issued.
Enter a bid, MSME, he has a MSME category, and they do not deposit the EMD. That is why MSME category is small, EMD not paid. And in technical bid, they an authorization letter, that is letter given by some of the authority council. Now, she kindly come to page 130 and step P9. And step P9, paragraph 3.
Page 130.
Paragraph 130 and step P9.
Last para.
Last paramelo.
130. Yes.
130.
Yes.
Without prejudice to my rights and contention, we are willing to deposit the EMD amount.
This is after rejection.
Merely as a safeguard my participation in the instant tender process. Admitted.
What is wrong in this? What? No.
Without prejudice. Without prejudice.
Yes, he agreed to pay
read
the
the first two.
Without prejudice.
Because he's failed this as a situation. He wants to admit this position.
Now the court has to see whether the EMD is liable to pay in terms of the. Yeah, have you got this Kerala judgment?
Yes.
Have you got?
We have given copy.
You considered it. Come tomorrow.
And Milord, may I request Milord, please give them.
Yes.
Personal difficulty.
So then you will complete the tender process. Then what will happen?
Yes.
What is the status of the tender? It is not.
No work order issued.
No
final one. No, not to issue. Can I pass an order or you give the assurance? I will record here. And you tell when you will be back and a specific instruction also with regard to the L1 whether the RDSO has cancelled the their certificate or not. And you consider the Kerala High Court judgment.
And then let them file a short affidavit in 3 days.
Reply. 2 things you have to give the reply. Because if 3.3, he could only be synergy integrator, system integrated. System integrator.
Yes.
So it is not your case, he is not a system integrator. Your case is that he has purchased, he has been authorized to purchase or use that camera from the Aditya Enterprises. Whatever.
Yes.
Whether. So because if a person is having the manufacturing company, so it is not necessary all the things is to be, even you go to the car also, you go to the Tata car or Maruti car.
Yes.
They are not making all the parts in your factory, in their factory itself. They are purchasing from the local market and putting the brand of the Maruti and sending it to the market by Maruti or the Tata or
This is the exact example my client gave me when he was explaining to me
Right, absolutely
that
correct.
nobody manufactures everything.
You have not remember, you have filed the you have argued the case before me in the original side.
This one.
Not this one, this manufacturing.
He's a,
I have forgotten.
he's covered under the MSME. So why did you file for the EMD?
Yes.
EMD. That's the honest money deposit. Should we take that?
No, that's
MSME, if you are saying that, it's the MSME category is for that because he has taken the some
Okay. You take instruction from the authority and consider the Kerala judgment also and consider 3.3e, 4.3e and come on the when you will come, but make sure not to take any further action. Otherwise, I have to pass an order. Because the point is to be decided. If tomorrow the court is held that yes, it is not required, then he will be in difficulty, you will be in difficulties. And with regard to if the L1 is RDSO has not certified the certificate, so naturally he will come as a L2.
Then I become L2. I get 35,
If it is
40%.
become L2, as per your procedure, he is entitled to be considered.
Yes.
So see that also. What can be done? Can I pass an order for interim order, or you stay your hand for the when you're able to come?
Present position. তাহলে মঙ্গলবার তো তাহলে টাইম নেই মঙ্গলবার পর্যন্ত
Lordship, kindly allow me to file affidavit in opposition, reply, and
But with regard to the if you continue with the tender process, what will happen?
টেন্ডার প্রসেস আমরা করবো না এটা আমরা
tender process is continuing, my lord.
That's why you continue affidavit filed tomorrow because the matter is on merit. That's why.
Let them not conclude.
Conclude.
You proceed, but don't conclude.
Right now. Not at finalize that now.
Huh?
Not finalize at present.
That's why not to finalize.
Yes.
Not to finalize. How soon you will file affidavit?
Seven days time now.
How soon you will file?
7 days, my lord.
7 days.
My lord, 1 day for me, my lord, to respond.
The petitioner has filed the presented application challenging the communication dated 16th October 16 January 2026, wherein it was informed to the petitioner that the tender submitted by the petitioner has not been considered as the petitioner has not submitted, not deposited the earnest money deposit. The contents, the petitioner is a MSME, and as per clause,
এখানে আলোচনা দিচ্ছে না এটা কি আমি সুইসাইড কিন্তু দাঁড়িয়ে
packet B of the tender document, MSME who are interested in availing themselves of this benefit will include with their offer a copy of the Buddham registration certificate only. The list of MSME benefit will not be admissible based on any other document. Clause 5.3 of the tender document mention that mention that MSME mention that the firm registered with MSME is not required to deposit earnest money. The petitioner has participated in the said tender as MSME, and on opening of the technical bid, as well as the financial bid, it was found that the petitioner is L3. But subsequently, the respondent has communicated the letter dated 16 January 2026, rejecting the tender of the petitioner on the ground that the petitioner has not submitted EMD, unless money deposit. As per the petitioner has relied upon clause 4 within capital E, and submit that as per this tender document, system integrated who shall submit tender specific authorization for camera, software of MNVR and MNVR from OEMS of camera, software of MNVR and MNVR. Tender has to submit SOC approval of camera and software of MNVR from OEM who possess STOC approval on or before the tender opening date. Full stop. Counsel for the petition submitted. The petition has submitted all the documents, and the authorities have the respondents have considered the tender document, but subsequently the authorities have cancelled and rejected the tender on the ground of not submitted EMD. Though as per the tender document, petitioner being the MSME is not required to file the EMD. Learned counsel appearing for the respondents has handed over a letter dated 24th of September 2025 issued by Aditya Infotech Limited, wherein it has been informed that the said firm has authorized the petitioner company to represent them to bid, negotiate and conclude the contract on their behalf. The London Council appearing for the respondent submitted from the said communication, it is proved that the petitioner is the authorized agent of Aditya Infotech and not a manufacturer, and thus he is entitled to get he is liable to pay the EMD in terms of the contract of. Consider the submission made by the counsel for the respective parties. This could find that the matter is to be decided on sought affidavits. Accordingly, Learned Counsel for the respondent pays for a week time to file affidavit. Let affidavit be filed by 6th February.
Which one?
By 6th February, affidavit.
5th February.
6 next
6th
Friday.
February. Yes.
By 6th February, reply be filed by 10th February. List the matter on 12th of February under the heading urgent motion at the top. Urgent motion at the top.
My lord, which date you fixed this matter? Which date?
12th.
12, that's some difficult, my lord. 12 and 13. 11, okay.
11 at top. Police. In the meantime, the respondents are restrained from taking further action in the tender process. Grateful, man. Grateful.
But I also have colored extension for entry model. So in the matter of 38, I appeared as an applicant of CAM 3.
You are appearing for 38.
My lord, 38, my lord, my learned friend has completed his argument yesterday. It was for us, my lord. I am the applicant in CAN 1. He is for the council. We are supposed to make our
matter.
Yes, my lord.
4 has requested if the matter can be taken up tomorrow at 12, my lord, because
if the time may be fixed, your lordship.
Time can't be.
But my lord, otherwise,
that is fixed till April 1st week.
No, my lord.
With regard to the time.
No. My lord, it was fixed, my lord. Yesterday at 2 p.m. only.
But can we see how?
My lord, kindly appreciate, my lord, the whole function of the council.
I appreciate. I am ready to discuss the matter. But give the time.
My lord, any time, my lord, any time. Tomorrow, any time.
ये कल के कल कितना है अर्जेंट मोशन में हमारा डायरी ये तो छोड़ दो कल कितना है कोई टॉप अप दिया पूरा है अर्जेंट मोशन
My lord, today your lordship directed the matter to appear under the first 5 matters of the urgent motion. It appeared, but also, my lord, could not be reached. Any time, your lordship, any time.
टॉप में नहीं टॉप में कुछ नहीं
My lord, if not tomorrow, then on Monday, any time.
Record and order. Item number 38.
38 and 39.
38
My lord, may I please mention item number 30 and 31, my lord, fixed at
Just
3.
a minute. Counsel for the petitioner submit that the interim order is till today and paid for extension of interim order. It is fine from the record. The matter was heard at length and the respondents have to give reply. In view of the above, let the matter appear on 4th February 2026 within 5 matters under the heading urgent motion. Interim order is extended till 6th of February 2026 or until further order which you are.
Lordship, 3rd, my lord. On 3rd, my lord. 3rd February, my lord.
Why?
Lord, 4th, there is some difficulty.
Then 6th. 6th February, interim order is extended till 10th February 2026 or until.
My lord, only my lord, one thing, my lord, if a time may be fixed, my lord, on 6th. Today also it was, my lord, within 5.
Lordship, yesterday I appeared, Lordship, on behalf of the applicant of CAN 3 of 2026. My name must record it.
Give the name.
No, yesterday it is missing.
the name.
Yes, definitely.
Yes. Huh? Suit. It original side. No, original side not yet.
Wait a lordship, please.
31 mentioning virtually.
My lord, yes, my lord. My lord, this is item number 30 and 31 listed at item 30 and 31 in the appellate side list, my lord. Fixed.
It's appellate side.
It
is not appellate side.
Wait a lordship.
My lord, these were matters which were heard on the 27th.
Wait a lordship, please. May I be permitted?
Original side. Okay.
Appellate side, item number 40 for extension of interim order, your lordship.
You were sleeping by that time?
No, I was, yes. But
Where is
item number 40.
Where is
Take up the matter today, man. Your lordship can take up any day, man. And not
electricity, how is
40.
electricity before this court, how?
Taking up rate from 2020 irrespective of in classification.
The electricity matter.
Yes.
Challenge to a notification.
Yes.
Lord, I am not a party to this writ petition, but we have a similar challenge. Well, I think it's a residuary matter, that's why it's
residuary matter.
I have a similar challenge to a notification. We are in the process of filing arbitration. I think
it is not in the list.
Yes. It's in the list. Item number 40.
Item number 40.
ESG is appearing, my lord. I'm also appearing in the matter. I have been discussed. Your lordship take up the matter on Monday, my lord. Your lordship will consider.
There is a fresh application also for intervention which we have moved.
But due to procedure.
Scan 3 of 26.
No, counsel for the petitioner prays for extension of interim order. In view of the submission made by the counsel for the parties, let the matter appear. I am fixing 10th February. 10th February 20.
Your lordship, affidavit of 10th February.
12th of February.
10th February. Opposition to file. Your lordship, affidavit in opposition we file.
Lordship, item 40.
Can you
Questioning there is an application for intervention and 26.
May I permit our petition, my lord?
File reply to that.
Permit to mention one. Item number 30 and 31 was fixed today at 3 p.m. only. On 27th, the matter was heard. Learned Senior Counsel Mr. S.N. Mukherjee appeared on behalf of with the petitioners. The matter was tagged along with the original said matters on
16 January 2026.
Oh, 2nd March.
2nd March,
and
2nd March 3 p.m. and 10th March at 3:45 p.m.
Which matter?
Item number 30 and 31.
Incentive matter, my lord, 5 to 18, my lord, similar. 5 to 18.
30 and 31. 30 and
What you are doing? Call the original side matter.
I am not for all these matters. I am only for today's fixed at 3 p.m.
Come on next day when the matter will be taken. You are not able to satisfy this court.
I am not with him, my lord. I am just saying that on 27 the matter was fixed on 5th and 10th.
Call the result.
My lord, item 30 and 31 was together with the original side matters on 27th, my lord. Your lordship.
अर्का अभी एक हियरिंग हुआ था ना, अभी जो टेंडर मैटर हियरिंग हुआ ना, जिसमें ऑर्डर किया उसको ये फाइल में लगा, याद है? 35 जो अभी डेट फिक्स की है 35 है.
Pilot, may I permit mention the matter?
Just a minute. Panorama 35 उसमें लगा देना. Yes. Just a minute. Where is the order? 3rd February. So today?
May I permit to mention on matter amended for inclusion, my lord?
Original side?
Yes.
Why? What is the matter?
My lord,
Give. Yes.
grateful, my lord.
My property, I injunction has been passed. That's not a been passed.
So what you have done? You file application?
File an application or order on to
Have you served?
I have served.
इसको उसी के साथ 3 बजे रख दो. 10 तारीख को ना 3 बजे रख दो.
On 6th, your lordship has fixed.
देखो कितना तारीख. Yes. Call the list.
Lordship, I appear for the defendants.
Yes. Where is the interim order? There's no interim order.
I'm very lost.
Yes.
Your Lordship, my
This is 6th November 2025 order.
Yes, got it.
Lordship, my application under Section 8 of the Arbitration and Conciliation Act is pending. I was praying that a date may be fixed for hearing that application.
GA number?
It will GA number 3. My is GA number
Number 3 of 2024.
and injunction application is
GA number 3 affidavit completed.
Affidavits complete, Your Lordship.
Plus 49.
Track.
Yes.
Track.
Even Miller just ordinary Mukherjee released this matter because Miller had recorded in order that substantially hard. So assigned to the release. Any date and time, Miller,
The matter is listed as to be mentioned on the prayer made by the counsel for the plaintiff for extension of interim order. Counsel for the defendant submitted. The defendant has filed an application under Section 8 of the Arbitration and Conciliation Act, being GACOM 3 of 2024, and the affidavits pleadings have been completed and prayed for fixing a matter, fixing a specific date. Learned counsel for the petitioner submitted. The petitioner also filed an application GA1 for interim order. That may, in that case, also the affidavit is completed. Affidavit complete. In view of the submission, that both the application be fixed for hearing. Give the date, June, July, whatever date.
Whatever date, Miller, renew with the time.
25th March at 3 p.m. Interim order is extended.
Your Lordship, any day before the 23rd of March,
For 23rd.
my senior is in some difficulty from 23rd to 31st of March.
Then come in the first week of April.
First week of
7th April.
I'm obliged.
7th April 2026. Interim order is extended till so 6th April.
I'm great.
Interim order is extended till 9th April. Or until further order, whichever is earlier. Yes, next.
My lord, item number 2, my lord. I am appearing for the state respondent. By the last order, my lord directed the state respondent to file a report by way of an affidavit. I just got the brief. I had come and without going through the writ petition. And today, my lord, very unlikely, I have not been able to come with any report. And even if Lordship gives me an extension, I will not be able to come with any report. I can assure your Lordship.
Why?
No single paragraph is getting out any single meaning. Just for a roaming inquiry, kindly roaming around, paragraph 3. Any paragraph, even paragraph 3, whether Lordship is getting any page 4, that not a single payment has been given and will, as the petitioner enters the ground floor and the chair will ask us to come out and wait for the advantage.
No, kindly come to the page 19.
Yes, my lord. Therefore, my lord, kindly paragraph 7, because for the report, I have to ascertain the
Paragraph 7, kindly come to the page P16. P16.
Page
Details
16.
of the rent. This is a document submitted by the rent controller. Give.
Yes, but my lord, kindly see that what they say, that the prayer apropos should have been a basis with the writ petition. Nothing is there, my lord. Kindly see. For the report, my lord, I have to ascertain that what is in the writ petition. But
My needs are the
my lord knows, my at least
to the government, and the government.
I am not the person to be escaping. My lord, kindly see the prayer A on their part, and kindly see the paragraph 7, what they have said.
Whatever, say in person, I have done maximum, sir.
But that should be understandable to the other side.
Okay, whatever it is, I am clarifying. The rent controller is submit the report how much amount is spending in terms of this challan.
It's around about with one tenant.
But
52,000
not, but
rupees.
anything could not be. And my lord, even if he is coming for a demand of money in a writ petition, and that must be a basis in the writ petition. I am not there to escape, my lord. But kindly see the writ petition. But kindly see the paragraph 4.
No, that's correct. That's correct. But kindly see the document.
Yes.
See the document.
But
Kindly come to the page P16.
16, my lord,
P16.
even the document should have a parity with the government.
Kindly come to the P16. This is your officer's certified that this amount has been deposited.
And then they are not given from 2015, sir. They have jumped the years.
The computer generator 2022-24.
November 24.
Yes. Now then you come to this page 19. Page 19. These are the challans, whether they have withdrawn or not.
No, I'm the landlord. I've not withdrawn, sir. I came.
So
to
that's
know
why
for the
you give the report on this.
Very well. I'm kindly my lord, give some order in
Sir,
something
sir,
in
you
detail,
want
my lord.
Quoted bench of this court
Something
has
in
said
detail so that I
he
can
is-
convince them to give a report. When my lord directs, I have to give, but nothing is coming out of the averment in the petition. Nothing is coming out.
Senior Citizen Act, section 27. we
Even
don't
my lord, they have asked for
any-
10,000. My lord, see the paragraph 4 averment once.
The
So the office should,
petitioner has filed the present writ application.
Then everyone will file a petition like this.
What is the how?
Done. Just have ordered.
Direction upon the rent controller to make the total payment received from the tenants from the year 2015 to 2000.
And we have long.
Let the honorable judge give him order.
By an order dated 13th January 2036, this court directed the respondents to file report by way of an affidavit. Learned counsel appearing for the state submit that as per the averments made in the present application, it is not possible for the respondents to file any report.
To ascertain or file.
To ascertain what the petitioner intend and what report is required to be filed. Full stop. This court find that
2 pages.
the
Yes, madam.
petitioner
Kindly.
has disclosed certain documents, that is the tenant details tenant details which has been furnished by the office of the rent controller, which is disclosed at P16, ma'am, page number 16, 17, 19 and 19, being annexer P2, being annexed P2. Accordingly, the rent correspondent state is directed to go through the documents which the petitioner has relied upon and to submit report. Is there any amount on any rent has been paid by the tenants with respect of the property in question? And if it is paid,
or
the
any amount is due.
And details of the amount be placed before this court by way of before filed by an affidavit within a period of 2 weeks from date.
But-
Sir, make it 1 week, sir, please. Because as a senior.
Unlike other matters coming from the rent controller, my lord.
Rent controller, but
Yes, my lord, because
beside,
I have, my lordship knows I am not in a habit of taking extension, my lord.
So just-
But at least, my lord,
20-minute distance.
unlike all other matters, my lord, in this matter, I
By-
save your
filed by-
3 weeks, my lord,
Sir,
instead.
make it 1 week, sir. I need the money, sir, please.
But
by-
for money, needing
by-
money and
by
making
six-
writ petition.
You can, as a
by
senior-
by 13th February 2026.
My lord, may I request one thing, my lord? Instead of 13, may it be subject to lordship's permission on 20th February.
So make, sir.
I'm leaving it to lordship, my lord,
Please,
because
sir, don't delay, sir.
this
Lordship,
By-
please.
By 20th February 2026.
deeply obliged, my lord.
List the matter on 20th February.
Sir, as the first, as the
Put
top,
that narration, put that.
much honored.
Under the
না পড়লে বলিস না।
I'm taking a short passover, my lord. Mr. Bandopadhyay would address, my lords. After 10 minutes, 10, 4.
That writ petition where the police authorities are in my property, that despite several notices from their end that they would purchase at the market value.
Acha, that one.
You're supposed to address, my lords, on the maintainability point, my lord. Just a short passover, my lord.
Go for the specific performance. Okay, pass on.
My lord.
But could I just cite my judgments which I would want to apply for? Or I leave it to you.
Come on then. Next day. When?
If my lord is adjourning, it can be tomorrow if my lord wants. I do not,
He will come. Okay, pass over. If it is come in time permit, then I will take.
my lord.
Pass over.
We need a lordship's flow.
Huh?
We need a lordship's
My lord, lordships is absolutely burdened with so many things.
we need your lordship's flow.
In the morning, only to bring it
Two court pending.
in the morning, only to bring it to your lordship's notice about a order which was to be uploaded. It took me 45 minutes from the gate to reach till here. So much of mention. My lord.
What can be done? So because today is the last date, then I have to, because correction takes time.
Your Lordship, Your Lordship, on the last occasion, the affidavit of opposition was not submitted, Your Lordship. Your Lordship, in this matter, I am appearing for the state led by Mr. Supratim Dhar. May I request for a short passover? He is on his legs, Your Lordship. He shall.
No matters pass over. What will happen? You persons are missing the opportunity.
I shall proceed.
Okay, you do one thing. Let me conclude.
I
You
shall
take
proceed.
note of.
Yes, I shall proceed.
Just to request your lordship, Devani, in the last occasion, I have almost completed my argument, madam. To request your lordship, Devani. Madam, this is the matter. That the fact where the position by the land acquisition collector long back under the temporary provisions that I handed over to the last occasion. That act.
Yes.
What they call pension.
West Bengal Premises Requisition and Controls Temporary Provision Act.
The temporary provision. Now, under this act, that cannot long more than 25 years. This is the provision. That as it may, flats were they did not after the expiration, they did not hand over the and came up people to lordship. In the year 1993. And I have placed with the lordship
By reason judgment, directed hand over possession. When they did not hand over possession, concept acquisition was moved. When then pending, the concept acquisition was pending. Thereafter, the petition is filed under the advice subsequent information on the sales and cause of action. That is on the same relief was granted, but against that they prepared an application. You can observe that the sales and cause of action is not mentioned. So, and since the concept is pending, that ended there. But the fact remains that the order passed to stands. But and the concept application was pending. The concept application was pending for 2014 and handover person after the order. Again, order passed by your
अनुदर एसी शुरू नहीं हुआ क्या अभी तक?
The order is dated 14 July 2023.
Yes.
Submits that originally there was an order directing the responding authority to hand over vacate and also the responding details number six. Subsequently, another was filed.
आगे पाठाई फॉर्म देवा ऑर्डर
order directing subsequent order was challenged. In the appeal record against them, allow the appeal. Now, basically, review of concept application on your order for execution. Subsequently, the petitioner to vacate the premises, which was not implemented by the respondent. Then a council that in accordance with code has been occupation of the property
আজকে হঠাৎ মামলা চলছে
and they have contributed to the by filing the officer. Right, why not? Under because so that the other submitted that nothing order takes of of the respondents to substantiate there are several documents then the county that the case is life giving more I am having this value of the report that for there cannot be any doubt that this is a code under section 36 of the same provide that the provisions of relating to the health so far as applicable will be applied to order. All in such which could be indicated also has power to order part of the hence the proposition looked by the United Constitution cannot be denied. However, that is so, the previous order, the provisions of order 21 of the Code of Civil Procedure, which pertains to execution of the decree, shall also apply in case of an order. In this respect, we can also take from section 141 of the Code of Civil Procedure. If such aspects of matter in view, the provisions of order also applicable to the present case. Hence, since the respondent has raised a claim regarding the and an independent right, title and interest, the property, which is not judgmentated. A right has been given some advances in order to obtain the responsibility also accordingly the responsibility of epidemics which is this was the finding of now when we come to the epidemic opposition. For their claim with regard to the effective right, I anticipate I will take the that question.
আমি সময় চাইছি আমি রেডি নই
Who is appearing for the 5? Only respondent number 4. 3 and 4. Three and 4.
And so far the file is concerned by the present that was allotted by the joint commissioner to but
That cancelled.
that has been
Recall.
and the document is filed only to the cost page where only the application on behalf of the respondent for himself. In paragraph 1 that I am the joint commission for himself the respondent and after I am and I am competent to find all papers and documents. I also on behalf of myself, not on behalf of the others. They have not been come forward and file their opposition, supporting their right. Now your lordship trying to speak. This case of paragraph 26.
Yes.
Further stated that the commission of English tenant over the premises number 67 and occupying the recommissions are debarred under the law waiving the responsibility of law. It is further stated that the order light of facts by before the court. We mentioned that the facts all these facts and all and it by holding same as not mentioned. Now your lordship continue on paragraph 31. What the matters of the court, all evidence and over that question, your lordship kindly 6 lines from the top, it is further stated that the commission and occupy the same same PI commission is clearly denied the order of the was landed in the collector and also get no nexus in present case. So not admitting, but assuming the said previously the opposite law, then the said order of the cost court earlier by their conduct have accepted as a lawful credit for the property invested. Furthermore, it is stated that once the insurers have accepted as lawful credit for the property, then the respondent property without constituting court of law. They have reached all the paragraphs.
In the 1993, who are the respondents? 1993 Police Commissioner. And that was not challenged.
That was challenged by a dismissed. I placed one of the fact.
Yes.
Not only dismissed, but the document comes to page 84. Affidavit officer, page 84.
Now the police is enjoying the property. What? Quarter?
Water.
Water.
Page 84 said, after the order passed in 1993, someone came like that he is the tenant. On Java police of the where is that order? Page 84, my lord, of the affidavit in opposition order. Page 84. This is an application filed by one also stated paying for an order of recalling of the order to be passed by the court in the matter of the 03 of 1999. This is recalling of the order passed by which go direct.
Vacate the premise.
That order was recalled when independent right by this. It is submitted by the learned advocate of the secretary. The occupant would have five measuring about certain size. Admitted by the learned advocate petitioner that auto secretary has been allocated to occupy the land by commissioner of police. Further submitted that the state allowed by order of 93 party to the application. It is also submitted by the land advocate for petitioner that by order of and as such we said order recall. That is by recalling in the learning advocate for the first land collector of the support petition. However, he admits that his client, the first land collector, was a party submitted by Mr. Raj, an advocate for Das and brothers, that the finding State of Western Court, first land acquisition collector, deputy secretary land and department, and after hearing of the case, a decision was allowed. And all these respondents are the responses. Thereafter, respondent submitted by Mr. Raj that the order passed by the court has marked order of the appeal court. Application. I have carefully submission that the petitioner was not a different party of the was allowed contact against that is the and the petitioner of police. The appeal is responsible. There is no order as to court. Since the fight is not this type of right, but that
Yes.
Now, my lord, got it, fine, fine. If it
পরের দিন কমপ্লিট করেন না, আজকে তো আমি রেডি নই, তো শুধু অপোজিশন দেওয়ার ছিল। মানে all I am beseeching, today, I was under wrong impression that today we would be filing the affidavit in opposition and the matter would be fixed for hearing some.
And
for
last
some.
night also the hearing was conducted. Yes.
So, I was requesting my learned friend that if we could do on the next date, so that I can bring all the judgments which I would like to rely.
Yes.
no use of piecemeal argument, my lord.
That is the problem.
Even when a replacement of a lot's,
No, so
Fix a date.
your
My lord,
colleagues said that you will come and argue. That's why I have taken the matter for argument.
সেগুলো হচ্ছে তাই। Probably, last occasion, our affidavit was not on
on the
board.
record.
So today it was supposed to
No, it is
be filed.
there.
Now today it's
It is there.
on board.
file a opposition filed by them, if the stop or not, that is the file the document.
Yes. Now it original has come. So you also filed the reply, no?
Yes, yes.
Kindly take
How
up
much time you will take?
only couple of weeks.
Couple of days.
Because দাদা টুর্নামেন্ট গুলো চলছে, intra court bar tournament is happening, that's why I'm just paying 1 week extra. Otherwise next week I would have.
कुछ है क्या डेट?
টুর্নামেন্ট গুলো চলছে সেই জন্য। তাহলে
3:45 minutes, आधा घंटा, 45 minutes. दो डेट 12th April. Yes. 12th February and 17th February, 3:45 I am fixing. 12th and 17th. Two date I am fixing. 3:45.
একটু বসো এটা নিয়ে।
But let us see. The Learned Counsel for the petitioner has argued the matter at length, but the hearing could not be completed. According case is adjourned. Let the matter appear on 12th of February and 17th, na?
Yes.
17th February 2025 at 3:45 p.m. as a specially fixed matter.
I'm deeply obliged.
Yes. Yes. Item 5.
Lordship, item 5, Your Lordship, I appear for the respondent number 1. I have just been engaged in the matter this morning, Your Lordship. So I wish to file my wakalatnama. My advocate on record, he's ill today, Your Lordship. So he's not been able to do it today. Kindly give me a short date. The respondent number 1, Your Lordship.
Authorized officer. What is the
Yes,
matter?
Your Lordship.
Okay, let the file wakalatnama.
Yes, Your Lordship. Short date may be given, kindly.
What you have prayed? What you have prayed for? I don't know. Learned Counsel for the respondents prays for time to file wakalatnama. Let wakalatnama be filed within a week from date. List the matter. You will not file affidavit.
Lordship, we will.
Okay. Let the matter appear on 9th February. 9th February.
I'm deeply obliged, Your Lordship. I'm grateful.
And 6th February. 6th.
Lordship, 6th, I have some difficulty, Your Lordship. Can it be on 12th, Your Lordship? 12th is a Thursday, Your Lordship.
This will remain as in the list.
Lordship, 6th, I have some difficulty, Your Lordship.
10th. 10th.
Lordship, 10th also. Can it be 12th or any day after 12th, Your Lordship?
What you have prayed for? Willful defaulter. Yes.
Lordship, 12th or any day
What
after the
happens
12th.
if
Your
it will declare? Since when? Since when is it under liquidation? When you have been declared a willful defaulter? July? Then, okay, for the 1 week, nothing will happen. 12th.
I'm so grateful. I'm deeply obliged, Your Lordship.
12th. Next.
My application will the petition that was allotted just will have to refresh will have a tender will have for the purpose of will have why basically advertisement for which revenue is generated at HON'BLE and also for philanthropic services like providing of wheelchair providing of wheelchair free Wi-Fi to sell in the train otherwise other than the food articles. Lordship will remember the tender section 9 was filed challenging a demand notice. Now demand notice cannot be stayed. But any event there was a direction to deposit which I have not. I deposited only 1 crore. Now the termination has been they have issued a termination notice. There are 2 challenges. One a reasoned order passed by the railway authorities on the reduction of license fees which I had prayed for. Now the order is itself erroneous because he has construed 2 clauses wrongly, saying the obligation.
Yes, 15 days notice.
15 days.
15 days
With regard to that notice, my lord.
Whether
Lord,
there's a
so
notice.
far, to be very candid, Lord, so far the so-called notice is to be the question with regard to that was not issued. But my lord, that was not given. So-called notice was not specified. The word so-called was not mentioned, my lord. But except that, my lord, may I place, my lord, the first notice, demand notice was given on, my lord, in the month of January, my lord. Lord, may I please?
Those are all there.
My lord, this is the first demand notice that was they were asked to pay, my lord, on
My demand I am not on demand at all.
My lord, I am
termination.
why I'm placing this answer.
I am on termination.
My
I
lord.
could be given that 1 month's notice for termination and a showcause hearing.
My lord, after that, subsequent to that, my lord, on 23rd, again a demand notice was issued. My lord, thereafter, on 3/9, my lord, 3rd of September, a letter was demand notice was where, my lord, they were said that your 3rd 9, my lord, got this second page, my lord. 3rd 9 guy copy though. 3rd 9, 3/9/2025, my lord. My lord will come to the
102.
It's 102, my lord.
Look, I have no dispute. I am
No,
not
no.
disputing.
My lord,
at
I'm
all.
not.
I'm not.
Let me please.
I'm not.
My lord, in that letter, they were said that your this. The third, it was said that your this contract will be terminated. My lord will come to the second page. My lord, it is requested to deposit the outstanding within 7 days. My lord, and then my lord shall be constrained to take action under para 2.25. That is with regard to my lord liquidation. My lord, and then the next line, termination of contract with immediate effect. My lord. So my lord, so far with there it is concerned that 17/9, my lord. This letter, they were said that your contract will be terminated. It is not that they were not said that your contract will be terminated. That was on 3/9. My lord, they challenged that order, my lord. This termination. My lord,
This termination was, my lord, not part of the section 9. My lord,
But-
it came, my lord, during when the section 9 was filed.
My lord.
The honorable judge, my lord, stayed it and my lord said, my lord, you
my lord,
deposit the money.
this was
This was stayed, my lord. During the hearing of that, this was 102, my lord. This 102, my lord.
We are aggrieved, my lord. What, my lord? Why, my lord? Two things. My learned friend will
Now,
correct
my lord-
me if I am wrong. I am aggrieved by this one.
I know, my lord. Let me complete.
Very well. You
My lord, I am very candid on this point that with regard to that 15 days and 30 days notice, my lord, that was not there. My lord. That is not there. To be very honest to your lordship, my lord. But save and accept the lord. Every time when the railways have made an attempt to serve them a notice, they have approached before this court and they have obtained an order of stay, my lord. That is the conduct, my lord. Their conduct with regard to the termination, my lord, or taking steps by the railways, my lord.
Yes.
That's why, my lord, I have placed these letters before your lordship, my lord. That the first was given on in the month of April, my lord. They were asked to pay the money. And last letter was 3rd, my lord, on 3rd of September, my lord. They were said that your this contract will be terminated, my lord.
Correct.
Now they 102, my lord.
102, my lord. If your lordship takes, my lord, that document is there, my lord.
Now, that is there. That is there.
That
I'm
is
not
the last
disputing. That was the last demand, my lord. That is annexed to the petition.
That's
that is
why
102.
now you come to the order of the court.
My lord.
Page 137.
Now, my lord, 137 speaks that, my lord, with regard to 136, that it was informed that during pendency of this application, notice was issued on, sir. My lord, subsequently on 17th of September, after this letter, 13th, 3rd 9, 102, my lord.
102.
After this, my lord, they issued a notice on 17th September, terminating the contract, my lord.
102.
That is
102.
102 is before the order of this court.
Before this order.
Before the order.
Before the
That's why I kindly come to 137. The order of passed by the court. Under such circumstances, taking a holistic view in the entire situation, this court says
Operation
displays
date
the
is-
operation of the 17th September. 17th September for a period of 3 months, the petition shall invoke the arbitration within the aforesaid period. The order of termination shall remain stayed unconditionally till 10th October. Within such time, the petition shall secure, so he has not complied with. No problem. By this process, the entire claim will be secured. The demand of service. In case non-compliance of this order shall stand automatically vacated without any further notice. Correct.
So if this is vacated, my lord, if this order is vacated due to the non-compliance on the part of the petitioners, my lord, in that event, this termination stands.
Correct. Correct.
This termination stands, my lord. Now, subsequently, in continuation to this letter, this 17.9, this last, the order challenge, this termination is challenged.
In accordance with law, they have to take steps. Accordance with law is, my lord, clause 4.6, which I showed you, lordship. That is in accordance with law.
That
between the parties. I get a show cause here because, my lord, the thing is I have put in
Non-compliance of this order shall stand automatically vacated without any further reference to this court, and railway authorities shall proceed in accordance with
With
law.
law.
the clause.
What is the law?
They have to give a show. My lord, is correctly what is falling from your lordship, I go by. But so far, my lord, if this letter 2910, my lord,
2910.
that is the termination.
That's page 100.
That is challenged. 151, my lord. That is challenged.
Clauses have been stated.
Yes, 100.
Railway can be terminated for breach of policy of the railway or extraneous like COVID. I cannot.
My lord, this speaks of the earlier order itself. This is not a fresh termination, my lord. This letter was issued that communicating them that since you have not complied, my lord, that's why the earlier termination, that is on 3.9, that stands, my lord.
He has to, my lord, give me a notice. Otherwise, High Court would have said so, my lord, it's the stands terminated. In accordance with law, must be the two clauses which
My lord,
I showed.
my lord will come to page 152, my lord, in compliance. My lord has got
Compliance
it.
of the Honorable High Court order, so and so,
My
so and
lord.
so. Consequently, security furnished
So
by the standard.
this is not a fresh termination which we are giving to them. Fresh notice, my lord, with
That's
regard to
law. You are telling that in compliance of the order.
My lord.
In compliance of the order, then in case of non-compliance, automatically vacated, no problem, without any further reference to this court, and railway authorities shall proceed in accordance with law. So whether the order in accordance with law, that on the basis of the order of the High Court, you can directly pass, or you can bypass the 4.6 or 4.5.
4.5, 4.6, they have
4.5, 4.5 has to be.
He's very fairly has said so.
Has to. That has to be. So further, one more thing is there, my lord. My lord, so far, I was just showing the conduct on the part of the petitioners. Because the first notice was issued, my lord, they came to court, my lord. They said that in anticipation, my contract will be terminated. So they preferred.
But Mr. Ghosh, your client is also not paying. What
My lord, this is, they so far with regard to the arbitration proceedings, my lord, my lord, so far with regard to the arbitration proceedings which they have come, the railway has given twice the server notice upon them. They are keeping silent with regard to that. The total due was around 9 crores, my lord. That
69,000.
My
Miller, there, Miller, I say one thing.
69 lakh 90,000.
Miller, that is a demand. Miller, demand can't be stayed. I said on the first day, Miller, that is minimum, I know, Miller, that you can't stay a money demand. Now, Miller, there is an order passed by that is culminating from a writ petition. So, Miller, challenge is the order and challenge is the termination. Lordship has seen, Miller, this termination. Why? Because I have put in 34 crores as a, Miller, condition for getting the tender. Not 1 rupee, 34 crores is gone, and he has not given me the recs. Now, Miller, kindly look at the order pursuant to passed by Miller in the Article 226. This order was passed. Kindly have a look at page number. Page number 95. The order passed by the railway. Oh, jeez. Straight away come to finding, Miller. This has to be, Miller, some, because this is pursuant to 226, Miller, order. Kindly have a look at it. Miller, finding starts or rest are all submission. Lordship can take it from me, Miller. Miller, normally try to avoid saying anything which is contrary to record. Page 96, Lordship, kindly have a look at it. Page 95 is the finding. This is pursuant to an order passed in Article 226. Now kindly have a look at 96. First, how perverse it can be. 96. Railway has a, Miller, if the rakes are not given, that is a matter now to be decided in arbitration. Miller, I have a right for adjustment. Kindly have a licensee. Kindly have a now look at 96. Come to 96. Yes. The licensee did not comply with the requirement to submit consolidated plans within 60 days as per clause 3.1, 3.3.1, 3.3.4, 3.3.5. Now have a look at page 46. Kindly have a look at this. Is perverse. Who has to give the plan? Lordship will read it. The senior DCM, senior DME of the respective division will prepare a schedule for display of advertisement during the lie over period of the rate carshed where the display work is to be executed. Licensee to adhere to the schedule prepared by the division. However, division should ensure that the plan is in such a manner that the display work can be completed by the licensee within 60 days from receipt of the work order. Now, how am I to prepare the schedule? I am a licensee. It's what the DCM has to do. Kindly second perversity. Clause number, Millard, 5. Lord Millard, kindly take Millard. Kindly Millard takes Millard. Clause number, Millard, 5. For adjustment of license fee against delay on the part of the railway, there are only 2 cases beyond one reason for adjustment, and these are not admissible in terms of provisions 3.2.4b and 4.3.5. Now kindly take Millard 4.3.5 at page 53. Or Millard kindly takes first Millard 3.2.4b Millard, which is at page Millard 46. Kindly have a look at Millard, page 46. This Millard is a wrong order on the face of it, Millard. Page number.
What your authority says.
Page 46.
What your authority says.
That is the what we were to submit, Millard, with regard to that so-called 30 days should have been, ought to have been, which is falling from.
If this order will go, then your total forfeiture also.
Order has to go.
Then total forfeiture will also go.
Because 34 crores
What will happen?
Them. I have
with regard to this, I need to take Millard.
Because see, In compliance, so and so, the expiry of extended period. Last, in view of the non-compliance of the honorable court order, the so and so, the security deposit furnished by you stand forfeited. Further inquiry proceedings shall be initiated for realize.
Kindly, Millard, have a look at Millard how they. Kindly have a look at Millard page 54 once. They say there is no provision on the face of it. Kindly have a look at page 54. The railway. Millard, kindly have a look at Millard page 54. They can terminate only Millard without notice.
Correct.
4.6 Millard C in case of extingency. 54, sir. And 3.5, which is page 53, Millard, specifically states, Millard.
Okay. Anything further?
No, my lord, only one thing more, my lord, that with regard to this contract, my lord, they have given floated a new tender and that has been awarded, my lord.
Very well, I have a separate challenge, separate cause of action.
Which one?
For this present contract, which they are, that has already been awarded, my lord. That I want to bring to the knowledge of this honorable.
I have
court.
a separate cause of action. I'll come back to your lordship, Millard, if there is no proper advertisement. This is nothing to do. I have to go to arbitration and take back my 34 crores.
That's all.
Also set aside the order at 53 because Millard, order at 95 because Millard, it obligation of the railways.
My lord,
Something like
if they are agreed by this, they need to challenge this order, my lord.
They have challenged it in writ petition here only.
এখানে তোমার কটা দুটো ইয়ে আছে
Yes, of course, sir.
My lord.
বলি না স্যার ওরকম
আরে তোমাকে কেন বলবো?
কখনো করি না।
Hearing concluded, CAB.
My lord.
Time is a really said so time.
No.
I'm saying
yes.
My lord, they have not given. Be
That's
very
my,
honest.
heard on an earlier occasion. It was also specially picked one of the days, but they took time. This was with regard to challenge for registration certificate under the West Bengal Apartment Ownership Act. That point is, yes, Mullah, point is very short. The last occasion, Mullah, they took time, so Mullah, matter could not be heard. But I was humbly praying, Mullah, if possible, Mullah, any day, Mullah, any day, it's a short matter, it's covered, Mullah, by judgments, Mullah, passed, Mullah, by this honorable court, Mullah, on previous occasion. Because Mullah, the hearing has to be in terms of the act itself. I know, Mullah, and that's why, Mullah, I'm hesitant, but Mullah, it's such a Mullah matter where Mullah, it.
Item 7.
Item
number 7.
Generally, Tuesdays and Thursdays.
Who is for the other side? You are.
I am appearing, my lord, Mr. Banerjee leading me.
Though the matter is listed as item number 7 in the today's list, but due to paucity of time, hearing could not be completed. Let the matter appear on 5th में top में है क्या? On 5th of February 2026 at the top.
I'm great. I'm so grateful. Very grateful.
Time भी कुछ time कुछ
5th February.
ना time की शुरू
Time की शुरू 5th February.
Appellate side matter. What order was passed?
Passed today.
What order? Interim order and new interim order? Ah.
Matter was disposed of.
Huh?
Matter disposed of.
33.
33.
What was the matter? You will file
Senior citizen.
that which has been dismissed, that order.
Yes.
You will get the order. You will get the order in the evening.
Item number 9, my lord.
Ah.
I affirm the affidavit, my lord. Not some delay is there. Not there. Not.
I am not taking, you file it. If I will take, then it will be difficult.